All right. Good morning, everyone, and welcome back. We are back on the record in the evidentiary hearing for the consolidated dockets under docket number 23 CONS 3017 CPEN. We made pretty good progress yesterday. We are in the middle of staff witnesses. I believe we just finished Mr. Sims. So unless there are any preliminary matters that the parties want to raise, I would propose we just continue through staff's witnesses. And Mr. Kimbrell, you may call your next witness.
Thank you. Staff calls Todd Bryant.
Good morning.
All right. Good morning, Mr. Bryant. I'm going to swear you in. If you'd please raise your right hand. Do you swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. Mr. Kimbrell, you may
Thank you.
proceed.
Thank you. Mr. Bryant, please state your full name for the record.
It's Todd Bryant,
By whom are you employed?
the Kansas Corporation Commission.
What is your work address?
It is 266 North Main Street, Suite 201, 67203. Sorry, 202.
What is your work title?
As the UIC and production supervisor.
Are you a member of the technical staff?
Yes.
Are you the same Todd Bryant who caused to be filed in this docket direct testimony consisting of 8 pages and 2 exhibits?
Yes, I am.
Was this testimony created by you or at your direction?
Yes, it was.
Are the exhibits TB1 and TB2 attached to your direct testimony commission records?
Yes.
As the UIC supervisor, are you familiar with commission regulations?
Yes, I am.
As the UIC supervisor, do you regularly apply commission regulations to oil and gas operators in Kansas?
Yes, I do.
Now that you're under oath, do you have any corrections to make to your testimony?
No, I do not.
If I asked you today the same questions contained in your testimony, would your answers be the same?
Yes, they would.
Do you swear the answers contained in your pre-filed direct testimony were and are true to the best of your knowledge?
Yes, they are.
Thank you. At this time, I move for the admission of Todd Bryant's pre-filed direct testimony and attached exhibits to the formal record.
All right. Any objection?
Subject to the same objections we previously raised, none further.
All right. Thank you. Mr. Bryant's testimony as described will be admitted into the formal record.
And I tender the witness for cross-examination.
All right. Thank you. And it looks like Mr. Ely, you are crossing this witness.
Yes, Chair French.
The witness is yours then.
Mr. Bryant, my name is Jackson Ely. I represent the operator in this proceeding. I'm going to ask you a few questions about your prior testimony and some other matters, okay?
Sounds good.
All right. Mr. Bryant, you provided testimony about the allegations in docket 233135. Is that correct?
Yes.
Okay. And those allegations are about the Grundy B5 saltwater disposal well. Is that correct?
Yes, it is.
Okay, I'm going to refer to that from here on out as the Grundy well, just to make it a little easier, okay?
Sounds good.
All right. You claim that operator either violated KAR 82-3400 by conducting unauthorized injection, or that operator violated KAR 82-3409 by submitting an inaccurate U3C report for the Grundy well. Is that right?
That is correct.
Okay. Based off what you know, are you absolutely certain that operator conducted unauthorized injection at the Grundy well?
At this point, I would say yes. The operator was given the opportunity to either correct the U3C, stating that he had injected at 100 psi, or to not correct it and accept responsibility for it. I kind of oversee 16,000 of these EOR and SWD wells, so we do have to take the operator at his word for these matters. Sorry.
Okay, Mr. Bryant, I'm going to ask that you only answer the question that I'm asking. Okay.
Okay.
So, is it fair to say that your response to that was you are absolutely certain that operator has conducted unauthorized injection at the Grundy well?
Per what he reported on his U3C, yes.
Are you Is it now your belief that operator did not file an inaccurate U3C? Is that not your testimony anymore?
Operator was given the opportunity to correct it, and he did not. So I would say no.
Okay. Other than the U3C report and operator not doing anything in response to your request about that, what leads you to conclude that operator conducted unauthorized injection at the Grundy well?
His self-reporting of his injection at 100 psi.
So the U3C report, though.
Correct.
I'm asking about something other than the U3C report. Do you have any other evidence that he conducted unauthorized injection other than that report?
Field staff, and their reports would be the only other way that I'd have any other proof
Is there
or any other evidence, excuse me.
Is there a field staff report for this specific instance with the Grundy well?
No, probably not in this matter. No, sorry,
So what statements of field staff are you relying upon?
their reports for. It was for everything else. I do apologize. Sorry.
For different wells, though.
Yeah,
So not the Grundy well we're talking about.
No, the Grundy well would be just the operator's report.
So for the Grundy well that we're talking about right now, the only thing that you have to support your claim for unauthorized injection is the U3C report and the fact that you said that operator didn't do anything in response to that.
The operator did not correct his U3C after we gave him the opportunity to correct his error if he did in fact report that in error.
Okay. I'm going to share my screen here. Mr. Bryant, can you see what I've tried to pull up on my screen? It is the penalty order for 233135. Can you see that?
Yes.
Okay. And this is the penalty order for the Grundy well that we've been talking about, right?
Yes, it is.
Okay. I'm going to scroll down to Exhibit A of that penalty order. Is this the U3C report that we're talking about for the Grundy well?
That one does state 2021. Yes.
Okay. Let's talk about what exactly is wrong with this form.
The fact that the operator has the incorrect authorized injection pressure listed at 600 psi, and then he has listed his maximum fluid pressure at 100 psi from the months of February through December.
Okay, so we have two categories of items, right? We have under section 2 of the form, we have the maximum authorized pressure being listed at 600 psi. And then our second issue is if we come down to section 3 of the form, maximum fluid pressure from February to December, it's all listed at 100. That's what you're saying is wrong, right?
Correct.
Okay. And essentially all those numbers should be 0 or gravity, right?
Correct, yeah.
Okay. Switch over here. Actually, I'm not. I'm going to scroll down even further. Staying on the penalty order, scrolling down one page from the UC3 report, I see a letter here. This letter was sent to staff or from staff to operator. Is this the letter that you were referencing where you asked operator to correct the report?
Correct.
Okay. What's the subject line there?
Says annual fluid injection, U3C reports, possible reporting errors.
Okay. What's the second sentence of the first paragraph say?
Staff has identified some data on the forms that appears likely to be a reporting error.
Is it fair to say that staff's first reaction to this was that this was just a reporting error?
That would be correct.
Okay. And then you say that you acquired no new information after this, right?
That's correct.
You didn't learn anything new about the well after this letter was sent, did you?
I'm not sure what you mean by that.
Did you learn any new information about the well after this letter was sent to operator?
About the pressure that was reported?
Or the well generally? I mean, specifically the pressure, yeah.
Yeah, the operator did not submit a correction for the possibility of a reporting error.
So operator didn't do something, but that doesn't mean that you learned any new information, does it?
No, it means that that he had admitted, or he had basically conceded to that. I mean that the report was correct.
Did the operator tell you that the report was correct?
No, he did not.
So how do you know what operator was thinking when it comes to the report?
A
Objection.
deadline.
Mr. Bryant wouldn't know what operator was thinking.
Well, he just testified that he did.
No, he testified that operator didn't take action.
He testified that operator acknowledged the report was correct. I want to know how he knows that.
All right. So far, we haven't done more than repeating what's already in Mr. Bryant's pre-filed testimony. Let's move to what the point of this is.
Okay. Mr. Bryant, the initial reaction of staff was that this was a reporting error. Staff didn't learn any new information. It just wasn't responded to by operator. And now you're testifying that you're absolutely certain that it was unauthorized injection. What changed your mind?
The fact that the operator did not correct the form. The
Okay.
form below.
Okay. Have you ever inspected the Grundy well in person?
No, I have not.
Are you aware that Mr. Freden will testify that the Grundy well is not even equipped to take water at pressure?
I was not aware of that.
Are you aware that it takes special equipment to inject at pressure?
I am.
Do you have any evidence that that equipment is present at the Grundy well?
I do not.
So if you have no other evidence that there's unauthorized injection other than this form, your initial reaction was that it was a reporting error. The Grundy well is not even equipped to inject at pressure. Do you still believe that it was an authorized injection?
As I stated before, I'm in charge of 16,000 wells. I have to take the operator at his word. And in the last paragraph of this form, it says after the deadline of August 29th, at that time, if the data on this form indicates that you exceeded the terms of your injection permits, then staff may recommend penalty. It was clearly laid out. He did nothing. This is all we have to go off of.
But does that mean that it was unauthorized injection?
It's a self-reporting form. All we can do is go off of what he has reported.
Do you know that Mr. Freden received this letter?
Yes, I do.
Okay. Well, let me ask you this here. You say that it was a self-reporting form, and in the paragraph that you just mentioned, it says that staff may recommend a penalty. Where does it say that failure to report or respond to this form is an admission of unauthorized injection?
Form doesn't clearly state that.
So how are you drawing that conclusion that that's what operator acknowledged?
That's what operator reported.
Well, he just reported information on the form. He didn't acknowledge that he was unauthorized injection. Correct?
Say that again, please.
He just reported the information on the form. He never reported that he was committing unauthorized injection.
Well, what he reported on the form was an unauthorized injection.
Is it possible that the information on the form was an error?
It is possible.
Okay. Do you have any evidence that the information on the form is not an error and that operator simply forgot to respond to you.
Operator in his testimony said that he somehow got this confused with an MIT reminder.
The operator was confused and didn't respond to you, and that means that it's an authorized injection. Correct?
I'm going to object. That's not what Mr. Bryant just testified to.
Well,
I'm not drawing that conclusion from.
Yeah, I'm at the point where I feel like we've gotten about 2 or 3
Okay.
times asked and answered on the particular question of Mr. Bryan's interpretation of the form and what conclusion he drew from it.
Okay, I'll move on.
I think we see your point.
Mr. Bryant, I'm going to go to your pre-file testimony. You testified to, on page 3 of your pre-file testimony. Can you see that on the screen here?
Yeah, I have it in front of me too.
Okay. You testified to specifically the requirements of KR 82-3400, correct?
Correct.
And you also testified to the requirements of KR 82-3409, correct?
Correct.
Okay. I'm gonna switch gears here a little bit. I'm trying to show a web page with the language of KR 82-3409. Can you see that?
Yes, I can.
And this is the regulation that you testified to, correct?
Correct.
Okay.
Mr. Ely, do you have the ability to zoom that in at all? I think most of us could probably find the regulation, but it's very difficult to read on the Zoom screen.
Let me.
If you press Control and
The
how
plus
do-
sign.
there you go.
Is that legible for everyone?
That's much better.
Okay. Mr. Bryant, let's kind of go in reverse order on this one here, okay? I think that might be a little bit easier. There are 3 subsections to this regulation that you testified to, correct? A, B, and C.
Correct.
Okay.
Yeah.
Let's start with C. Report has to be submitted by March 1st of a year. Is that right?
Correct.
Okay. When did operators submit the U3C for the Grundy well?
I don't have that information in front of me right now.
Okay. I'm just going to go ahead and state it because it is in your pre-file testimony. You testified that he submitted it on February 22nd, 2022. Is that correct?
Sounds correct.
Okay. Well, that's in your testimony. Okay. So the timing is not the issue here, is it?
Oh, sorry. No.
Okay. So we don't have an issue with subsection C of this regulation, do we?
No.
Okay. And you also testified to what subsection B requires. I'm looking at this regulation here, and correct me if I'm saying something that's not to your understanding of it. Each operator of an injection well shall submit a report to the Conservation Division on a form required by the Commission showing for the previous calendar year the following information. 1, the monthly average wellhead pressure. 2, the maximum wellhead pressure. 3, the amount and kind of fluid injected into each well. And 4, any other performance information that may be required by the Conservation Division. Is that correct?
That is correct.
Okay. I'm switching back over to the U3C form that we've been talking about. Can you see that?
Yes.
Okay. Can you point out to me a number that purports to be the maximum average wellhead pressure on this form?
You state that again, sorry.
Can you point out on this form a number that appears to be the maximum average wellhead pressure?
The 100 PSI?
This?
Is that what you're asking? What he
I'm
reported?
asking for the maximum authorized injection pressure, essentially.
Well, he reported 600 on there.
But there is a number on that form, right?
Yes.
Okay. Can you point out the monthly average or the monthly average maximum pressure? Are there numbers on that form for each month?
There are.
Okay. You just have an issue with the accuracy of the numbers, is that correct?
That's fair.
Okay. Can you point out where it states the amount of fluid that was injected?
The 50 barrel. Oh, that was injected.
Yeah, the amount of fluid injected.
It's the first column to the left of maximum pressure. Yes.
Where it says total fluid injected, BBL, and then it has a number for each month. Is that correct?
Correct.
Okay. Can you point out the kind of fluid that was injected into the well?
At the top where it says produced water and untreated brine.
Okay. Essentially, all the information that was requested, there is at least a number that purports to answer that question. Is that right?
That's correct.
Well, our concern is just with the accuracy, right?
Correct.
Okay. I'm going to switch back to the regulation. Can you see that?
Yes, I can.
Okay. Where in subsection B does it state that the information provided has to be accurate? Or is that in subsection A?
That'd be subsection A.
So he gave all the information that was requested in subsection B, didn't he?
Yes.
So he couldn't have violated subsection B either, could he?
Correct.
Okay. Let's talk about subsection A. I'm going to read this. If this is not consistent with your understanding of the regulation, please let me know. Each operator of an injection well shall perform the following. 1, keep current accurate records of the amount and kind of fluid injected into the injection well. And 2, preserve the records required in paragraph A1 for above 5 years. Is that right?
Correct.
Okay. What information does subsection A require be kept current and accurate?
The records of his injection activities.
Does it say that?
I'm sorry.
Does the regulation say that?
Oh, it says to keep accurate records of the fluid injected.
What specifically about the fluid injected?
Keep current accurate records of the amount and kinds of fluid injected into the injection well.
Does subsection A require an operator to keep accurate records of monthly average pressure or maximum pressure? Is that in subsection A?
The word monthly is not, but it is to keep current accurate records, which encompasses all records.
Does it say that, or does it say current and accurate records of the amount and kind of fluid injected into the injection well?
It says keep current accurate records of the amount and kind of fluid injected into the injection well. Yes.
An operator kept current and accurate records of the amount of the fluid and the kind of the fluid, correct?
Objection. How would Mr. Bryant know that?
I'll sustain that one.
Are you alleging, Mr. Bryant, that operator kept records other than the pressure inaccurate?
Can you say that again?
Are you claiming that operator kept records other than the pressure inaccurate?
I can't speak on what he kept.
Okay. But subsection A never says that he has to keep accurate records of the pressure, does it?
I think this is asked and answered. I object.
Okay. I'll based off the way subsection A is written, can you identify what part of subsection A operator violated?
I mean, no.
Okay. So you just testify that operator didn't violate subsection C, didn't violate subsection B, and it didn't violate subsection A, did you?
I object. I don't think that was Mr. Bryant's testimony.
I think we can go back and he'll say that for every single one, and the record will reflect itself.
All right, I think we get the point. There appears to be a legal argument that you all can take up at briefing of whether it's a violation of this regulation to file inaccurate or false information.
I'll move on. Mr. Bryant, are you aware that Mr. Freden will testify that the U3C was approved almost immediately after he filed it on February 22nd, 2022?
Yes.
Share my screen again here. I'm trying to show the letter that was sent. Can you see that?
Yes.
What is the date of that letter?
August 15th, 2022.
Almost 6 months after the form was approved, wasn't it?
Correct.
Mr. Bryant, are you aware that Mr. Dooling has changed forms that operator has submitted?
Objection. That's argumentative.
I don't understand how that's argumentative. I'm just asking if he's aware of a fact that we established in prior testimony.
You did not establish that he changed something, a form that was improperly changed.
Could you, Mr. Ely, proffer for me what the relevance of this is to Mr. Bryant's testimony?
The direction I'm trying to go is Mr. Dooling's testimony. We presented evidence that he was changing forms that operators submitted. It appears to me that this was a reporting error in the form. I would like to know why Mr. Bryant did not exercise the same discretion that Mr. Dooling does of changing forms.
Okay, I think you can ask the question as to Mr. Bryant's practices. I'm not sure I understand the relevance to Mr. Dooling's practices. I frankly don't remember the issue of him changing the form, but that's probably my failed recollection. But go ahead. If you want to ask Mr. Bryant about his practice of changing information, go ahead.
Mr. Bryant, have you ever changed information on forms submitted?
In general?
Ever. Have you ever changed information on a form submitted to you from an operator?
I do not change operator submitted forms, no.
Okay. Do you think that is a proper procedure to do?
To change operators' numbers? In the central office, absolutely not. We have 16,000 wells. If we were changing forms, like there's no way to keep track of who's doing what and for what reason.
Okay. Mr. Bryant, in your pre-filed testimony, you testified to the potential to pollute usable waters. Do you have any evidence that there was pollution of usable waters as a result of the operator's actions with the Grundy well?
Can you point me to that in my testimony?
Yes. What I'm looking at here is page 6 of your pre-filed testimony, specifically the question on line 12, and then your response on lines 13 through 18. Did you testify to the impact of pollution of usable waters?
Yes, I did.
Do you have any evidence that there was pollution of usable waters arising from operators' actions at the Grundy well?
I do not either way.
Scroll down a little bit. On page 7 of your testimony, you testified in response to a question about the Gale-Mullen C43, the Gale-Mullen E43, the Gale-Mullen I43, the Mullen I22A, and the Underwood 6R90. Is that correct?
Correct.
Have you ever been to those wells?
No, I am not.
Further down, you testified to the DR Nelson N6, the DR Nelson R2, the DR Nelson R10, the DR Nelson T4, the John James JL1, the Mullen OW1, the Ralph Samp SAM 26, and the Sargent SAR 15. You recall that testimony?
Correct. Yes.
Have you ever been to any of those wells?
No, I have not.
I'm going to scroll down to page 8 of your testimony. On the last sentence of your testimony on lines 6 through 7 there, you state operator was clearly conducting unauthorized injections at the 5 wells at issue in this docket. Is your belief on that based entirely upon what other people have told you?
Yes, it is based on field staff reports.
So you have no firsthand knowledge of unauthorized injection, do you?
Correct.
And let's scroll up. The wells, for the sake of reference, that are contained in the question in lines 8 through 11 on page 7 of your pre-filed testimony, beginning with the DR Nelson N6. Are you aware that those wells only became an issue in January of 2023?
I don't.
You don't know when those wells became an issue, do you?
I don't. Correct.
Okay. Of all the wells that we mentioned, do you have any evidence of pollution of usable waters at any of these wells?
We don't have any evidence that they're not polluting waters.
Okay. I have no further questions for Mr. Bryant.
All right. I think we are ready to turn to commissioner questions at this time, and I will begin again with Commissioner Keene. If you have questions for Mr. Bryant.
Yes, thank you, Chair French. I do. Good morning, Mr. Bryant.
Morning, Mr. Keene.
I want to address some of these U3C issues that were the subject of your cross by Mr. Ely. But before we do that, the well really that he was focused on, I think, if I'm correct, is called the Grundy B number 5 SWD well, is it not?
Correct.
That's a API number 15-073-22198-00-00. Have I identified the correct well?
I believe so. I don't have that in front of me at the moment.
I've checked it with the against the well that was the subject of penalty order in the docket number 23 CONS 3135 CPEN, and it's the identical well. We do have the benefit, as a result of the field investigations that were conducted in January, of a photograph of this well. So, Mr. Myers, if you would please, if you would go to do a screen share for me. It's from Exhibit RD1. Specifically, it is page 257.
Oh, one moment.
Thank you.
Taking a bit longer to load than I anticipated.
Okay.
It's getting there. It's just taking its time.
Okay.
All right, almost there. We have page 257, Exhibit RD1.
That's the well. That's the photograph. Can you see that, Mr. Bryant?
Yes, I can.
The date of this photograph is January 17th, 2023. John, you're going to have to keep that stationary. Okay, there. All right. As I say, the APIs are spot on match. So this is the well.
Okay.
This is the well as it appeared on January 17th, 2023. Keep in mind, the U3C that is in question here was filed in 2022, reporting 2021 injection. Is that correct, Mr. Bryant? Am I correct in that?
That is correct.
So the report that you believe evidences certain conclusions you've reached was filed in early 2022. It's interesting, go down to the very bottom of this here, and you can, if we could maybe enlarge that slightly, John, so we can read what the additional information here is on this particular well. That's good. Let me read that into the record. It says, additional information, Grundy B number 5 SWD is an unauthorized disposal well, evidently under previous permit number D-24701, constructed with 5.5-inch casing and 2.5-inch tubing that is inactive. It goes on to say that this well failed its mechanical integrity test on September 18, 2022, which was roughly 4 months before this photograph was taken. It goes on to say the well has no surface control, no TA application had been filed. You can see pretty much, if you take the photograph together with the narrative. My question to you, Mr. Bryant, given your position within the Corporation Commission, is, in your opinion, does this well present a pollution risk or a risk to the freshwater or groundwater resources?
Yes, it does.
Why?
It had with no surface control and a failed MIT. We don't know exactly what or where and how the MIT failed. And with no surface control, I mean, water can be going up and out. Methane could be coming out. Water could be leaking at any point there. into the fresh and usable water.
Could those
So,
pollution risks be present? I'm sorry, I didn't mean to interrupt you, Todd.
No, you're fine. I'm done.
Could those pollution risks be present whether or not water was being injected presently into the well?
Yes.
And why is that?
With no control over where the fluids could be possibly moving. I mean, it could be going anywhere, and that's enough of a risk.
Okay. And as it indicates here, it has 5.5 casing with 2.5 tubing, presumably on a packer. Okay. Well, I just wanted to give everyone the benefit of seeing what the well looked like as of January 17th, 2023. Let's go on to the more to the point, really, of the issue at hand here with respect to basically we're looking at docket number 23-3135. I think as your testimony in response to the cross by Mr. Ely evidenced, if I understood it correctly, these forms are due on March 1st of each year succeeding the year for which the reported injection activities are to be provided to the KCC. Is that right?
That's correct.
Is this report just kind of a nuisance? I mean, how important really is this report? Is this just another bureaucrat form, or how important is this form?
It's very important for them to submit the correct and accurate information, so that way we know exactly what's been going on and how much fluid and at what pressures they've been doing it, so that way we can mitigate risks for pollution.
And without that form, you wouldn't know that information, would you?
Absolutely not.
And I think you evidenced that when operators file these, it's a self-reporting process, is it not?
Correct.
So when the form is, and these forms are submitted on Kohler, are they not?
Yes.
All right. Correct me if I'm wrong, but the procedure within Kohler is such that once you fill out the form on Kohler and you go to the prompts to submit it to the KCC, does it not ask you if you're really certain that you actually want to provide this form, that it's accurate? Isn't there a request to, or a prompt that makes you indicate one way or another that that's the case?
Yes, there is.
Furthermore, before you actually submit it, don't you swear basically that you're you're certifying, let me be more specific, you're certifying under penalty of perjury that the information submitted is truthful and accurate before you push the button to actually provide the form to the commission through Kohler. Is that not correct?
That is correct.
If we could bring up once again and I may have to rely upon your efforts again, Mr. Ely, if we could bring up the form itself that's in issue here, the U3C. Okay, thank you. Could you enlarge that just a bit so we could see it a little better? Yeah, that's fine. That's really pretty good. That would do it. I'm okay. All right. And do you remember some of the questions Mr. Ely was asking you about this form, Mr. Bryant?
Yes.
And specifically, he was asking you about the under well data, which is part Roman numeral 2 of the form there, the maximum authorized pressure of 600 pounds. What problem does that cause you?
The fact that the well was given 0 psi or gravity, 600 psi is far above and beyond what the well is authorized for.
And what does that authorization come from?
Our application process, the review by the geologists, and understanding of how the formation takes water.
Okay, and then basically there's an order. There's a commission order, is there not? That if you pass muster on all of the requirements and the prerequisites, will actually authorize injection, and it says quite specifically what that authorized injection pressure is, does it not?
It does.
And for this well, what is that authorized injection pressure?
0.
All right. We can take the screen share down now. Thank you, Mr. Eden. So we're relying upon the veracity of the operator to provide accurate information on a form that is important for the commission to regulatorily fulfill its responsibility to make sure that the orders of the commission that authorize injection are being complied with, among other things. Isn't that correct?
That is correct.
And so in this case, having noted the discrepancy between the order authorizing injection and this particular U3C report, basically, I'm not to put words in your mouth, but if I'm incorrect in any way, you correct me. Basically, to give the benefit of the doubt to the operator, we went back to the operator to say, basically, you did, we didn't, we did. To say, basically, in so many words, this doesn't comply with, basically, this doesn't comport with what we believe it should be. And if you believe that your report is an error or that the commission is an error, let us know that. Isn't that the essence of what your letter was about?
That's correct.
And I think you've testified to Mr. Ely that you know that Mr. Schleider had received this letter. How do you know that?
Yeah, he had said so in his testimony.
Okay. To me, it's racist ipso loquitur. It's pretty much speaks for itself. I think that is the essence, really, of all of the questions that I have for you, Mr. Bryant. Thank you very much.
Thank you.
Thank you, Commissioner Keene. Commissioner Keither, do you have any questions for Mr. Bryant?
Thank you. Good morning. Good morning, Todd.
Good morning.
I have your testimony in front of you in the KAR being referenced, and I just want to make it very clear in my mind that it is the responsibility of the operator to provide this accurate information to you on a caller form, which has its own responsibility behind it, but it is the responsibility of the operator to provide this accurate information.
That is correct.
And you sent him a letter, which you know he received, saying, this is not accurate, numbers, please fix, never done, correct?
Mostly, I didn't necessarily send the form. My department sent the form.
Okay.
But yes, absolutely.
Okay.
The rest, that's correct.
Okay, well, that is something that really stands out to me, that it's an operator responsibility, and regardless of the other questions, the bottom line to me is it's the operator's responsibility, which he did not fulfill in my mind. Okay, thank you very much. Thank you for your time.
Thank you.
Well, I didn't have a question, except for I just want to clarify that last piece. When you reached out to Mr. Freden with the letter, you weren't telling him his numbers were wrong, correct? You were saying your numbers may be wrong. I want to give you an opportunity to change it if they were wrong. Is that a more accurate statement? That's
correct. Yes.
Okay. I just wanted to make sure you didn't have any information one way or the other that they were wrong. You knew they didn't comply with what was authorized, and so you were giving sort of a second bite at the apple, I guess.
Correct.
Okay. Gotcha. Okay. That's all I have. Any redirect, Mr. Kimbrell?
Just briefly, Todd, are you aware of any instances when it's all right for an operator to submit inaccurate information to the commission?
I'm unaware of any instance. No.
Okay. In your testimony, when you were talking about potential results of unauthorized injection. You were speaking hypothetically, or were you speaking specifically about these wells?
Can you state that again? I'm sorry.
Sure. So in your testimony that Mr. Ely brought up, you were talking about what could potentially happen with injection wells that's unauthorized. Is that correct? Is that my understanding?
Yeah, that is correct.
And
yes.
do you have any knowledge that these results haven't happened with these wells that you testified about?
I do not.
So, okay, you do not. Thank you.
All right.
Yeah. The U3C report that we've been discussing, has Ace Energy updated that U3C report?
Not to my knowledge, no.
Okay, thank you. I have no further questions.
Thank you.
All right, we didn't plow a lot of new ground, but Mr. Ely, I'm going to give you the opportunity for very brief recross if you have any.
I think I only have two small pointed subjects, if I could
Go ahead.
do that. I'm trying to find the RD1 exhibit. It might be easier for Mr. Myers to share his screen if he found that earlier, if possible.
I did. Yes, absolutely. Do you want the same page 257?
That would be fantastic. It would
All
save
right,
a lot of
one
time.
moment. I just closed it, so it's gonna need to reload.
I appreciate that. Thank you, Mr. Myers. Thank you, Mr. Myers. If you could scroll down a touch. Okay. And then if you could scroll back up to where I could see the well and the additional information paragraph, if we can finagle that, that would be. Okay, that's perfect. Mr. Bryant, can you see the image that Mr. Myers has pulled up on the screen here?
Yes, I can.
And this is exhibit RD1, the same page that Commissioner Keene referenced, correct?
Correct.
Okay. What is the date that this inspection was taken?
The date on the form is January 17th, 23.
What is the date referenced in the additional information paragraph of the MIT?
September 18th of 22.
For a reminder, the operator submitted the UC3 form or U3C form at issue in this case that we've been talking about with the Grundy on February 22nd, 2022, correct?
Correct.
And the letter that was sent was on August 15th, 2022, correct?
Correct.
All of those dates predate the information on that page, correct?
Correct.
Mr. Myers, you can take that down now. I'm done with that. Mr. Bryant, was there any allegation of an MIT being a part of docket 23-3135?
Objection.
I do not
That's a
believe so.
totally different-
Oh.
Yeah, we'll let him answer, which I believe he already has.
Yeah.
Yeah.
Next. Are you aware that it's been established previously in this proceeding that operator is responsible for over 400 wells? Are you aware of that?
Yes, I am.
Do you have an estimate on how many U3C forms an operator submits to you each year?
All operators in the state.
No, this operator in particular, Ace Energy.
I'm unaware of how many he submits annually.
Would it be fair to say that if he's responsible for over 400 wells, he probably submits a lot of U3C forms each year?
Yes.
With the volume of forms, would you anticipate typos to occur?
I'm gonna inject this is speculation.
Let me rephrase the question. Mr. Bryant, have you encountered typos in forms before?
Yes, I have.
Okay. I have no further questions.
All right, thank you. I'm going to assume that probably didn't prompt any additional commissioner questions from the redirect and the recross, but I'm looking at my fellow commissioners, not seeing any hands waving. Mr. Kimbrell, I'm assuming no additional redirect. Okay. All right. We have come to the conclusion of Mr. Bryant's testimony. Mr. Bryant, you may virtually step down. We've not
Thank you.
yet been, yeah, thank you. We've not yet been going an hour, so I want to keep moving. Although at some point here, I do want to give everybody a mid-morning break. So Mr. Kimbrell, I'll have you call your next witness, just knowing that at some point during Mr. Russell's testimony, we may give a short mid-morning break. But why don't
Okay.
you go ahead and proceed?
Sure. Staff calls Troy Russell. And there's that delay in YouTube, so it might be a little bit before he actually
No
jumps on.
worries.
And Mr. Myers, if you could change his name to Troy Russell.
All right. Looks like we've got the correct title there. Good morning, Mr. Russell.
Good morning, Chair Friends.
If you would you please raise your right hand? Do you swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Mr. Kimbrell, back to you.
Thank you. Mr. Russell, could you please state your full name for the record?
Troy Russell,
By whom are you employed?
the Kansas Corporation Commission.
What is your work address?
It is 137 West 21st Street, Chanute, Kansas 66720.
And what is your work title?
I am the district supervisor and a professional geologist.
Are you a member of the technical staff?
Yes,
Are you the same Troy Russell who caused to be filed in this docket direct testimony consisting of 7 pages and 2 exhibits, as well as rebuttal testimony consisting of 9 pages and 1 exhibit?
I am.
Was this testimony created by you or at your direction?
Yes,
As District Number 3 Supervisor, are you familiar with the Commission regulations?
yes,
As District Number 3 Supervisor, do you regularly apply Commission regulations to oil and gas operators in your district?
yes,
Now that you are under oath, do you have any corrections to make to your testimony?
no,
All right. If I asked you today the same questions contained in your testimony, would your answers be the same?
yes,
And do you swear the answers contained in your pre-filed direct and rebuttal testimonies were and are true to the best of your knowledge?
yes.
At this time, I move for the admission of Troy Russell's pre-filed direct and rebuttal testimonies to the formal record.
Any objection?
In addition to the objections already lodged, I do have one specific objection that I believe is probably better served to be addressed before we get into I think it'll be more efficient to address it now, I guess is the best way to say that. Involves a mischaracterization of testimony. I'm going to share my screen real quick so you can see what I'm talking about. But this is in Mr. Russell's rebuttal testimony, and it's not Mr. Russell's testimony that's actually the problem, it's the question asked. Can everybody see that?
I can see it.
Okay. So I'm on
What
page
page?
4 of Troy Russell's pre-filed rebuttal testimony. The question is asked on page 7, line 4 of Mr. Freden's testimony. He states that operator is in compliance with all penalty orders listed on exhibit TR1. That is not what Mr. Freden's testimony was. I think that mischaracterizes his testimony. The question asked to Mr. Freden, and I've now turned to page 7 of Mr. Freden's pre-filed testimony. It says, to be clear, except for penalty orders that are the subject of an open docket or petition for judicial review, has Ace Energy satisfied all obligations under penalty? So there's a qualification there. The answer is yes. Scrolling back up, page 6, line 13 of Mr. Freden's pre-file, or beginning there, he specifically identifies the docket that Mr. Russell says Mr. Freden is not compliant with. I don't think that's fair to say what Mr. Freden stated is true when he directly addressed this particular docket. So I would move to strike lines on page 4 through page 7 of Mr. Russell's testimony as improperly mischaracterizing Mr. Freden's testimony.
Could you just, I think I lost the train there at some point. Are you making the distinction between, in one place, a characterization of compliant with all dockets versus compliance with all dockets subject to the pending items? Or maybe you could restate that in.
Yes, let me walk. I'll just go through it. This is
maybe I'm the only one that didn't follow that. You
okay.
Caught me cold.
That's okay. I was going to do this in testimony. I thought it wasn't fair to Mr. Russell to do that since this isn't his question. This is Mr. Kimbrell's question. Thought we ought to address it here. This question says, in Mr. Freden's testimony, he states operator is in compliance with all penalty orders listed on TR1. That is not what Mr. Freden testified to. Mr. Freden testified that except for penalty orders that are the subject of an open docket, as Ace Energy satisfied all of its obligations under the penalty orders described in TR1. And Mr. Freden earlier, the previous question asked him, specifically identified docket 3124 as that open docket. Mr. Russell, in his testimony, goes on to say that Mr. Freden's statement is not correct and that that same exact docket is one that he's out of compliance with. That's not fair to Mr. Freden. It's the one he specifically identified as being excluded from his testimony. And I don't think that's fair. And I think that testimony should probably be stricken.
Well, before
And I would
rule, Mr. Kimbrell, I want to give you the opportunity to respond.
Yeah, I would object. I believe that it is clear that Mr. Freden is testifying that he's brought all of the wells subject to the penalty orders in that exhibit into compliance. And moreover, Mr. Schlatter has argued during the course of this hearing that operator has in fact brought all of those wells into compliance. That was part of his cross-examination with Ryan Dooling.
Not true at all.
You went through didn't you go through the list of the penalty orders in TR1? And
this is the one that's after the date. I mean, that's the.
But even if there is an issue, then it's clearly harmless. It's obvious what Mr. Russell was talking about and describing.
Imputing his credibility based on something that he already testified to be true. That's not fair to Mr. Freden. It's an improper mischaracterization of his evidence. It can't be admitted into evidence.
So here's where I think I'm going to go. Rather than just striking the testimony, I think maybe your point is well taken that you believe it's your witness's testimony has been mischaracterized. I would suggest that might be a ripe area for cross-examination for you to ask the witness whether his testimony would change based on a different set of facts as your witness sees it. I've got no problem with you going down the road of whether that testimony needs to be tweaked. I think it's fair to ask whether his testimony would change if the question was different. Is that fair, Mr. Schlatter?
It is. I can do that. Thank you.
right.
With that objection lodged and the commission noting prior objections, I'm ready to proceed with Mr. Russell.
Okay. So to be clear, we are overruling all the objections, but I am offering the opportunity to add that nuance or to clarify that testimony on cross-examination, just for the record. So
Thanks.
with that, Mr. Russell's testimony, pre-filed testimony as described, is admitted into the official record, and it appears Mr. Schlatter is going to do the cross-examination. Is that correct?
Yes, Chair French. It's the ball is in my court, if you would.
All right. Mr. Kimbrell, have you tendered your witness for cross?
I tendered a witness for cross-examination.
Thank you very much. Mr. Schlatter, the witness is yours.
Thank you, Chair French. Good morning, Mr. Russell. How are you today?
Good morning.
Were you tracking along what we were just discussing?
I was trying to.
Okay. Would you want to correct your testimony along those lines, or do you want me to ask you these questions?
I would like you to go through them and ask them so that I can look at them in detail.
Sure. Okay. So we're at your pre-filed rebuttal testimony, and I'd just like to move through this quickly. Your pre-filed rebuttal testimony, the question was asked of you, and I don't think this is your fault. I think that's just a bad question, and that's okay. I've asked a lot of bad questions so far. But the question says that on page 7, line 4 of Mr. Freden's testimony, he states that operator is in compliance with all of the penalty orders listed on TR1 in this document. And that's your exhibit TR1, and it has, if I can find it here, and geez, I'm not sharing my screen. I apologize. It's TR3. Oh, TR1's in your pre-filed testimony. Let me open that real quick. Your pre-filed direct testimony, I should say. Okay. And that includes these dockets. Here, you've got a list here. I believe this has been updated with staff exhibit 5, but for the sake of the limited sake of this objection, we would like to just use this particular docket. There is 223124. Going back up to the question asked. Okay, on page 7, line 4, Mr. Freden, he states that operators in compliance with all of the penalty orders on this. You say, and the answer is asked, is this correct? And I want to turn you to that specific question of Mr. Freden's that he answered in his testimony. This is page 7, line 4 of Mr. Freden's testimony. It says, to be clear, except for penalty orders that are the subject of an open docket or petition for judicial review, has ACE Energy satisfied all of its obligations under the penalty order described on TR1. So that's everything except for this category is his question. And he testified just a few lines above on page 6 at line 20 that docket number 3124 is the subject of a petition for judicial review. So he's expressly excluding that from the list of penalty orders that he is compliant with. Do you understand that?
If I understand you correctly, he's excluding whether he's in compliance or not with that docket, which for the judicial review?
Yes, sir. And then in your, go ahead, Troy. I don't
No, go ahead.
Okay, I just want to make sure you understand that that docket 3124 is expressly excluded from this bit of testimony. Turning back to your testimony, beginning on page 4 at line 3, your rebuttal testimony, you specifically identify that docket as one that he is not correctly testifying to. But that's not what he testified to, is it?
Can somebody, if that is under judicial review or an open docket still? Can somebody clarify that for me on the 3124?
3124 is subject to judicial review, Mr. Russell. That's correct.
Okay.
So does that change your answer to this question? At least as to lines 3 through 7.
I think my answer would be that would just add the caveat that operator expressed that if it was under judicial review, he was not referring that he was in compliance with those.
So is that a yes?
Restate one more time and I'll give you, I'll answer succinctly.
Yeah.
I just want to make sure I'm clear on this.
Assuming that docket 31, well, not assuming, docket 3124 is subject to judicial review, understanding that, would your answer to the question change?
I believe the question would change, as I know you've brought that to bear, because he does not say he's in compliance with that 3124 docket.
Okay.
Mr. Schlatter, I think I'm finally tracking, and I think I see what you're getting at. And maybe if I can get an indication from you and Mr. Kimbrell, I think it might be most appropriate if you all would be willing to just stipulate that there is an agreement that for that docket number 22 CONS 3124, everyone agrees operator is not in compliance, and operator did not represent that it was in compliance in its prior testimony. Is that what you were getting at?
Yes, Chair French, and that is well articulated.
Mr. Kimbrell, is that all right with you?
Yes, staff would stipulate to that.
All right, thank you. I'm sorry it took me so long to get there, Mr. Schlatter.
It's okay. I guess it's still kind of early in the morning. Mr. Russell, I apologize, and that doesn't affect your test. I mean, other than for the purpose that we just stipulated to, I wasn't planning on going there with you today, so I apologize. Just I have to make a record as an attorney, and I'm trying to do the best I can. It's nothing personal to you.
Nothing personal taken.
Okay, so now I'm ready to begin with you with some substantive questions. And I'm just going to ask you a few of the questions that I asked Mr. Dooling real quick, and also a question that he told me to ask you. So to the extent you want to blame him for that, that's completely within your discretion. Mr. Russell, do you believe that as the District 3 supervisor, you have a duty to administer and enforce the commission regulations, the same against Ace Energy as every other operator?
I do.
And do you believe you have a duty to administer and enforce the regulations in a fair and judicious manner?
I do.
And is it fair to say that based on your testimony that has now been admitted into the record, you are dissatisfied with operators' compliance efforts?
Yes.
And this is where I'm going to ask you the same questions I asked Mr. Dooling. Is it your preference that operator improve its compliance efforts and bring these wells into compliance, or that Ace Energy be put out of business and its wells put on the state or federal plugging list?
I would like to see all the well violations and all of these dockets brought into compliance whether they're brought in by compliance by ACE, another operators, or the state of Kansas. I just want to see them back into compliance.
Okay. I've again continued to share my screen beyond any reasonable time frame. So, Chair French, if you catch that, please holler at me. Mr. Russell, I had asked Mr. Dooling a question about a settlement proposal that I had tendered to Mr. Kimbrell on May 18th, 2023. That would have allowed Ace Energy to bring all of its wells into compliance within a period of 18 months. Are you aware of the terms of that settlement proposal? Does that ring a bell?
Could I know you had that exhibit, or where you were able to pull that up? Would you be able to do that, please?
Yes, sir. That is what I've marked as Exhibit AX2, and I'm going to publish it right now. Okay, this is the email that you asked me to publish, dated May 18th, 2023, from me to Mr. Kimbrell, and talks about this particular docket. It basically proposes or outlines the terms of a proposed settlement agreement to bring all of these wells into compliance.
Yeah, I can see the document, the email.
Okay. Are you familiar? I mean, did you receive and review this settlement proposal?
I did receive it from Tristan, and I don't recall in great detail the discussions, but I recall my general thought on this.
Was that on or around May 18th of 2023 you received this?
Yeah, on or around. I would. It was in May, I believe.
Okay.
Late May.
And were you in favor of any of these proposed terms or any modification there too?
And I'm going to
I was
object.
not.
I'm going to object to that. That was a conversation that took place with the council president, so it's under attorney-client privilege.
I don't privileged at all. This is my email. It's not.
Yeah,
The conversation. Sorry, I apologize. The conversation
anything
surrounding.
anything relating to your conversations with counsel could be covered by privilege. If you have your own personal observations, what you thought about it, I don't think that's an issue. You can answer as to your own personal observations about the offer.
Thank you, Commissioner French. No, I'm not. I was not in favor of this proposed settlement agreement.
Can you explain why?
At this point in time, where we had built up, so many history of violations and unable to bring these wells into compliance. 50 wells. What was that? 50 wells a quarter, I believe. No.
That was the proposal.
50 total wells, first quarter, 100 total wells, second quarter, etc. I don't think that's realistically possible for operator to complete that. I mean, for multiple reasons, not everything here would be a simple filing paper of a TA or something. There are other, mechanical integrity tests that would be needed. Some wells would probably need to be plugged. They've already expressed the difficulty of them obtaining contract services or in a timely manner to, there was the issue of failed MIT and the timeline it took to get that eventually plugged. But those are big numbers to try to do per quarter. And then I thought it would put a tremendous amount of burden on staff because, we would have to track that and witness these things and to ensure, that everything was done properly and on time. And I felt that we would eventually be before the commission again, as we have in the past, to argue about timelines and deadlines that at the time I thought were clearly in the commission ordered settlement agreements, so that takes a tremendous amount of time too. So I did not think this would be feasible.
Would you have been in favor of a more protracted compliance schedule?
I don't believe so at this time. At this point, we've gotten down so far down the road. I believe it was best to stay within the regulations, go with the regulations, bring it before the commission, let the commissioners make their decision.
Is it fair to say there was no terms that could have been offered that you would have been agreeable to as far as Ace Energy itself bringing these wells into compliance?
That's pretty, broad statement. I cannot think of any terms that I would have proposed that I think would have been attainable. It's a difficult situation with the number of wells we're dealing with at this point.
Given the aggressive, or what you've testified as an aggressive compliance schedule, you had testified that you believe Ace Energy demonstrates a disregard for commission's regulations. If Ace Energy is proposing to cure all of them within 18 months, is that demonstrative of an operator that disregards commission regulations?
I believe it's demonstrative of an operator that has been backed into a corner and now is forced to deal with the situation. We've tried to deal with the operator for a long period of time. I believe, the compliance record, pretty much speaks for itself. We deal and successfully with hundreds of operators within District 3. This one has been a difficult situation to address.
So at this point, there was nothing Ace Energy could have done to remedy its situation in your eyes?
Well, it would have been helpful if they'd have went ahead and begun addressing some of these issues. Even when the operator's license was suspended, they could have been remedying many of these situations. Repair surface control on wells to obtain TAs. There's lots of activities that could have been ongoing that would have showed a good faith effort that they were ready to toe the line and take this seriously and begin addressing these issues. And none of those occurred.
Mr. Russell, I lost you there for a second at the end of your answer. Right as you said, none of those. I don't know if others had that same issue.
Excuse me. I'll restate. I said none of those activities to begin remediating or addressing these issues have occurred voluntarily by operator. That they could have, they could have begun on some of this issues on this that they outlined in this proposal. They could have started on that, and that would have showed, that would have went a long ways to showing that they had a sincere effort or intention that they were going to take this serious now.
Mr. Russell, would you say that offering to fix 50 wells per quarter is a serious offer to bring the leases into compliance or the wells into compliance?
Based on the tangible efforts and results that we've seen versus, telling me you're going to take care of 50 and then taking care of 50 from what I've seen in the past, I think we would have quickly been back before the commission again because, we'd have excuses, want extensions. It would have been drug out. I think it would have been drug out significantly past the 18 months.
Well, here one of the terms offered was that if ACE fell short of those obligations, that by agreement its license would become suspended. So wouldn't that sort of obviate any concerns?
No, simply suspending the license does not address any of the violations? I mean, the license has been suspended quite frequently, and I think currently is, and I've seen no, actions by the operator to go ahead and start remedying these. There's nothing preventing them to go ahead and being proactive and begin this process.
Well, as of November 30th, 2022, and I remind you, this offer was made May 18, 2023, but as of November 30, 2022, staff had filed a motion to basically have operator's license revoked. Why would an operator want to spend money remediating violations if it wasn't going to be permitted to operate them?
Well, I think maybe that, I don't know why operator, what they're thinking, but it may have showed that they were sincere or truly intended to take action at this time.
That's all I have on that particular issue. Chair French, one housekeeping items. I've gone through quite a few exhibits on cross that I've not offered into the record. My intention was to do that at the conclusion of testimony. Is that okay?
Yeah, that's fine. I think probably makes some sense to wait on that one. I'll wait until you want to go ahead and offer it, and then we can make a decision at that time.
Thank you. Mr. Russell, in the spirit of housekeeping, your exhibit TR1 attached to your pre-filed direct testimony is this. Freden's testimony. This is your exhibit TR1, which goes through the penalty orders that Ace Energy has been subject to in the past and the license suspensions. Is it I want to make sure I'm understanding, is staff exhibit 5 intended to replace your exhibit TR1?
I believe there was an update to that TR1. Could you pull up exhibit 5 and it should say, or maybe John can?
I think I just did.
Yeah, it says updated at the top. I see it, sir.
Okay, and this is intended to update your TR exhibit 1. Correct?
Correct.
Okay. I just didn't want to be fumbling around between two exhibits if this is the correct exhibit going forward.
I appreciate that.
Scrolling down, this is the first 2 pages of this exhibit. This is staff exhibit 5, deal with penalty orders entered against Ace Energy of whatever the date of this exhibit is or purports to be. Are you, and this, I want to draw a line of demarcation here at this particular date here, above 23/31/35 and below 23/30/87. The date those penalty orders were issued, being for 23/30/87, September 20th of 2022, and 23/31/35 is December 1st, 2022. That's the line where I want to stop here, because on November 30th, 2022, staff filed its motion to deny operators license renewal application. So I just want to clarify the universe of penalty orders I'm referring to on my subsequent question to you, okay?
Yes.
Are you aware that Mr. Dooling previously testified that all of the wells subject to the penalty orders and the universe of penalty orders I just described had been brought into compliance as of November 28th, 2022?
I am aware that the wells are now or had been brought into compliance at that time. And they brought into compliance, not necessarily by the established deadlines.
And are you aware that Mr. Dooling also previously testified that all fines had been paid at that time?
I do not recall that in his testimony. you're talking from 9/20/22 and prior, correct?
Correct.
Yeah, I'm,
It's okay. You don't have to.
I would assume so. I mean, up to that point, I think, but I do not know for sure without going through there, but yes.
Yeah, and do you have any reason to dispute Mr. Dooling's testimony?
No.
Now, the question I have for you kind of gets back to the issue of fundamental fairness or judicious. Is it fair to say that as of that date, Ace Energy had already faced the consequences of those penalty orders and taken remedial measures?
I believe they were issued penalties, taken remedial measures. I think they may have addressed those specific violations. I do not feel that they have tried to prevent future violations of occurring or may have occurred.
But as go ahead.
No, sir, go ahead. I'm sorry.
I just want to clarify that, the specific penalty orders that we're talking about, Ace Energy had done what it had been asked to do. It had suffered the consequences of those penalties as of November 30th, 2022.
Yes.
And I'm trying to, seemed to me that the crux of your testimony was that the main reason, or maybe the only reason, that Ace Energy's license should not be renewed is because of these particular penalty orders. Is that a fair statement?
I think they're a part of the record, and I would go on beyond the date that you specified that you were not talking about, but I would include them right up to the current date.
Okay.
As a concern for me.
By utilizing these penalty orders as a basis to deny Ace Energy's license, isn't that in effect punishing Ace Energy twice for the same conduct?
I'm going to object. It's the commission that is going to be deciding this. It's not Troy Russell who is punishing anybody.
I think it's a fair question to ask. This goes to just kind of, universal public policy on, do the crime, pay the fine, whatever, and I think Mr. Russell's perfectly capable of answering that question.
Mr. Russell, if you have any opinion, go ahead.
Would you please repeat your question, Mr. Schlatter?
Well, if Ace Energy had been, had already been penalized for these violations, had suffered the consequences of those violations, and had performed the remedial measure, is it fair to then subsequently use that course of conduct to punish Ace Energy again for the exact same things it's already been punished for through the denial of its license renewal application?
Well, the purpose of the penalties is to encourage them to not repeat them in the future, to act as a deterrent, so that they will abide, that they're aware of those violations. There was a consequences, that they do not wish to repeat that in the future. It also acts as a deterrent, for, all operators within the state, to know that the state will enforce their regulations. I do not think that it has deterred Ace Energy from changing the way they operate and, address the large number of violations identified, and they have not been proactive about doing it in the future. It's kind of, if you catch me, I'll deal with it. If you don't catch me, I'm not going to deal with it.
And these penalty orders have been dealt with, correct?
Yes, sir.
Okay. And I'm gonna look at this. I'm remembering to stop share. You also testified that your duties include supervising District 3 staff. Which of the witnesses are subject to your direct supervision of staff's witnesses?
District 3 staff, Brad Boyer, Ryan Doolin, Dwayne Sims.
Okay, so that would you would not be, Nancy Borst and Todd Bryant would not be subject to your supervision.
No.
And I think that's all the witnesses. What about Dwayne Sims? That was the third one.
Yes.
So he's also subject to your supervision.
Dwayne Sims, Brad Boyer, Ryan Doolin.
Okay, thank you. Mr. Dooling previously testified that the violations contained on his exhibit RD2 through RD8 present imminent harm to the environment and pollution of fresh water. Do you agree with that statement?
Can you repeat that? I'm sorry. Was that in his testimony?
Those are the exhibits attached to it. Those are the 300 or 400 wells.
And in his testimony, I'm sorry, repeat that question, and I'm really focused here. So,
and Mr. Dooling testified for hours, so you know that this wasn't all of his testimony or the exact words from his testimony, but generally speaking, he testified that the violations he identified as recited in exhibits RD2 to RD8 present imminent harm to the environment and pollution of fresh water. Do you agree with that statement?
Yes, they could cause those harms to the environment.
Are you aware that staff conducted those inspections in January of 2023?
Yes, sir.
And are you aware that the testimony in the record is that those violations were not communicated to Ace Energy?
I believe any environmental issue like a spill or some ongoing thing that staff discovered was reported to the operator so that they would have a chance to address it.
Do you have specifics on that?
I believe you pulled up the 603 violations. And get my book of exhibits.
Spills that were remediated. I believe those are the. Those weren't violations.
603.
Yeah, Mr. Russell, those were violations for submitting the spill notification form, not the spills themselves.
But they would have conducted where they also show the pictures. We can pull them up. There was obviously significant amounts of brine and salt water at the surface, open holes. They were contacted so that they could address them. So they were brought to operators' attention.
I don't have it other than the spills that were remediated, which weren't alleged violations. I'm unaware of any such correspondence.
Well, can we pull up that exhibit?
Which exhibit?
The Ryan Doolin's 6 through 8.
I'm sorry, I didn't.
Ryan Doolin exhibit. Did you say 6 through 8?
No, this is RD2 through RD8.
I'm sorry, that's correct. RD2 8. I apologize. Yes.
Mr. Schleider, I hate to break out. I think I've lost the track again. Can you remind me what the question to the witness is at this point?
Yes, and I kind of want to maybe rephrase that question to avoid going down this trail. So maybe I should just withdraw the question and restate it.
That's certainly fine by me. I was just trying to figure out what we were driving at with all the discussion of the exhibit.
Yeah, I'm getting there, and I don't have much left to go. So I believe actually it is in Mr. Russell's testimony that well, let's handle it this way. So after these investigations were were conducted in January of 2023, I believe it's been previously testified by you, Mr. Russell, that not a single notice of violation was issued to operator with respect to those particular issues. Is that correct?
No penalty recommendations were made based on those violations. No NOVs were sent to the operator during that time period.
And there's no evidence in the record that these violations were otherwise communicated to Ace Energy at that time.
Well, I don't want parts, but what I'm saying, I believe if we came across a spill where something was fluids were actually escaping from a well bore or line, that would be communicated to the operator so that they could come address it. And I believe that did happen on a few occurrences.
Yeah, I understand that, Mr.
That's all. That's all the communication's about.
I just want to remind you that there were not one violation cited in those exhibits deals with an actual spill, merely the reporting of a spill.
I guess I will have to pull that up because I thought that there was a couple spills but the not reporting also, I mean, that entails they did not clean it up.
But no one's alleged. It's not been alleged that there are spills on these leases, at least in those particular exhibits, that haven't been remediated in violation of commission regulations.
The only thing I'll tell you that have not been cleaned up, we have not determined anything that would maybe need future remediation as far as brine impacts to soil.
As with respect to this, these particular violations and the imminent harm to the environment, are you aware of any actions staff has taken to ensure that pollution or environmental harm does not occur over the preceding 10 months?
Can you be more specific? You mean specifically to Ace Energy or in District 3 in general?
Ace Energy.
No.
Have these findings from these proceedings been used for any other purpose than the pre-filed testimony in this docket?
Not to this point.
Does it concern you at all that imminent environmental and pollution matters have not been directly addressed over the course of 10 months by staff or Ace Energy?
Yes. What we're trying to do.
Through the application or to the motion to deny license, you're seeking to remedy imminent pollution.
We're seeking to force the hand so that at that point the operator would do it, or if the operator is not able to do it or does not have a license renewed, then KCC will step in.
Is a period of 10 months more or less than imminent?
I'm going to object to that. That's unintelligible. Ambiguous, I should say. Sorry.
I think I'm going to sustain it. It just seems too subjective.
Mr. Russell, I'm going to turn to your rebuttal testimony. And I'm about done here. Just to clarify one thing. Pre-filed rebuttal testimony of Troy Russell. Lines 317 through 321. The question asked here is that Mr. Freden claims that you have never traveled to any of operators' leases. Is that accurate? Your response is, I've traveled to several of operators' leases over the years that I've worked in District 3. Is that do you wish to correct that testimony?
No.
So I'm going to call up another exhibit here. We had asked this specific question in discovery. And and the response to that discovery was, most recent recollection of being on Ace Energy's leases is a handful of visits to the Beechner lease in 2018. Do you see that?
Yes.
Is that correct?
Yes.
Is that consistent with your testimony at lines 3, 17,
Line 3.
1?
Mr. Slaughter, did you mean page 3, lines?
17 through 21, yes.
Yeah. Yeah, I've been to several of these leases prior to becoming district supervisor. Prior to Ace Energy obtaining these leases, I've been on some of these leases.
But the most recent time, I guess, is 2018, and we're talking about one lease, right?
Yes, sir.
Okay. Last topic for you here today. Okay. I'm at page 6 of your rebuttal testimony, line 16. The question asked references Mr. Freden's testimony where he alleges that staff retaliated against operator after Mr. Freden spoke with the KCC Human Resources Director about filing a complaint against staff. Question is, did staff retaliate? You say no. Were you aware? I mean, did Mr. Pierenboom ever communicate to you that this complaint had been lodged?
I had a record request to know of communications, which I believe we put together, but eventually we were made aware of that. Yes.
When were you made aware of that?
I do not know the exact time frame. I think it's something. I think it's something that we could find out.
Is there a quick way we can find out? I will offer to you that I believe the phone call to Mr. that's referenced here occurred in December of 2022.
Okay.
So do you recall
from a phone record or a phone document from myself or Mr. Pierenboom?
My question is, were you made aware of that complaint and when?
I don't have that right in front of me, but I was made aware of it. I would assume it was probably fairly recent to the complaint being made.
Do you remember how you were made aware of that?
I can't recall if it was by email or by phone call.
And with that,
probably both.
Okay. And those emails or phone calls were from Mr. Pierenboom or somebody else?
I believe that they would be from Mr. Pierenboom, and it would probably, the response for me was probably made through email to him. Would be my guess, but like I said, I do not have that information in front of me.
Okay, well, Mr. Pierenboom unfortunately is unavailable today, and we had requested we had requested his correspondence, and I don't believe we were furnished any on that topic, and so I was running that trap to its end. Mr. Russell, that is all I have for you today, at least at this juncture. Thank you for your participation.
Thank you, Mr. Schlatter. We are at the point of commissioner questions, but I think this is an ideal time to give everybody a mid-morning break. I see everybody's been working on their coffee. So we will return at 11 o'clock for commissioner questions of Mr. Russell. But right now we are off the record and in recess until 11 o'clock. Thank you all. All right, I've got 11 o'clock, so we are back on the record for this evidentiary hearing. We are still within the examination of Mr. Troy Russell. I see Mr. Russell has rejoined us. We are going to move to commissioner questions for Mr. Russell, and I will begin again with Commissioner Keen.
Thank you, Chair French. Good morning, Mr. Russell.
Good morning, Commissioner King.
I want to, I have just a few questions I want to ask of you this morning. But before I do that, I think it's important for the record to, beyond just the pre-filed testimony, to note your experience and level of responsibility. It strikes me that you have a lot of experience and a heck of a lot of responsibility. I'm looking really at page 2 of your pre-filed direct testimony, and I'm just going to excerpt parts I think are relevant there. You correct me if I'm wrong, if you would, Mr. Russell. If I'm reading this correctly, you have a Bachelor of Science degree in geology from Kansas State University. You received your professional geologist or PG license in 1992. You began working with the Chinook District 3 office in 1997 as a petroleum geologist responsible for overseeing site remediation of environmental impacts to soils, water, and water resources resulting from oil and gas producing activities. And in 2017, you became the District 3 professional geologist supervisor, or basically the supervisor in charge of the District 3 office. Did I recount that accurately?
The first part, maybe I do not have a master's. I thought maybe you said master's. Maybe
no, bachelor's. Yeah.
Yes, sir.
Yeah.
Yes, sir.
Didn't mean to offend. Thank you.
No, that's just one feather I don't have.
Okay. But more to the point now, it appears that, again, from your pre-filed testimony, that as District 3's activities pertain to regulating oil and gas activities, you supervise 2 public service administrators, 11 environmental compliance regulatory specialists, and 1 professional geologist. Is that correct?
It is correct at the time of the testimony. Currently, we now have 2 geologists, Levi and Julie, and now we're currently at 17 total staff. Only 2 are administrative, so not counting myself, 15, 14 field staff now. So
okay, thank you for that. Again, for perspective and by way of overview, and you may not have this at your ready command, but if you don't, just say that you don't. So how many Kansas counties are there within, pardon me one second. How many Kansas counties are there within District 3?
32.
32 counties. Do you have any idea how many oil and gas and injection wells you have regulatory oversight within District 3?
Yes, we have just under 10,000 UIC wells. The producing wells, oil and gas, I don't have that exact number, but it's getting awful close to 40,000. And then that does not include a number of abandoned or orphaned wells that we are currently working through.
All right, well, thank you for that. The KCC has 4 district offices, does it not?
Yes, sir.
The well count that you just gave me is far in excess of the well count in any of the combined total of the other districts or in any single other district. Is that correct?
Yes, sir.
The first question I want to ask you before I get to the questions I intended to ask is really an offshoot of the questions you were asking, or you were answering in response to Mr. Schlater's question on cross. In particular, let me ask you the question this way: whether or not, let me start differently. Are you familiar with the exhibit attached to Mr. Dooling's pre-filed testimony identified as exhibit RD1.
Yes, sir.
That exhibit, by my recollection here, is approximately 667 pages of documentary evidence that pertains to wells that are operated by the operator Ace Energy. Isn't that correct?
Yes, sir.
So my question is this, because there are a lot of issues that are presented by the evidence that's contained within RD1. My question to you is this: whether or not these issues were brought to the operator's attention by the KCC staff, isn't the operator responsible to be aware of and remediate any and all compliance issues presented by the operator's wells, whether or not included within that exhibit, without being prompted to do so?
Absolutely.
We could, Mr. Myers, let's do a screen share again, if we would, of staff exhibit number 5. Okay. Well, we've seen this a fair amount of times this morning, Mr. Russell. I think you're pretty familiar with this exhibit, are you not?
Yes, sir.
Okay, a few questions about this exhibit. In your opinion, does this exhibit accurately portray the operator's past compliance record and the operator's violations and penalty orders and license suspensions?
Yes, sir.
In your opinion, are these listings complete and comprehensive, including the footnoted items on page 2?
No, there are many more violations that we could pursue than what is presented here.
How many licensed, again, another stat question for you, Troy, how many licensed operators, if you know, conduct operations in District 3?
It's difficult to find because we have operators that operate in other districts, and then when you try to pull that information, I would need IT or Denise Klug to maybe work that for us, because it pulls up the license with each well. We deal with numbers, but I think 300 to 400 it'd be my best guess.
Okay. So a part of the nexus of my question, really getting to the essence of my concern here is, based upon your experience, for operators in District 3, is this record of compliance violations and suspensions typical?
No.
Why not?
Don't have the sheer number of repeated violations. In most operators, there are violations, but we are able to communicate with them and talk to them and have them help them address them and direct them to address them, and they do so voluntarily in a timely manner within the regulatory timeframes.
Again, in your opinion, would most operators under the purview of District 3 be incredibly concerned about one penalty order, a single penalty order?
Yes, sir.
You most take action to remediate it quickly?
Yes, sir.
Okay. Let's turn to page 3 of this exhibit. If we could do a screen share once again, please, John. Yes, that's perfect. Thank you. Can you see that, Troy?
Yes, sir.
Here's my question to you. What this does is this sets out from basically 2016 through the current date, a list of license suspensions by the operator Ace Energy LLC, correct?
Yes, sir.
My question to you is this: procedurally, how and why does the commission in its enforcement efforts move from a penalty order to a license suspension?
Because they did not comply with the commission order.
So in terms of levels of seriousness, where would you rank license suspension?
Probably the highest.
And why is that?
You are suspending that operator's capability to produce oil and gas, which is how they make their livelihood.
Very good. So again, for the record, with respect to the docket before us, docket 23-3143, what is your recommendation?
I stand by my recommendation that their license not be renewed. Ace Energy's license not be renewed.
Troy, thank you for your responses to my questions. I appreciate your indulgence. I have no further questions for this witness.
Thank you. Commissioner Keither, do you have any questions for Mr. Russell?
No, not at this time. Thank you.
I have just one clarifying question. It's not for you, Mr. Russell. It's actually for your counsel. Commissioner Keene and Mr. Schlatter both were referring to Staff Exhibit 5, and I just don't recall in my notes whether we have that admitted into the record yet. I think both of them laid foundation for it. If it's not, I just wanted to double check with you whether it's actually been admitted. It's the updated list of.
Right. Yeah, I don't believe it's been admitted. I would move at this point that it be admitted into the record.
Mr. Chairman, I think that is correct. I think I was the first one to refer to that exhibit in conjunction with Mr. Dooling's cross-examination, and I think we deferred on the admission of it, but it could be timely anytime, obviously.
Yeah, I think you laid some foundation, and Mr. Schlatter confirmed it was just an updated version of a previous exhibit attached to Mr. Russell's testimony. So any objection to admission of Staff Exhibit 5?
None from operator.
Okay. And I think Mr. Kimbrell did offer it, so I will order that Staff Exhibit 5 be admitted into the official record of this proceeding. I have no additional questions for you, Mr. Russell, so I will turn back to Mr. Kimbrell. Do you have any redirect for Mr. Russell?
A few quick questions. So Troy, I believe during your cross-examination, Mr. Schlatter suggested that if Ace Energy's license is not renewed and it goes out of business, then all of its wells are going to end up on the Kansas plugging list. Is that the only option for those wells?
Whoa,
No, it is not.
That was not put on in testimony.
You asked if Ace Energy goes out of business,
Authorization of
wells go on the PL list. I believe that was the question.
No, that was not a question. That's something was fabricated.
I will ask the question directly then.
Mr. Russell, I know there was some discussion of who would be responsible for the wells, but I think it would be good if you would rephrase the question.
Absolutely. Troy, if Ace Energy has its license not renewed, will its wells go on to the wells absolutely go on to the Kansas plugging list?
They will go on to the PL list, but they may not remain on the PL list depending on interest from other operators or potential for, interest in those leases to continue production.
All right. So it's possible that many of those wells will not end up being plugged by the state of Kansas.
Correct.
There was a fair amount of discussion about the proposed settlement agreement. Does Ace Energy have to be on a settlement agreement in order to bring wells into compliance?
No.
All right. And I know you talked about this a little bit, but in the compliance agreement, in the proposed settlement agreement, there was a suggestion of bringing 50 wells per quarter into compliance. What is the average number, the typical number of wells that are brought into compliance in a settlement agreement in District 3?
I think it ranged from 1 to 8 per quarter, depending on the size of the agreement and the nature of the violation we're addressing.
Would 50 wells
So,
per quarter? Would 50 wells per quarter be more than you've ever seen in a settlement agreement in District 3?
Yes, it would be the highest quarterly objective, and I do not think it would be feasible to attain that.
So staff filed its direct testimony on April 17th, 2023. Do you recall that being the date when staff filed its direct testimony?
Yes, sir.
And were RD1, all of the field reports attached to staff's direct testimony on that date?
Yes, sir.
Has Ace Energy done anything to bring wells into compliance since that date?
No, sir.
In conducting the lease inspections in January, did staff deviate from normal practice in performing those field inspections?
No, sir.
If a operator's license is being reviewed, does District Number 3 staff perform lease inspections of all of the operators' leases?
Yes, it does. I mean, this was common. We've done that with several operators who had significant compliance issues.
Okay. There was some testimony earlier that Todd Bryant gave regarding changing forms that have been submitted to the commission. Does District Number 3 change information on forms that have been submitted to District Number 3?
Objection. That is already in the record. That Mr. Dooling changed the DR Nelson T application for the DR Nelson V2.
All right, I was just trying to see if that was typical or.
The witness can answer.
On a TA form, if staff has documentation that indicates that, like in that example, the U3Cs filed by the operator indicated that they had not used that well for over 10 years, then we will try to get the correct shut-in date put in on that form. And that's, you know, that says time to put in the description on that. If you look at that denied form, it says, it also indicates where that date come from and why it was changed. The operator can talk about that, but if we left that date and we simply denied it, it creates a lot of confusion for the operator, and potentially, you know, they got 30 days to address that. And that's one of the things that we can do to say, you know, this is what we have. If you want to call and talk to us and debate that, we'd be happy to, but, you know, our records indicate this is the shut-in date. You know, if we need to take a look at that in the future, where we just simply deny it for incomplete or incorrect information that is not as helpful to the operator.
Okay. So it's fairly typical to change the shut-in date on a TA application.
Yes.
Have you changed, has District Number 3 staff changed that date on operators other than Ace Energy?
Yes.
There was also some discussion of Dennis Pierenboom. Do you recall, you've had a chance to think about it now, do you recall, did you receive an email or send an email to Dennis Pierenboom regarding Mr. Freden giving him a call?
I would think that would be highly unlikely, being as IT would have done a sweep of all emails looking for that for the discovery request. I think it could be related to another issue that we were having with a landowner was filing a complaint to or a grievance against one of our field staff in Elk County. And I think probably I was juxtaposing the two.
Okay. Thank you. I don't have any further questions.
I will allow a little recross if Mr. Schlatter, if you have anything.
Oh, very, very quick. Mr. Russell, you were placed under oath at the time your pre-filed direct testimony was offered, correct?
Yes, sir.
And through the 10-minute break we took and until now, you've remained under oath, correct?
Yes, sir.
Did you discuss your testimony concerning Mr. Peerenboom's email correspondence with your counsel during that time period?
Yes, sir.
That's all I have.
All right, any additional commissioner questions? I'm not seeing any hands raised. I'm assuming no redirect. All right, Mr. Russell, we have reached the conclusion of your testimony today. We thank you for your testimony. You may step down virtually. All right, we're at 11:20. I think we ought to keep motoring and at least get started with our next witness. We have concluded all of staff's witnesses. So now we will move on to operators' witnesses, and Mr. Schlatter, you may call your first witness.
Thank you, Chair French. Operator Ace Energy calls Jonathan Freden.
Good morning, Mr. Freden. If you can unmute.
Okay.
And
yes. Good morning.
very, very good. We hear you. Good morning. If you would please raise your right hand. Do you swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Absolutely.
All right. Thank you, Mr. Freden. Mr. Schlatter, your witness.
Thank you, Chair French. Mr. Freden, could you please state your name and address for the record?
Jonathan Freden, 11704 Aberdeen Road, Leawood, Kansas, 66211.
And Mr. Freden, are you here today testifying on behalf of Ace Energy as its manager and member?
Correct.
Mr. Freden, you caused 12 pages of pre-filed testimony containing exhibits marked A1 and A2 in this docket, correct?
Correct.
And would the answers to those questions be the same today as they were when you pre-filed that testimony?
They would.
And do you have any corrections or clarifications of your testimony at this time?
There's I could be more specific on some things if we were to discuss questions. I don't know if I could add more detail if asked.
Why don't we save it for redirect if necessary?
Okay. But yes, there is more detail I could add. Yes. If asked, for the record.
I would submit Mr. Freden's pre-filed testimony containing 12 pages of questions and answers and exhibits A1, A2 into the record.
Any objection?
And I would object to certain lines and ask that they be stricken, specifically page 3, line 26, page 4, lines 6 through 25, and page 7, lines 11 through 13, as all that testimony is hearsay.
Mr. Schlatter, your response?
I was not tracking with those lines here as hearsay.
I know page 3, line 26 was the first I heard.
I would just maybe ask that the commission afford the same deference to the testimony as it has in the previous 6 witnesses.
You've correctly gauged where I was going to go. We have given some leeway to staff in our view of flexibility of the evidentiary rules, and I intend to overrule the objection of Mr. Kimbrell. We're going to allow in the full pre-filed testimony of Mr. Freden, and the commission can evaluate and weigh the credibility and weigh the evidence as it deems appropriate. So the objection is overruled. And Mr. Schlatter, I believe you did offer the testimony into the record, and the commission will admit the entire pre-filed testimony of Mr. Freden into the official record.
Thank you, Chair French. If you recall, at the close of our proceedings yesterday, I offered to proffer an exhibit, and you afforded me the opportunity to put that exhibit in through Mr. Freden. I'd like to do that at this time.
Yep.
Okay. Mr. Freden, do you recall Ms. Borst's testimony from yesterday when she suggested for the first time that the reason your license renewal application was held was because you didn't submit rig tags with it?
Yeah, I remember she said that.
Do you recall her further testifying that she had never received those rig tags as of that date?
Correct. She said that under oath.
Is that correct?
That is incorrect.
I'm going to publish an exhibit here. This is an email from you to Ms. Borst, dated November 29th, 2022, that I would like you to authenticate for me. Okay. And this was, I believe, produced in staff's discovery responses. This is an email string, so I'm going to go chronologically from the bottom. This email here is from Ms. Borst to you.
Correct.
To you on November 20th, 2022 at 2:36. And this, by the way, this exhibit's been marked as AX12. It states, we have received your license renewal but are unable to process your license at this time. Please provide proof of ownership of the 2 rigs you want to tag. That can be a receipt showing 2021 property tax in full, a bill of sale, or title. You may email this to me, to me at her, what I assume is Ms. Borst's email. Your renewal application will not be processed at this time. Do you recall receiving that email?
Yep.
And here is an email dated the following morning, November 29th, 2022. This is from you, Jonathan Freden, to Ms. Borst. It says, Nancy, attached are a bill of sale for each rig we would like you to tag. Thanks in advance for updating. And it references a 1994 Ford F-250 pulling unit and a 1969 International 1700 pull rig. Do you recall sending that email?
I did, as requested.
I'm going to scroll to the bottom. These are the attachments to that email. This is a document titled Bill of Sale dated November 1st, 2022. It's for a Ford F-250 year 1994 pulling unit. Is this the same Ford F-250 pulling unit referenced in your email?
Yes.
And I'm going to scroll down to a second bill of sale dated November 15th, 2022, concerning an International Model 1700 pull rig, model year 1969. Is this the same International 1700 pull rig referenced in your email?
Correct.
So you furnished the requested information.
Yes, this was all that was holding up my license from my discussions with her.
And the following is an email from in fact, this is a reply to an email. An email from Ms. Borst dated November 29th, 2022 at 1:32 p.m. stating that your license renewal has been put on hold, presumably acknowledging receipt of those documents. Is that correct?
That was after that. Yeah, Tristan inserted himself. Yes.
Okay, but you, at this time, you understood that the commission had received the requested rig tags.
Oh yeah, she acknowledged that, put it in. Yep.
And until
no other issues were mentioned.
I would move to admit Exhibit AX12 into the record.
Any objection?
No objection to that.
Operators Exhibit AX12 will be admitted into the record. Thank you, Mr. Schlatter.
And Mr. Frieden, Ms. Borse also testified that she'd only talked to you twice on the phone. Is that accurate?
No, I've talked to her so many times she's in my phone
I'm going to object
as
to
a
this.
direct contact. No, I'm answering a question.
Right, but this is you're doing direct testimony. I should have an opportunity to do my cross exam.
You will.
Yeah,
I've
this
talked
does
to
seem-
Nancy Borst over 10 years or however long I have been in this business. I know Nancy, she knows my voice, and she's in my phone as a direct contact, which my lawyer can, John can introduce as an exhibit if he wants.
So that's well taken. We'll save any of that for redirect if it's within the scope of the cross. We allowed getting the exhibit in. I appreciate that, but I think this does go a bit beyond and into sort of adding additional direct testimony. So at this time, Mr. Schlatter, if you would tender your witness for cross.
I will, and that was my only other question. So I will tender this witness for cross-examination.
Thank you. Mr. Kimbrell, you may proceed.
Thank you. Since we were talking about the email with Nancy, let's start with that.
You want me
I would like to.
I don't think it's still off. I'm sorry. I was just asking if you'd like. I'm still sharing my screen, of course. Would you like to keep that exhibit up for you?
Well, I will actually ask you to put it back up unless you want to email it to me real fast.
No, I'm happy to drive a little
Okay.
bit.
Drive a little bit. Okay. Well, I want to put up my screen first, and then we'll go.
Okay, then I think I stopped sharing mine.
All right. Mr. Frieden, can you see this license renewal application? Is that on your screen?
Okay. Okay.
All right. And this is a license renewal application for Ace Energy, correct?
Looks like it is. Yeah.
And was it submitted by you?
Yes.
And I should point out that this is Nancy Borse NB-1 exhibit. So under equipment 2 tags, did you list the tags that you wanted, the rigs that you wanted to be tagged?
Again, this screen is not information that I can see on my Kohler end. Just to clarify, this is an administrative screen.
Okay. When you were filling out the license renewal application for Ace Energy, did you put in those?
Yes, as we just reviewed, those 2 units, correct.
Okay. And so if I'm reading it right, it's a 1983 Ford F350, correct?
Correct.
And a 1969 Ford F500?
Correct.
Okay. Mr. Schlatter, if we could bring up those bills of sale. I guess I need to stop sharing my screen.
Okay. Can you see it now?
Yeah.
Okay.
So if you go to the bills of sale. Okay. So the first bill of sale, is this for a Ford F250? From
Yes.
1994? Is that either one of the rigs that you listed on your application?
Yes.
So you just testified that you listed a 1983 Ford F350 and a 1969 Ford F500. Is either one of those a Ford F250 from
The
1994?
truck body is different than the unit.
So it's a model Ford.
This is what I sent in. The truck body was swapped. Yeah, we swapped. So if it says what this is, I didn't enter that form. This is what I sent in. I told you that's an administrative. If this is what was sent in, this is what matches the title.
So
that
you didn't
VIN number
enter
matches the title of the 1994 truck. We had just swapped it out. So I don't, again,
And to clarify, you didn't.
the 1983 was swapped out. So this is 1994. This is what needed to be updated. This is what was submitted. Does that answer your question?
No, it does not, because
There previously was a 1983
please let me finish
unit
my question.
body.
Mr. Frieden, please let me finish my question. You submitted
Okay.
a 1983 Ford F350. through Kohler, correct?
No, I did not. Let me clarify that. No, I did not. I submitted this.
All right, let's go back to.
I did not input that screen. That's an administrative screen.
All right, let's go down to the next bill of sale, please, Mr.
I
Schwartz.
submitted what's on the bill of sale.
Okay, so you also submitted a bill of sale for an International 1700. Is that a 1982 Ford F-350 or a 1969 Ford F-500?
These are new tags. I did not have any. These were new tags. It doesn't matter. I was submitting these to be put on my application. So I don't know. She puts the information in, not me.
Does this bill of sale match either of the rigs that were listed on your license renewal
I
application?
don't. That screen is not mine. That's Nancy's screen.
Are you the one who enters in the rigs that you want to be licensed?
No, I sent this in to Nancy. She enters it in.
That wasn't my question. I was asking if.
No, I do not enter it in. No, I do not enter it in.
Okay.
She asked me to submit these. I submit these. She enters it in.
Will you admit that the bill of sales that you submitted do not match what is on the license renewal application that we have a copy of?
I don't know what's on there. No.
I just showed you what was on.
She asked me to. Okay, well then that's incorrect on your end.
All right, so you will admit that it doesn't match.
May I interject?
I think that's.
No, you're harassing me. You're not answering. No, I'm answering the question. I submitted this. I don't care what's on there.
All right,
Doesn't matter. This is a license renewal.
Mr. Freden, let's let your counsel. I think he had something.
Well, you're harassing me. I answered the question.
Mr. Freden, hold on. I think this clarifies the point here. This is in the evidence. Thank you, Advance, for updating the make model year. We inputted into Kohler. The issue was resolved on this date. The testimony is being elicited on.
And again,
we can move on.
It says error.
For his client here.
All right.
I think.
All right, we can move on.
Yeah. I think the documents are going to speak for themselves in this situation. Let us make sure that the commission is able to draw on all those documents. We did admit staff's exhibit AX12. Mr. Kimbrell, the Kohler application, I assume that is in evidence.
Yeah, that was part of Nancy Borst's testimony,
okay.
Exhibit
Right.
ND1.
So we have all of the documents and can evaluate the back and forth of what was submitted and what requests were made. Is that fair?
It's very clear here what was submitted.
Okay, Mr. Freden, moving on. In August 21st, 2019, were you involved in a 3-day jury trial in Crawford County?
Ace Energy was involved, and I was a co-defendant. Yes.
Okay, and did the jury trial was it concerned about whether Ace Energy had committed fraud against J&B Oil and Gas?
May I just lodge an objection? I'm not.
Oh, go ahead.
This particular line of questioning doesn't appear to be in any way related to the testimony in the record.
This goes to the motion in limine regarding J&B Oil and the fraud that had been found by the jury.
That motion in limine has been ruled upon. This is an evidentiary objection based on the point of what relevance does a 2014 lawsuit have to do with Mr. Freden's testimony?
Yeah, so at this point, I don't know the relevance. I think I'm going to have to allow Mr. Kimbrell a little bit of leash to understand how this may relate to the issues in this docket. But Mr. Kimbrell, I will ask you to get there somewhat quickly so we can see where this is going and make a decision on whether it's going somewhere relevant. I will remind the parties, though, this isn't a jury trial. This is effectively a bench trial, and we're going to give a little more latitude, and then the commission can decide whether it wants to give any weight to these sorts of matters or whether it would be appropriate. But I do want to see, what the relevance of this is. So go ahead, Mr. Kimbrell. We'll overrule the objection for now.
Okay, thank you. So just to be clear, J&B was an oil and gas operator in Kansas, correct? Mr. Freden?
J&B was not a licensed operator when I met them.
Okay. Did the jury find that you committed fraud against J&B Oil?
Who is you?
Did the jury find that
Ace
you had-
Energy was not, Ace Energy was dropped out of the case. So is this a personal question against me? Ace Energy was not involved in the case. The jury
Okay,
did not,
so-
they dropped charges. This is a direct question towards me personally. So how is that relevant?
As the sole owner of Ace Energy, did a jury find that you personally had committed fraud?
Can I just relodge my objection? I'm not quite following where this is going, other than to improper character evidence.
I've caught your objection, and we're going to continue to overrule it to see where it is going.
So, Mr. Freden, you can answer the
jury-
question.
Okay, yeah, that's fine. A jury made a decision against me in that case, yes.
Okay.
On some counts, yes.
And one of those was fraud. One of those counts was fraud, Mr. Freden.
Contract, yes, there was a disputed contract that wasn't signed, yes. It was a business case, had nothing to do with oil. It was all contract.
It had to deal
Go ahead, go ahead.
it had to deal with a lease, did it not? An oil and gas lease.
No, well, it was, no, it had to do with a contract. The lease, Ace Energy was dropped. It just literally had to, at the end, it had to do with a contract that wasn't even signed. And it went to a jury, not of my peers, but that's fine. That's what happens in law.
All right, just to make clear, this did not involve the Beechner lease.
It involved a contract between myself and the other party, a sale contract.
Okay.
Has nothing to
Let's
do
go
with, it was a dispute.
go
So
into-
I don't understand the relevance here. Personal dispute.
I just wanted to draw it that you had been found by a jury to have committed fraud, which I believe you have admitted to. So we can go ahead and move on. So let's start with docket 23-3017. To your recollection, is that the docket that concerns operating under suspended license?
Okay, if that's. All right.
Was that a yes, Mr. Freden?
Yes.
All right, thank you. To the best of your recollection, was Ace Energy's license suspended between June 21st, 2022 and July 20th, 2022?
Again, you'd have to bring it up. I don't, or my counsel I don't have the exact, I mean, if that's what you're saying, then what was it? What were the dates?
Do you have any reason to doubt the Ace Energy license was suspended from June 21st, 2022 to July 20th, 2022?
Oh, no, I know,
Okay.
I'm aware of that, yes.
Okay, I'm going to share my screen. And we're looking at Exhibit B in the 23-3017 penalty order. Can you see that, Mr. Freden?
I can see some pump jacks, yeah.
Would it help if I made it a little larger?
I can see it.
Does that help?
Thank you.
Okay.
All right.
Are these pictures of the Peggy Kruger number L74M73 well?
No, I don't think it is. Doesn't look like it to me.
What do you think this is a picture of?
I have 400 wells, but I don't think that's the Peggy Kruger well because there's fluid next to it, and that's not the right. I've questioned a lot of the facts in this case, so I'm questioning that. So you asked me a question. I don't think that's the well.
Okay.
The right well.
Do you believe this is an
I
H
answered a question.
All right. Do you believe this is an Ace Energy well?
Excuse me?
Do you believe this is an Ace Energy well?
I can't tell from the picture, to be honest with you.
Okay. From the picture, can you tell that
There's no markings on it, and no, it does not look like the Kruger lease. it's a field, it's a plowed field with crops. So I'd question, but that's okay. You asked me a question. It's possible.
Do you happen to know the API number for the Peggy Kruger number L74M73?
I don't have it in front of me, but okay, that's probably the correct API number. I'm going to go on that.
Okay, and you believe that matches up to the Peggy Kruger name?
Quite possibly, but again, I mean, we've seen a lot of mistakes today. So
okay, and
for,
do you happen
for
to
the
know
past
the
2
latitude
years? Let
and
me
longitude?
rephrase that.
Yeah, Mr. Reed, I'm asking you a question. Do you happen to know the latitude and longitude of the Peggy Kruger?
No, I do not. I know
Do you
exactly
have
where it
any
is on a
reason?
map. I don't know the exact coordinates, but the KCC system is not accurate because they were out there redoing all that on your lease inspections.
Do you have
So
any
no,
reason to doubt?
I don't acknowledge that that is correct.
Do you have any reason to doubt that the latitude and
Yes,
longitude
I do have
accurate?
reason to doubt. I do because on your lease inspections, they were redoing everything. Yes, I do have a reason to doubt. And you can
And
ask your staff that.
Have you raised this issue before?
Yes, because that's not my responsibility to do longitude, latitudes. That's their responsibility.
Did you raise this issue
'Cause
in your testimony, Mr. Frieden? Did you
It
raise
was
this
not,
issue in
no,
your
I raised
testimony?
it to staff when they were doing it.
So in
I
your
said, why are
testimony,
they
there's
out
nothing
there?
about
I
this
said,
being-
why are they out there? And they said, we're doing our GPSs is what they told me and my staff. So they do that all the time.
So, Mr. Frieden, there's nothing in your testimony where you claim that this is not actually the Peggy Kruger L74 M73.
You asked me a question, I'm answering it. I'm not sure.
Hold on. This just for my own purposes and for the clarity of the transcript, we can only have one person speaking at a time. So I'm going to ask that the witness, when the attorney is asking a question, just let him get to the end of his question. And then you can disagree all you want, but it is important for the transcript to only have one person speaking at a time.
Thank you. Mr. Frieden, my question was, did you raise in your testimony, in your pre-filed testimony, your belief that this is not actually a picture of the Peggy Kruger L74 M73 well?
What's the relevance of that? You asked me a question today. I'm saying that I'm questioning I question KCC data because they've changed, as we've discussed. The information has been changed. Staff has been not trained, and staff has railroaded me in terms of putting false information in. You asked me a question. I'm saying, no, I'm not certain that this information is accurate. That's my answer.
That is not the question I asked you, Mr. Frieden. Please answer the question I asked you. If
what
you
is the
have feeling
question?
that you believe it is not relevant, your attorney can object. My question is, in your pre-filed direct testimony, did you raise your belief that you think this is not the Peggy Kruger L74 M73 picture?
Not specifically on this one, no.
Before you answer that question for the 14th time, I'd just ask that, this has been asked and answered, that we move on. He's testified now that he doesn't think that's the correct photograph of the well. The document is already in the record. The commission can garner whatever it wants to from that record. But to continuing to ask questions about where GPS, whether he knows the GPS coordinates of specific wells or the API number, is not helpful.
I was just trying, with that last question, I was just trying to raise the fact that this has not been raised as a defense previously.
But you asked him about it and he answered the question, so now it has.
All right. Now that there's an answer, certainly.
I do agree that the questions are now asked and answered. I think we've got an idea of the disagreement. So if you will move along, Mr. Kimbrell.
Absolutely. Thank you. Mr. Frieden, does this show the pump jack going up and down?
It's 2 pictures. I don't see, it's not a live action shot. So it shows a pump jack up and down. So it does not show. So yes, it shows 2 pictures. Yes.
And if you're seeing a pump jack going up and down, does that mean that the well is likely producing?
I'm not seeing a pump jack go up and down. I'm saying someone could have moved it up and down. I'm not saying that there's electricity. I don't see anything. So no, I'm not going to answer that that's a pump jack going up and down.
All right. would you consider it possible that this well was in operation on July 8th, 2022?
Not to my knowledge.
All right. Let's move on to the next well. This is Exhibit B, page 6. And Mr. Freden, is this a picture of the Stanley Stitt number I6I well?
Again, to the exact well, I don't know. I'm looking to see if that's it looks like the Stan Stitt lease, yes.
So you admit that this is an Ace Energy lease?
I will admit this is an Ace Energy lease, yes.
Okay. And in the picture, do you see the pump jack going up and down?
No, I do not. And I know it's not going up and down because there's no power to it.
How do you know there's no power to it?
Because we've had a fire there and there's no power to that pump jack.
So are you testifying that someone—
I'm testifying that the
jack—
picture has been altered and you can see that the pump jack's not going up and down. You can see. And I know that there's no power there.
How can you see that it's
Look
not
at
going up and
it.
down?
Well, I can see on the wheel's the same. Look at the position of the wheel. The pump jack, and I know there's no power there. So no, it's not going up and down.
So the horse head being in an up and down position suggests to you that it's not
Yeah,
going up
somebody
and down?
moved it. If there's no power there. So no, that pump jack is not going up and down.
And so you're testifying that you do not believe this pump jack—
I do not believe
that this well
pump
is—
jack is going
Mr.
up and
Freden, I
down
have not
because the
finished my
motor is
question.
not. Okay.
Mr.
Freden,
Freden,
please let me finish my question.
please allow the attorney to finish. his
Well,
question.
I'm being harassed.
Mr.
I
Freden,
answered the question. Move on.
Mr. Freden, are you testifying you do not believe that this well is producing oil?
I know that the well is not producing oil.
Okay. So were there any Ace Energy leases producing oil between June 21st, 2022 and July 20th, 2022?
If it was during a shutdown, no. If I was requested to turn stuff off, then it was no.
And did you personally turn off all of your wells by June 21st, 2022?
I personally ordered and I came down to check. Not all of them, but yes, I personally ordered that.
All right. Did you come down and check the Stanley Stitt number I6I?
The Stanley Stitt didn't have power to it.
That was not my question, Mr.
I
Freden.
told
Did
you it
come
had
down
a fire.
Personally check. Mr. Freden, please let me finish my
I
question.
did not check
Asked—
the Stanley Stitt lease because it doesn't have power to it. I
Thank you.
answered the question. No, I did not because it doesn't have power to it because of the fire.
And did you personally check the Peggy Kruger number L74M73 well?
I personally came down and checked the Peggy Kruger. The power was off.
And what date did you go down and personally check it?
I don't know what date it was. It was whatever date. I don't recall. I was down there checking to make sure all the leases. It was over a multi-day period.
Roughly, when was this multi-day period?
But that lease only has 2 or 3 wells. I don't recall. Before the deadline.
So it was before June 21st, is what you're testifying?
That's all I recall.
Okay.
Before the deadline, correct.
So you weren't on the lease on July 8th, 2022?
Before the shutdown deadline.
Okay.
I don't recall a specific date. Again, I go down there regularly and I give orders. So was I on the lease around that time? Yes. I mean, I was around there. Yes. Multiple times.
On July 8th? I'm sorry, I missed the last part of that.
Why would I be on there on July 8th specifically?
That's what I was asking. I wasn't sure what you were testifying to.
I wasn't testifying to that.
Okay. I misunderstood what you had said.
No, I did not say July 8th. You said that.
Okay. So you weren't on the leases on July 8th?
No, probably not.
All right. I'm going to move to your testimony real quickly. Page 9, lines 14 through 16. It states there that you, after your license was suspended, you called Nancy Borst and requested that she intervene. So when you called Nancy Borst, you knew that your license was suspended. Is that correct?
I called Nancy Borst to find out what the situation was because I had a TA that needed to be reviewed, the V2, and I had no action done on it, which I've already testified. And she refused to take any action on that. And I said, this is causing the suspension. I should not be held accountable. And she did nothing I called her numerous times, even though she claims I never called her. Mr. Dooling was on vacation. He was no longer available. And then Mr. Russell refused to do anything about it after she contacted him. And I said I had a deadline that if I didn't address this, then there would be potentially a 10,000. She didn't care. And she said that no one's available, no one can help me. And I said, why should I be penalized for their inaction on a well that actually was even valid? So it was I can get into that too, if you want to ask me about that.
We'll get there, Mr. Freden, but right now,
the V2 well is a valid well.
Mr. Freden, that was not my question. My question was, when you called Nancy Borst, did you know that your license was suspended?
Yes, that was the reason I called her, because it was a mistake. It should not have been suspended.
Thank you.
That's exactly why I called her. I said, why is my license suspended? Because it shouldn't be.
And what date did you call her?
Because it's a problem my license shouldn't be suspended because, well, what dates? I can give you the exact date.
That would be great. Thank you.
Because I have it in my notes.
Okay.
$622. ACE urgently contacts staff, TA status, and why they have not been reviewed to avoid the 6:30 deadline. Avoid license suspension and possible fines. Dooling was on vacation from 6:15 to 22 till after July 4th holiday. District management refused to have another staff member review the TA application, which had been sitting for weeks waiting for KCC review. Refused. And then when I said, why is my license suspended? I thought maybe there was the payment the payment was made. Everything was fine. She said there was a pending TA that hadn't been reviewed. And I said, why am I being held accountable for staff's incompetence? And she said, it's out of her hands and Troy Russell, and he refused to do anything. Dooling was on vacation. And when she got a hold of him, he said, well, I'm on vacation. It's not my problem. So there was a concerted effort to ensure that there was maximum harm and to cause my license suspension on a well that shouldn't have even been TA'd. It was an active EOR well. So this is a bunch of BS as far as I'm concerned.
Mr. Freden, to your knowledge, does Nancy Borst suspend and unsuspend licenses?
Yes.
And how do you know this?
Because she tells me. And
So
she looks at the file, because I talk to her a lot, because I know her, even though she doesn't claim to. She goes in there, looks at the notes, and she said, oh, you have a pending TA. I said, we specifically discussed this. I have a pending TA here, and I can't, this is why you have a suspension. And I said, excuse me? I said, it's been sitting in there. Well, I said, my license should not be suspended because of staff incompetence.
So,
and she said, yeah, I agree with you. Those I can do. It's a lot of sense to me. And sure enough, staff's witch hunt against me continues.
From everything you said, Mr. Freden, Nancy Borst did not say that she could suspend and unsuspend your license. Am I correct?
How do you know what she absolutely has the authority to do that. She does it when fines are paid, when she looks on her screen and says that in Dooling or whoever, Troy Russell puts in their notes, She does. She unsuspends them unless you get involved and you cause problems. So like you've done.
All right, let's move on.
Illegally.
Does Nancy Borst approve or deny TA applications? To your knowledge?
No.
All right,
But
thank you.
she has the authority and the necessity to contact the people that can do. Hence why I called her 5 times.
Mr. Freden, I haven't asked
And
you a
how
question.
she conveniently doesn't
Mr.
provide
Freden.
does
Okay,
not provide the
let's-
discovery that you did not provide.
Let's keep moving.
Did you
to the
provide
next
it?
question.
Why don't you answer that question?
Mr. Freden, I'm asking the questions here. Please wait until I've asked a
Well,
question.
you need to answer your own
I'm going to
questions. I'm
instruct-
upset.
I am going to instruct the witness to answer the questions that are asked. And then to
Okay,
allow the attorney
okay.
to move along. We need to keep,
Well, the attorney has broken the law.
we just need to keep a clean record here.
All right, so moving on.
Plenty clean for
In
me.
your testimony, page 9, lines 4 through 7, you state that you filed a TA application for the DR Nelson number B2 well within 2 weeks of May 10th, 2022. Is that correct?
Yes.
And so I am now moving.
And let me add on that I had a conversation, I can give you the date as well, with Mr. Dooling about that well doesn't even need a TA because it's an active injector well with the
Mr.
MIT,
Frieden.
and he refused to acknowledge that. You asked me, did I file a TA? I was forced to file
It
a
was a yes
TA
or no
on
question,
that.
Mr.
I was
Frieden.
forced against my will. You asked me.
All right, I am going to again instruct the witness to be responsive to the questions that are asked.
Thank you,
Okay.
Judge.
Okay.
This is staff's exhibits 1, page 1 of 15. I believe it's already been admitted into evidence. Mr. Freden, does this document show that you submitted the TA application for the DR Nelson number B2 well on June 11th, 2022?
I was waiting to hear, but yes, I think that, well, I don't know. This is not my records. I don't know. I cannot vouch for this, but I can vouch because we have, my lawyer can submit the emails today. We were waiting on feedback from staff to submit this because it was not needed to be submitted. And hence why we had to submit it finally, because I just, we had to do something because of a deadline, but it did not need to be submitted because it was an active EOR well that had just been MIT.
All right, that wasn't my question, Mr. Freden. My question was simply whether it had been submitted on June 11th, and I believe you answered yes. So my next question is, did you submit this TA application?
I'm going to say that
more than 2 months, Mr.
record,
Freden, I'm speaking.
I don't know. Let me
Mr.
rephrase that.
Freden,
Let me
please.
rephrase that. Okay,
Please
fine,
respond
fine.
to the attorney's question.
So, Mr. Freden, you submitted the TA application for the DR Nelson well more than 2 weeks after May 10th. Is that correct?
Well, let me rephrase that. I don't know when we presented evidence on when I submitted it. I don't know if this is a Kohler generated system from, I don't know. If we presented the evidence, if that's what it says, then that's what it says.
All right, I'm going to move down to staff's exhibit number 1, page 2 of 15. Is this the temporary abandonment well application that you submitted for the DR Nelson number B2, Mr. Freden?
Looks like it, yeah.
All right, this is a commission record. I would ask that the commission take administrative notice.
Any objection? Hearing none, we will take notice of this record. Mr. Kimbrell, can you just identify it one more time for the record?
Sure, it's staff's exhibit 1, page 2 of 15.
Okay, thank you.
And Mr. Freden, does indicate on this TA application that on the TA application that it was denied on July 6th, 2022?
Yes, and it also shows that it was altered.
That was my question, Mr. Freden. I was just asking if it was denied
I've
on
altered that. It says shut-in date, why, yes, it shows, the 6th. I don't know when it was sent to me, but it shows that's a date that's on there, but it also shows that the shut-in date was changed.
All right. And
So was it sent to me back?
this TA application.
Was I contacted on that? No.
Mr. Freden, this TA application was denied before staff claims that they found 2 of your wells operating on July 8th, correct?
There was a deadline. No, that's incorrect. I disagree with that. Staff had an obligation to let me know prior to a deadline. And also staff changed the information on this.
Mr. Freden, my question was, is July 6th before July 8th? That was the extent of my question.
It's July 6th before July 8th. What does that matter?
I am asking if the TA application denied on July 6th.
It's a month after it was
occurred before
submitted.
the July 8th deadline, before July 8th, when staff claims they found 2 of your wells operating.
It was after the deadline of my $10,000 fine.
And staff is claiming that they
My
found.
fine was,
All right, the
yeah,
documents.
and
speak
staff
for
had
them-
an obligation to approve this or deny it before. So yes,
Mr.
my
Freden,
answer is
we'll
that
move
we
on.
testified to that already.
The documents
Thank
speak
you.
for themselves at this point, but I will remind the witness to please try to be responsive to the question.
Okay, let's move on to the next penalty order.
Well, again, I am a witness and I'm being harassed. So I don't appreciate, I answer a question, and we need to move on after I answer it.
Ms. Freden, I'm the one asking the questions here. I'm just asking that you answer those questions. We're going to move on now
I am
to
answering
docket
them.
23. Mr. Freden, we're going to move on to docket 23-3029. To the best of your recollection, is this the penalty order regarding 2 failed two MITs that did not occur before the deadline?
Yes, it's a docket, correct.
Thank you. So, pardon me while I scroll down a bit. Okay, let's start with the E. Larson number 6 well. Is this the MIT form for the E. Larson number 6 that you submitted?
I did not submit the form.
Who submitted the form?
Jackie Windish.
And who was that?
She is the hired contractor that handles handles MITs for me, as you can see on this.
Okay, and does this form show that the MIT failed on April 5th, 2022?
Again, I didn't submit the form, but if that's what it's test date, April 5th, correct?
Okay, this is Staff's Exhibit 2, page 1 of 14. I would ask the commission to take administrative notice.
Hearing no objection, we will take notice of this document.
I had one objection. I apologize, and maybe I'm just misunderstanding the order of
Okay,
things.
we will rewind that finding. Go
Yeah,
ahead,
sorry.
Mr. Schlatter.
I wasn't quick, not triggered quick enough. I can't tell. This exhibit has 69 pages. I can't tell where the exhibits begin and end. Just for the purposes of this particular exhibit, purportedly has 14 pages. I don't recall reviewing those. Just maybe ask that we be real careful as to what we're talking about and what's actually admitted.
Yeah, absolutely. So this is Staff's Exhibit 2, page 1, and attached to the MIT form is a letter. And Mr. Freden, does this letter say that on April 5th, 2022, the E. Larson 6 well failed mechanical integrity test?
I don't mean to interrupt, but I had lodged an objection and I don't believe it had been ruled on, and we're just kind of plowing ahead with testimony.
Yeah, Mr. Kimbrell, what do you think about moving through the document, and then you can be very specific about which portions you want to make sure are part of the official record? Is that acceptable to you, Mr.
Yep,
Kimbrell?
that would be great. It should be all of this Exhibit 2.
Okay.
All right, so on page 2 of Exhibit 2, Mr. Freden, is this a letter stating that on April 5th, the E. Larson number 6 well failed a mechanical integrity test, and under KAR 823-407C, you have 90 days to repair the test, plug the well, repair and retest the well, plug the well, or isolate the leaks?
Yep.
And does it give a deadline of July 4th, 2022 to perform these tasks?
Yes. Yes.
Right. Now moving down to Staff's Exhibit 2, page 3 of 14. Is this an MIT form for the hold on, I think maybe yeah, I apologize. It looks like I may have grabbed the wrong lease. I apologize. We'll skip that one. So, Mr. Freden, I believe in your testimony, you stated that you plugged the EC Larson number 2 well on July 6th, 2022. Is that correct?
If that's what it says, yes.
Okay. So
Against my will.
Did Ace Energy plug the well after the July 4th deadline?
We were given permission. Casey Jessup was in constant contact. We were given permission by staff. We were said that was okay because of the July 4th holiday.
Who on staff told you that?
Ryan Dooling. Talked to Casey Jessup.
Ryan Dooling
Yes.
talked to Casey Jessup. So you didn't speak with anyone from KCC?
Numerous times. Excuse me?
You didn't speak to anyone on KCC staff, on District Number 3 staff?
I was told as well by Dooling. Yes. We
So
both
Ryan
were,
Dooling-
because I wanted to call and confirm it. It was the July 4th holiday. I was concerned about, we all were concerned, and yes, KCC staff signed off on it. Yeah, but
Good.
and Casey Jessup confirmed it with Dooling.
So when you say signed off on it, did they send you an email?
He was able to get a hold of him. No, verbal.
So Mr.
Because anyone with a reasonable sense of, because of the July 4th holiday, unless you're being attacked by the KCC, would be reasonable with this.
Mr. Freden, did you receive an email from anyone in District 3 extending the deadline to bring this well into compliance?
We received a verbal phone call, and nobody had time to receive an email because it was a July 4th holiday.
Okay. And
it wasn't necessary. I gave you the answer. We were given permission by Ryan Dooling.
And Mr. Freden, you had already had more than 90 days to bring this well into compliance since it had first failed at MIT.
Staff was fully aware of the problems we were having, and they worked alongside us. They were fully aware, and they actually made us plug it the wrong well that we were on. So they had full knowledge of what we were doing and cooperated with Casey Jessup, and who they've had very good relations with.
Mr. Freden, in your pre-filed.
Yes, we had major problems with this well. It takes time, and we worked on it, and you can ask and call back Dooling, and he'll lie, but he's fully aware that we were working very diligently on this.
Mr. Freden, in your pre-filed testimony, did you make any of these claims?
I'm making, you ask me questions now. My pre-filed testimony, can I talk about the last 2 years? No, you asked me a question, I'm telling you now.
And I'm asking you whether you raised this defense previously.
I said at my start of my testimony that I'm providing more details. Did I not say that?
And you didn't feel that this was an important detail to include in your testimony?
I just object at this point.
We've discussed this in our case, that staff has been lying.
May I just suggest an objection that perhaps if Mr. Kimbrell doesn't want these answers, he shouldn't ask these questions?
If you don't like the answer, I'm sorry, but this is our central case. That Mr. Dooling won't acknowledge the fact that he went on vacation.
All right.
And Nancy Borst doesn't talk to me. And where are the phone records?
We got the answer. Everybody at this point.
Everyone's lying here.
All right, Mr. Freden. Mr. Myers, do you have the ability to just mute all the participants?
I do, yes.
I'd like to have a quick sidebar with counsel for both parties. And you could probably include the other commissioners in that as well. Do you have the ability to create a breakout room for that sidebar, Mr. Myers?
I do, yes. Give me a moment.
Thank you. You all should see a button pop up if you're invited to the sidebar. You'll get a button to pop up to join that breakout room. Okay, Sean, I think you can take down the slide. We're back. All right, this is Chair French. We are now back on the record. I've conferred with council. What we're going to do at this point is we're going to go ahead and break for lunch. And we are going to break until 1 o'clock, so a little extra time. So at this point, we are now off the record and in recess for lunch. We will reconvene at 1 o'clock p.m. Please, everyone, make sure you mute your microphones, turn off your cameras. Okay, folks, we are at 1 o'clock, so we've reached the end of our lunch break. Let me confirm that we've got both commissioners back. I see Commissioner Keen coming on camera and Commissioner Keither. Okay, looks like we have everybody. I apologize, I cut us off in the middle of Mr. Kimbrell's cross-examination of Mr. Freden. So we are, if I didn't say it before, we are now back on the record. And we are resuming with Mr. Kimbrell's cross-examination of Mr. Freden. Mr. Kimbrell, please continue.
Thank you. Mr. Freden, if you recall, we were talking about docket 23-30-29, which was the two wells that had failed MITs. Do you recall that?
Which two wells?
The EC Larson and the E Larson.
Oh, yeah, yes,
EC
yes,
Larson,
yes.
Yeah.
Mm-hmm.
All right. So is it correct that you claimed in your testimony the EC Larson number 2 well was plugged on July 6th, 2022?
July, yes, it was. Yes.
Okay. And July 6th is after the July 4th deadline that you were given by staff, correct?
Correct.
Okay. I'll share my screen real fast. And so we'll go down to a MIT for the EC Larson number 2 well. And this is staff's exhibit 2, page 11 of 14. And do you agree that this is a MIT for the EC Larson number 2 well, Mr. Freden?
Yeah, real quick before I just wanted to apologize for my previous outbursts. I have a terrible headache from not sleeping, and I wanted to apologize to council and the commission. And yes, I will. That's of my own volition. So I do apologize for my upset nature, but
Sure. No
little
apologies
Tylenol helps. So
very good. Well, we'll move forward. No apologies necessary, but much appreciated, and hopefully we can get through everything today.
yes.
And I would echo Chair French and say thank you. Thank you for that. So to return to my question, does this look like the MIT for the EC Larson #2 well?
Yes, this is an MIT submission. Yeah.
All right. And does it have a test date of July 8th, 2022?
Says on the bottom, there's a note of 7/4/2022. I don't know.
It was at the deadline that staff had given you, July 4th, 2022.
I think the deadline was the 6th. You could,
No.
I mean, no.
Ms. Freden, you testified that it's the 4th, and we've shown a letter showing that it was the 4th. Do you remember that?
Okay. Then again, yeah, then this was submitted by my MIT people. So the test date is is what it says.
Is the 8th. So you couldn't have plugged the well on the 6th, correct?
Is this the same well that was, test date acquired the 6th? Test date.
Larson 2.
No, it says here, again, I didn't submit this form. It says right here, 7/6 is the date acquired. So maybe the form was sent in. Again, I didn't, Jackie Windish does the form. So it says date acquired and then it's on the 6th. So, but I do think that well was plugged after because we asked for permission, like I said. I think it was plugged after the deadline.
Okay. And just to put a bow on this, is it possible that the well was actually plugged on the 19th of July? And I'm looking at
yes, it's possible.
Exhibit 2, page 14.
Yeah, that's correct.
So it was plugged on the 9th. So it was plugged well after July 6th.
It was, but again, I just want to remind it, we were in communication. Casey was in communication with the KCC about that.
And I think as we've covered, you didn't bring that up in your pre-filed testimony, correct?
I'm bringing it up now, so I'm putting it in the record.
Let's move on to the next docket. So this is docket 23-3087, unauthorized injection at 5 wells. Is that what this docket concerns, to your understanding, Mr. Freden?
Yes, to my understanding, that's correct.
And in your pre-file testimony, did you testify that no water has been injected into any of these 5 wells listed here? I can go to your testimony if you'd like.
Injected in those wells, they're not. Yes.
Page 8, 25 through 26. You state that no water has ever been injected into these wells. They were hooked up for injection because the plant was.
To the best of my knowledge, that's what my staff. Again, I don't live on the lease, but yes.
Okay. Going back to the penalty order, I'm going to go down to Exhibit A, page 3. Is this a picture of the Gale Mullen I-43 well, to the best of your knowledge?
To the best of my knowledge, yeah.
All right. And to the best of your knowledge, is this what the well looked like on July 13th, 2022?
I'm going to go with you on that. Yeah, to the best of my knowledge. Yeah.
Okay. Is an injection line hooked up to this well in the picture?
I don't know what that line is. We relayed that entire release. So it was relayed for potential injection and lines were put in. So I'm not, that it was there for injection, could be a future injection, but they weren't set up for that yet.
What were they set up for?
We put in all new infrastructure there. So wells could be dually used. So that could be a lead line. I don't know what that is. I'm not.
So are you saying that this is a duly completed well, Mr. Freden?
No. I'm saying the lead lines we put in would allow for wells to be converted.
Okay, my apologies. To the best of your
The
recollection.
lines were put in, so that's why there would be, I'm sorry, go ahead.
All right. Just wondering where the other end of this line was attached.
Based on our, it would be attached to a main trunk line going in through the middle.
And if all the valves on those lines were in the open position, would water flow into this well?
They were not set up currently for injection, so there's no way that water could get, the trunk lines were closed.
The trunk lines were closed, so the valves
Correct.
here were open.
The trunk line in the middle of the lease was not set up to allow that at this point. They had to be converted to injectors to allow that.
Okay, but I'm asking where the valves leading into this well, other than the trunk line, were they all in the open position?
I have no idea.
Okay.
I can't tell looking at the picture personally, no.
When was the last time you were on the lease?
I'm on lease regularly, but not, I mean, again, that well, the lines would not allow water to go to them because the trunk lines are not activated. So that's all I can tell you because I designed it.
All right. And when did you hook up the injection line to this well?
I didn't hook them up.
Who did?
Why are you saying they're hooked up? I see one that is, there's a line to it, and I see there one isn't. So
this is pictures of the same well, Mr. Freden? Do you see the line hooked up to the well?
I see a picture with a line. I see a picture without a line.
I believe you can see the line going backwards this way. So this is the part that's sticking off.
Looks like a different well to me. I mean, I don't know. I mean, I'm seeing it's maybe it's a different angle.
All right, but my question remains, Mr. Freden.
Anyway, yeah.
At least for the picture on the left, who hooked up the line?
I've had various staff. Again, I can't tell you if the line. I just know it wasn't injecting water because it was impossible for that system to inject water.
And roughly when did they hook up that line?
Like I said, I don't know who hooked up that line for the farmer to make sure it wasn't run over, but that system was put in. So, but it was not put in to inject because it wouldn't work. It had to be turned on and working.
So you don't know an approximate date of when it was hooked up?
It just because it was hooked. Well, I don't know. I don't know. It was not injecting water, is what I testified to.
Yeah, that was my question. I was just asking.
And I think as we've talked about, go ahead. Yeah.
Real quick,
Go ahead.
objection. This question's been asked and answered 5 times now.
And I'm moving on. I just wanted to clarify that Mr. Freden understood my question. Have you applied for an injection permit for this well?
No, we were, like I said, it was designed, the whole field was designed to convert wells. And that's why lines were put in to convert wells as needed and as prepared. So we were in the stages of evaluating wells for permitting.
Was production occurring on this lease on July 13th, 2022?
If the license was valid, it was in production. I don't know if based on license suspensions and dates.
But if the license wasn't suspended, it would have been in production.
Yes.
Okay.
Most likely, to the best of my knowledge, I have 430 wells. So.
All right. The other wells were the Gale Mullen E43, Gale Mullen I43, Mullen I22A, and Underwood 6 are 90 wells. Do you know when any of those lines were hooked up to any of those wells? I don't want to go through every single one of them, so I'm just asking if you know.
Like I said, the lease, I'll repeat my answer again. The lease was completely relayed and set up for converting anything to production or injection. So whether it was hooked up or not, they weren't injecting because they couldn't be injecting.
But you don't know if the lines were hooked up 2 years ago, 3 years ago, 4 years ago?
They weren't injecting, so I don't know.
That
I've
was
answered
my
the question.
No, my question was when were the lines hooked up? Not if they were injecting.
When were the lines hooked up? I have no
Yes.
knowledge of when the lines were hooked up.
Okay. And have you applied for an injection permit for any of those wells?
Those wells, not currently, no.
All right. I'm going to move over to Dwayne Sims's rebuttal testimony. This is Exhibit DS1, page 4, and we've discussed this one before with Mr. Sims. Is this an email that you sent Dwayne Sims on August 17th, 2022, Mr. Freden?
Yes.
All right. And in the email, do you claim that the Mullen I-22A well is an authorized injection well?
I do.
All right. And why weren't you injecting into this well if you thought it was authorized to inject into?
I do believe this is an authorized, to this day, I do believe this is an authorized injection well since the day I drilled it. It
Right,
was in Kohler. Yeah, go ahead. Sorry.
I was just going to ask, so were you injecting fluids into this well?
Again, if that's what was said, it's an authorized injection well.
So you were injecting fluids into the well?
Again, I don't know that day. I don't know, but if it's an authorized injection well, then does it? It might have been.
All right, but Mr. Freden, you just testified that none of these wells, including the Mullen I-22A well, you've applied for a permit to inject into, correct?
I drilled that well, and it was my understanding, and this is what we discussed, is that it was permitted when I drilled it, and it was my understanding, and to this day, it's my understanding that it was an EOR well, and nobody has told me since 7 years. KCC has been on that lease, has approved my inventory. Not one person has ever told me a problem until Dwayne Sims happened to mention that. So I'll say that it's an authorized injection well. In Kohler, it's an authorized injection well.
Do you have a permit for that well?
I was never asked for a permit.
Do you have one?
KCC is responsible for that, as far as I was told.
So you don't keep records of your permits?
No, I don't. KCC does.
All right, let's move on to, let's see, docket 23.
But I've had 8 years of inspections, and nobody has ever, inventories that are submitted. That well was drilled and approved by Troy Russell himself, and he was involved in that because we had to drill it twice. Nobody have ever said anything. So I don't know if I'm making a mistake. I need to be told. So we do make mistakes, as we've all seen.
Who do you think is responsible for knowing whether they can inject into a well or not? The operator or the KCC?
The KCC's job is to help operators and inform them if they have an EOR in their inventory for 7 years and drilled a well, and if there needs to be a permit. No one's ever told me that. I drilled the well. And if it's in Kohler and nobody ever says anything, and after 100 lease inspections, it was my assumption. So if I'm wrong, then fine. But is it a $10,000 fine? No, we all have errors, and but after my leases have been inspected 100 times and have had years worth of submitted reports, nobody said anything, and it's a drilled well, it's permitted as an injector, it's on my inventory as an EOR, and I don't have permits. No, I don't keep copies of it. The KCC does. So if no one says anything until I'm under harassment, then I can change when I'm told.
So just as long as you think it's okay to inject into a well and no one tells you no?
To my knowledge,
like you
on my inventory. Okay, I'll answer that. To my knowledge, and to this day, I drilled drilled the well. It was permitted as an injector. The KCC approved it. They approved the drilling. Everything was approved. This well has been on my inventory. KCC has been all over my leases and has never said a word.
We can
I'm
move on.
only in the wrong. How am I supposed to interpret? It's not my job to interpret the law.
Is it your job to comply with the law, Mr. Freden?
Yeah, it's my job to comply with the law, and the KCC for years has been helpful as a resource to help us comply and not punish us. They've worked with us, and usually, oh, can you go ahead and fix this? Update your inventory, get a permit for this, instead of slashing me with huge penalties. It's a paperwork error as far as I'm concerned.
Wouldn't injecting into a well that is unauthorized to inject into be not complying with the law?
No, actually, because it was drilled as an injector and I was told it was, and I've never been told otherwise. So I would say it's an oversight on KCC compliance.
So KCC, I'm going to drop this because I don't think this is a productive line of questioning. Let's move on to docket 23-3135. That is the docket concerning unauthorized injection or inaccurate U3C. Is that your understanding of the docket, Mr. Freden, of the penalty order?
Oh, let's see here. Oh, the Grundy B. Oh, yes. Okay.
And this is what we talked about with Todd Bryant earlier today,
Yes.
if you recall.
Mm-hmm.
All right, so I'm going to go down to Exhibit A in the penalty order. And is this the annual reports, the U3C for the Grundy B number 5 SWD well?
This is the report, correct?
All right, and did you submit this report?
Yes. Mm-hmm.
Okay. Where you put maximum authorized injection pressure 600 psi, is that correct?
Yes, and I pulled that information off of every single report I've submitted for the past 8 years, and from my recent MIT, that I rely on the information from my hired team that does MITs every single day, and it was signed off on the KCC for 8 years. So I'm not an expert in PSI pressures on a well that has on natural pressure anyway.
So you're testifying that you believe that this well is permitted to inject at 600 psi?
I believe that it was, to the best of my knowledge, I submitted just like I have every single year, and I submit 92, and this was submitted, approved, and it was approved at this, and I even double checked it when it was brought to my attention. I looked at my recent MIT on this, which was done, I think, in November, and I double checked the numbers. They do this every day. They were with your staff out there. They inputted the numbers. I even called your team. Nobody had any knowledge of what the right number is to put in here. I don't know this information, and they said it wasn't even that big. I don't know what to put on there. I've never had this question brought to my attention, and I was told that it's a paperwork error and it's not that big of a deal. So it said on the letter that was sent to me, if I don't have anything to change, don't worry about it. So I went back to all my paperwork, and I felt that it was another attempt at, to be honest, at nitpicking me and harassing me off a minor paperwork error that I tried to work with the KCC and ask them for guidance, but nobody could provide me. I only had to go on the 8 reports that were previously approved and my MIT that Jackie Windish worked with your team to approve on. I don't know what else to do.
Okay.
Does that answer
so
your
if
question?
I'm understanding your testimony, it does. Thank you. I appreciate that. So if I'm understanding your testimony correctly, Mr. Freden, you went back and looked at your old records, and you felt that everything in this U3C report that you filed is correct?
No, on this specific well, when I was notified, I don't know, I don't have records. And actually, I called, and the person that the phone number, she had no idea. She said she was unaware. She called the person. They had no idea. Nobody seemed to have an idea on what that number is for this well. And then I found out it's on natural injection, and then there was no real number. She said there really isn't a specific number, that they couldn't find the permit. I mean, Jackie, I go off of what Jackie and your team, if they agreed on the number, they're out there doing the MITs, they submit the forms, it's approved. I hire them and pay them a lot of money to do this. I have to go off of the data that I hire people to do. And yes, it's an assumption that, and then if forms need to be updated, they get updated all the time. And that's common practice in this business.
All right. Did you see Mr. Bryant's testimony this morning?
Yes,
Todd
yes, I did.
Bryant. Yeah, and when he testified that the permit states that the injection pressure should be 0 psi, do you agree with him that the permit states that it should be 0 psi?
Well, I wish I could have been forwarded to him, the 3 people that I talked to, and I made a real strong effort to try to update the information. In the letter, it said to make an effort. I did. I looked at the MIT, I looked at all the reports, and you're the first person, because the letter came from you, I think, that brought this minor, well, maybe it's not minor, but to me, it's a fact that I didn't have the paperwork. The office did not have the paperwork, that I could have changed it right there. What else am I supposed to do? I can't, I'm not to call Todd Bryant. I would have called him if they would have told me to call him. April, or whoever the girl is at the office, I did what I was told.
All right. So to clarify, the maximum fluid pressure, where you listed it as 100, is that the pressure that you injected fluids?
Whatever's on there was approved, and it was based off of years and years of approvals. So if that's the right pressure, and it wasn't, again, I go off of guidance from your teams. So if that's, I have 92 wells, 92 injectors. So it's never been questioned.
And you believe it's still accurate to this day?
Again, it hasn't been brought up as, on all my reporting, and I've updated things over the years. She calls back, the woman that does it, I know her. Oh, please update this, please update that. It's not a big deal. There's ongoing updates throughout the year. That's common practice, especially with someone. I have more wells than most operators in Kansas, and I'm very proud of the fact that actually most of my wells are in compliance, and I think I do a pretty good job, since I do it myself, and in terms of the paperwork, and it's been challenging, but I try to do to the best of my ability. And in this case, I think I've demonstrated that I made an extreme effort to try. So
okay, we can move on. And actually, what you brought up is my next question for you. So looking at page 2, lines 20 through 23, you indicate that Ace Energy has always engaged and employed full-time staff or contractors, such as pumpers, roustabouts, production superintendents, to keep the leases pumping safe, compliant. How many individuals currently work for Ace Energy?
Right now, I don't have any full-time, just contractors that might be available or third-party vendors if I call, but I'm currently out of business, frankly.
All right. And before your license was suspended, how many individuals did you have working for Ace Energy?
What time frame?
Last year at this time, how many individuals
I had individuals working for me up until May. And I decided I said I had 3 or 4 individuals. Hello?
Can you hear me?
I hear both of you, if that helps. I think you may have just been speaking over each other.
Well, it looks like Mr. Freden can't hear us.
Mr. Freden, did your earbuds perhaps die, or You are not shown as muted. Can you give me a thumbs up if you can hear me? All right, we're going to go off the record right now. And we're going to try to get Mr. Freden's audio fixed. I don't know if IT has any ideas here.
Hello? Hello?
Oh, we've got you back, Mr. Freden.
All right, yeah, my earphones went, or my ear pods. All right, let me just get back on Zoom then.
Okay.
Oh,
And you
sorry.
can hear us?
I can hear you, I just can't see you. So here, let me get back on. All right, come on.
It's all right. Mr. Freden, we've gone off the record, so take all the time you need.
All right. Oh, it's just I'm having trouble here. I don't know why it's. Hmm.
Mr. Freden, if we can see you on
Yeah,
our
I'm
Zoom.
having, oh, you can see me? I don't know
Yeah.
why. You can see me?
We can see
the
you.
Oh,
You're
here
in
we
the
go.
Zoom.
All right. Yeah, I'm sorry. It was a browser. Okay.
Ah, okay,
All right.
very good. So you're
Okay.
ready to go?
I'm ready to go. Yeah, I know
Okay.
your phones. That's fine.
Okay, very good. Well, we are now back on the record, and I don't
Okay.
quite remember where we left off. Maybe Mr. Kimbrell, could you repeat your last question?
Sure. Mr. Frieden, my last question was on November 28th, 2022, when you applied to renew your license. How many individuals did you have working for Ace Energy?
Because I think I had one, because I lost two, and I had three. Again, because it was a very dicey period for me. So I think I had one kind of full-time contractor because I just lost two others. So
Do you think that having one employee is enough to manage 400 wells?
no. I mean, you said at that specific time, and then I quickly tried to bring on some more people, but I had lost people because they quit in October because they were harassed and told them, the staff told them to leave. So it was a short period of time that you asked specific, that's why I said, what date?
All right, well, that actually takes me to my next question. So moving down to page 3, line 21 through 24 of your testimony, you stated that on multiple occasions, Ryan Dooling and Dwayne Sims have told me and representatives of Ace Energy in no uncertain terms that they want Ace Energy's license revoked, Ace Energy prohibited, and they think that you should personally be out of business. On what dates, let's start with Ryan Dooling. On what dates did Ryan Dooling make those statements to you?
Okay. Yeah, let's get into details on that. I've had numerous threatening calls from Dooling.
Describe
Statements
it.
about, yeah, well, I have detailed dates. Let me just look at my notes. When discussing the DR Nelson V2 well, around the time of, looks like my date was 5/13 on about on a phone call with Dooling. We had a discussion about the fact that that well was valid, and it was it had recently been MIT'd, and that an injection well doesn't have to be TA'd, and it was active, and we had a heated discussion about that. And I had just MIT'd that, and he was making up his own opinions on it. He said, well, it was completely equipped. It had lead line out there. He said, well, it wasn't connected, blah, blah, blah. And he was disagreeing with me, making up excuses. And then he got extremely confrontational and threatened me, saying I didn't need to be there, didn't need to be in business, that I had, that I was a pariah, and I didn't know what I was talking about, and he knew all the regulations, and how dare I how dare I cause a problem for him. So that's one. And you're
Let me
talking
ask about that. This screen, let
Okay.
me stop you there and let me ask you. So this was by phone?
This was
All
a
of
phone
these
conversation. Yeah.
Right. So
Yes.
you don't have any email evidence of him saying any of those things?
No, of course not.
You don't have any
No, he
text
provides
messages
that.
of him? You don't have any text messages? All right. Do you have any written evidence showing that Mr. Dooley made any of those statements?
Yes, I do.
He said that he talked to him on the phone. I think that answers the question.
Well, I believe Mr. Freden just said he has some written correspondence. I'd let
No,
him
this
answer.
is my
to whatever.
notes that were made after these notes I kept for the past 2 years of my interactions with staff and the various harassments that I've had. And you asked, I'm telling you. So
Very good.
you want me to continue?
And so for any of these various harassments, instead of going through every single one of them, were any of them by email?
Well, I'd like to go through every single one of them because you asked.
No, I'm asking you now. For every single one of them, are any of those by email?
Oh, I believe he's entitled to answer the question completely if it is asked.
Yeah, sure. I think can continue with your answer, although I think we may have gotten through the answer of what specifically was asked. I think he asked the dates. But if you'd like to briefly continue with your answer, I want to make sure people are able to give a full contextual answer. But I think we're probably getting to the end of this.
Well, you
line of
asked me for
questioning.
details, and these are notes. Just being completely honest, these
Sure.
are detailed notes that I've kept over the past 2 years to provide my legal counsel and to refresh my memory of the harassment and the negative interactions, and that are the core of my case, of proof of harassment. So, I mean, I didn't write these yesterday, so. That was that time, and then we had that discussion about that well, and then in looking for the exact date here, we talked about the Borst conversations, and then the lack of her. She denied the conversation, but yet we haven't been. Well, anyway, about that. That I was harassed on that call, that I wasn't able to get a hold of anyone, and Mr. Dooling was on vacation, and Mr. Russell.
I'm going to stop there, Mr. Freden. I didn't ask about Ms. Borst. I simply asked about dates.
Okay. All right. So 6/22, Dooling was on vacation from 6/15 to July 4th. When I got a hold of Mr. Dooling, looks like here I did get a hold of him on, it looks like it's somewhere over that July 4th weekend, or 6/30 is my notes. And he claimed that, and I specifically remember this, we had a discussion about why he didn't take the time to review, why I can't believe that you didn't review this, and why was it sitting in your email box? And blah, blah, blah. He didn't apologize. He didn't feel bad. He was berating me. And his comment was, well, I'm on vacation. Don't you take vacation? I'm allowed to take vacation. And he specifically said that to me. And he basically said, I don't care. And it's not my problem. And again, continued on his harassment of me. So that's 6 between that time period. 7, 8, without notice, dueling legal, suspended ACE's license, and assessed a $10,000 fine. I called him up and to discuss this, and you know, and because my team said that they were out there reviewing, and I said, "What's going on here? You gave us permission to give us some leeway here. I don't care. So, that's your problem. You're basically, again, harassing me, causing problems, and then again, incurring more fines because of him. I think that he was worried about losing his job because because I had this information, and it made him look bad that because he was gone for the month of June. I'll continue.
All right. At this point, so Mr. Freden, we appreciate that. I do think basically what you're telling us, I'm not saying it's irrelevant, but I do think it's basically included in your pre-filed testimony. I think Mr. Kimbrell was just getting at what the dates and form of those communications were. If you have more to add on that, that would be fine. But I think you've basically testified to the content of the conversations as you saw it.
Not all of them. Not all of them. So I'll be briefer if you want. I just thought you wanted as much detail as possible, but there's a significant number of harassment episodes by staff. So, and legal too, but I won't get into that.
Well,
And I just like to state again that I never asked for the form. I simply asked for the dates. This goes well beyond my question. I did not ask for the details.
You didn't ask for the details.
No, I asked for the dates.
Okay, all right.
Well, Mr. Kimbrell, I think you did ask whether it was in writing or whether it was telephone conversation. That's what I was referencing.
Well, okay. Yes, but not the form, or not what was actually included with any of that conversation.
Yeah, as to the content of the conversations, I mean that is detailed and pre-filed. Operator had a chance to say that piece, and I think you basically reiterated what's in your notes. I'm not challenging the accuracy of your notes. I think that's reflected in your pre-filed testimony, but we need to move along. So,
okay. Well, I'm just saying that I have detailed. This is not hearsay. This is I just didn't know how much detail the commission wanted me to get into. It's significant and relevant, and I can just rattle off dates and who and how. Or I can, in content, or how would you like me to proceed?
I think at my recollection of the question, to get us back on course here, my recollection of the question was basically referencing your statements on lines 21 to 24 on page 3, statements about your communications with Mr. Dooling and Mr. Sims, and which dates those conversations took place. Mr. Kimbrell, is that generally correct?
Was my question, yes.
Okay, and then the most significant one, which I would like to discuss and clarify, and well, not clarify, but provide more, is the August 17th conversation. I think that's the right date, based on my emails. I know that Mr. Sims was trying to dodge that, or not dodge, but whatever. I've disputed the date. Regardless, we had a call during that time period, and that one was quite heated, and he did not mention anything. I mean, basically,
Chair French, I'm going to ask that you strike all of this. This goes well beyond the question I asked. I asked about Ryan Dooling and dates.
Okay.
I did not ask any of these questions.
Okay. All right.
I think we got the date there. It was 8/17, correct? And that was with Dwayne Sims.
Dwayne Sims.
Very good. Mr. Kimbrell, you may continue.
Thank you.
I don't know if there's much more on this line.
Yeah, I know. We'll move on.
It was significant interactions with multiple staff members, not just Dooling, and I can continue, but it doesn't sound like Mr. Kimbrell doesn't. I'm
All right, moving on to your testimony, page 3, line 26. And then page 4, line 6 through 9.
Yes,
You talk about certain statements that you claim Ryan Dooling and Dwayne Sims made to individuals working for Ace Energy. Were you present when any of those supposed statements were made?
I was in the area, yes.
You were there and heard the statements made by Ryan Dooling or Dwayne
I
Sims?
was told right after I was not there, but I was told right after because they quit.
So you were told afterwards what Ryan Dooling
I
and Dwayne
saw
Sims
them
supposedly said?
discussing it. No, I saw them just talking to the KCC guys, and then they quit. My 2 guys quit because the KCC guys told them I was losing my license and that that they needed to find jobs somewhere else to be in their best interest. So the guys quit right then and there on the spot.
Mm. But you only saw, you didn't hear anything.
Well, I think it's pretty apparent when someone quits, and I trust their opinion why. So I answered that question. I was right there.
All right.
I saw them
And-
talk.
And I believe you said that this was face-to-face communication between.
It was face to face.
All right. And who were the individuals who heard Ryan Dooling and Dwayne Sims say this?
Dwayne Lansdowne and David Gumphrey.
All right.
I'm not. It was other KCC people too, and it was not just that occasion, but that was the final straw.
All right. It was, you said Dwayne Lounston
Sitting out
and
there
who
with
else?
pickup trucks, and they told me, oh, it was they said that KCC staff, they told me that they were sitting out there for weeks watching them in their white pickup trucks, and they were harassing them on a daily basis, just sitting there watching them. And this was not the first time that they told them that they had problems with Ace and they should find other jobs. But this was the last straw because they said my deadline was coming up, and that staff had told them they better find another job because I was losing my license.
And you didn't hear any of these statements either, though.
I didn't hear any of these statements.
You didn't personally hear those statements made by anyone on KCC staff.
No, they weren't going to berate me in person. They quit right away instead.
All right. And you said it was Dwayne Lounston and who?
Probably, excuse me?
Dwayne Lounston and who?
David Gumphrey.
And is Dwayne Lounston going to be testifying today?
No,
Is David Gumphrey going to be testifying today?
no.
So no one who
my
supposedly heard
knowledge.
these statements is going to be testifying.
It's in my testimony, and I'm talking about it today. Their actions.
But no one who
Asked
actually
about my
heard
team.
these supposed statements is going to be testifying.
I don't think it matters about hearing. Direct consequences, and I saw it.
But you didn't hear it.
They were talking to the KCC, and they quit afterwards, and they told me why.
May I lodge an objection? These questions have been asked and answered. I understand that it's trying to build some case of hearsay, but the rule in hearsay in Kansas, if the party who witnessed it is available for cross-examination, it's admissible. And so here we are.
So I'll sustain the objection on the asked and answered basis. I think the questions about hearsay were viable and in the sense that they go to the weight the commission may want to give those statements. But as far as additional questions along the line of what Mr. Freden heard or didn't hear, I do believe it's been asked and answered.
Okay, I'll move on. Mr. Freden, do you see the Ace Energy license renewal application submitted on November 28th, 2022 on your screen?
Yeah.
Okay. And this is Nancy Boer's testimony, exhibit NB1. Panning down where it says representatives. Do you see where it says James Lane is listed as a member of Ace Energy?
Yeah, I see that on there.
All right. Who is James Lane?
That is an old, not to my knowledge, I don't know who that person is. So
Is he a member of Ace
I
Energy?
no, not a member of Ace Energy.
So a random
That's
person's
that's
name.
an error.
Did you submit this license application, Mr. Freden?
I don't know if this is, I mean, I don't think this is the form that I submitted most recently.
So where it says here, November 28th, 2022, submitted by Jonathan Freden, is this the most recent license renewal application for Ace Energy?
Correct, but I am the only member of Ace Energy, so I don't know why James Lane would be on there. So I don't know if this is a system generated thing. I don't know. So I'm just letting you know I'm the only member.
When you submitted this license application, did you have to click a button saying that you are submitting a true form?
Yes, and it also shows my phone number is 773-209-8602, and that's not hasn't been my phone number for 3 years, so, or 4 years. So I didn't generate this.
Did you update your phone number last time you submitted a license renewal application?
Yes, my phone number has been updated in Kohler, so I did not create this form. So I don't know who created
Even though it says it was submitted by you, your testimony is that you did not submit this form.
Why would I submit my old phone number? I think
Ms.
Nancy
Freden, I'm
did.
asking, Ms. Freden, I'm asking who James Lane is. Is he a member of Ace Energy?
James Lane is not a member of Ace Energy. I submitted that I was the only member. I don't know who did this. If you pull the old information, it says on here that I'm a well plugging. I'm not a well plugging. I mean, I don't know where you're getting this information. I didn't submit this. So I'm just being honest. Why would I put in my
Fire? Do you know who Prairie Fire Innovations LLC is?
I have some knowledge of it. Yeah.
Who are they?
Who are they? It's a LLC that I'm aware of.
Are you a member of Prairie Fire Innovations?
No.
And does Prairie Fire Innovations have any stake in Ace Energy?
Nope. No. As I've stated in my testimony, I am the only member of Ace Energy, always have been. Look on the state rolls. Again, I don't know. This is a form. This is Nancy Borst. Again, my phone number is wrong. It hasn't been that phone number. Again, I did not do this.
So
why would I submit
when you were submitting
the
your
correct
license
phone number? Okay, real quick. The correct phone number is up here, 913-963. So why would that phone number be correct and this phone number down here be wrong?
Is it possible, Mr. Freden, that you just forgot to update the representative side when you were submitting this application?
No, I think Nancy didn't update it. That's a Nancy generated field. So
is Nancy Borst's job requirements? You wouldn't know. I retract the question. Has James Lane or Prairie Fire Innovations ever been a member of Ace Energy?
I don't recall.
You don't recall if they've ever been a member of Ace Energy?
No, Ace Energy has always been, there might have been 1 year that for privacy reasons, I don't have it in front of me, but legally, Ace Energy, I've only been the member of Ace Energy. So for privacy reasons, again, sometimes I put various information, but legally, but yeah, so no, I'm only the member.
I guess I'm not following you. Can you explain what you mean by for privacy reasons you put other information?
No, I'm saying like on Facebook, I use various, I've only, Ace Energy is, I am the only member. I've only been the member always. So this is incorrect information.
What have you put on Facebook?
No. For privacy, it has nothing to do with. Yeah, I'm just using an example for privacy reasons. I mean, it has nothing to do with you. Yeah, it has nothing to do with anything.
And I just note that this question's also been asked and answered about 3 times now. He's testified that he's the only member and that this form is incorrect.
Well, I'm trying to move on to new question on exactly what he means by putting new individuals down for privacy matters.
Yeah,
I'm just trying to understand this.
I'll sustain the objection as to whether this is the information he believed he submitted. That's been asked and answered. And whether he is the sole member, that's been asked and answered. But I agree, that does appear we've moved on to a new line of questioning now. So, Mr. Kimbrell, you can continue.
So when you list Ace Energy on Facebook, who do you list as the owner?
Ace Energy is not on Facebook.
Oh, then what were you talking about on Facebook?
Oh, I just was saying in general, for privacy reasons, I don't go on Facebook. I don't want my identity out there at all. So that's all I'm saying is I don't like having my information out there. That's all I'm saying.
So you use a pseudonym when you go on Facebook? Is that what you were talking about for privacy reasons?
Yeah, that's what I'm saying. Yeah, it has nothing to do with. I'm just saying, has nothing to do with this. I'm just saying, I don't like my personal information being out there. So.
And what pseudonym do you use?
How is that relevant here?
Well, if it relates to any of these other individuals who,
nothing, it's not James Lane's. So if that's what you're getting at. So it's not for privacy reasons, I'm not going to discuss that.
Chair French, I would ask that Mr. Freden answer the question.
I'm having difficulty seeing the relevance of that question, but perhaps you could make a proper of where you're going with this, Mr. Kimbrell.
Well, we're going to be talking a little bit about XX54 and other individuals who are associated with other licenses. And so if any of those individuals are the name that he uses as a pseudonym, then I think that would be very relevant.
All right, we'll allow a bit farther. As I've said before, I think, this is essentially a bench trial. So we'll let you establish the relevance and then we'll make a determination later on the weight we give to that. So please continue.
All right, so what pseudonym do you use on Facebook?
Freedom Ridge. Thoroughbreds.
Sorry, what was the second one?
Freedom Ridge Thoroughbreds.
Thank you. I'm going to move on now. So this is page 4 of Exhibit RD1. Ryan Dooling testified about this. This is the Allen Hauser #1 well. Is that correct, Mr. Freden?
I can't tell by the picture, but I'll go with you on that.
All right. And do you remember the last time that this well produced any oil or gas?
Not to my knowledge.
So it's never produced?
No, you asked, no, I don't know when the last time, not to my knowledge.
Okay. The KGS records, in the additional finding, it indicates that the KGS records show that no oil has been reported since 2020. Would you agree that this well has not produced since 2020?
Based on the lease, yeah, I'll go with you on that.
All right. And does this well have any surface control?
I can't tell.
I can make it bigger. Do you see any surface control on this well?
I can't tell. It might have something beyond the. Yeah, I can't. Again, all my leases are inspected, and we do what we're told. I've been asked to put surface controls on wells many times, so I only do what I'm told. If this is viewed as a threat, then or an issue, then I can't tell
it's how you define a surface control. I mean, there might have been something on there because I know we cleaned that up. So it might have been on there, taken off. I don't know.
Okay. So you testified that
I'm
this
not-
well likely hasn't produced since at least 2020. Does that mean this well is out of compliance with KAR 823111?
What do you mean out of compliance? Does it need a TA submitted?
Yes.
Probably.
So
Yeah,
it
needs a
needs a
TA.
TA.
Probably. I would agree.
All right.
Yeah, I would agree. It needs a TA submitted. Yeah.
On November 28th, 2022, did it need a TA submitted?
On my inventory was approved for that year, and my application didn't mention this. So we submit TAs throughout the year all the time.
But on November
I don't
28th,
view that submitting a TA is not necessarily we submit TAs all the time. That's not a violation. We don't submit a TA or not.
Mr. Freden, if a well is out of compliance with KAR 823111, then it is in violation, is it not?
No, we bring wells into compliance. We work on wells. This one, I think it might have had a pump jack on it. I don't know, but I don't think any producer would be in business if you went through every lease and said that they needed a TA well. So
I'm sorry, I guess I didn't quite.
Everyone has wells that need to be TA that aren't. If under what your inspections show on mine, I can go on every single lease and I'll find a well that needs to be TA and you wouldn't have any production in Kansas, according to 83-111. So it's interpretation. Right. Just being completely honest.
Okay. So how many of your wells are currently out of compliance with 82-3111?
Well, we've had lease inspections for 10 years. I've had my license renewed for 10 years. We have probably in District 3 more interaction with staff, and they look at our leases, and again, they interpret and they tell us this is part of the issue, is that everyone has their own opinion of what a TA is or TA isn't, but they've never had what we're told, and we put TAs in when we're told that we need to. So when my license was submitted, it was submitted until you stopped it. I mean, to be honest, according to Ms. Boris' email.
So looking at 82-3111, Part A, where it says, within 90 days after operations cease on any well drilled for the purpose of exploration, discovery, service, or production of oil, gas, or other minerals, the operator of that well should perform either the following: plug the well or file an application with the Conservation Division requesting temporary abandonment authority. Did I read that correctly?
That's what it says, correct.
All right. So does 82-3111 specifically say within 90 days after operation cease, you have to take action?
Staff has always worked with us because they spend more time helping us, in the past at least, instead of spending time wasting money and time on these type of proceedings. We work to try to get everything in compliance and get wells back into compliance and to avoid situations like this. My wells, as of this submission of this license, were all in compliance according to the staff inspections. You can take it up with them if I go off of what staff tells me and what my team tells me in my inventory reports. So
do you think an operator has
never been on my leases? Mr. Dooling has never been on my leases. You have very few staff. And again, I would hold you to inspect everyone's leases, and you're going to have everyone out of business. If you hold everyone to this same standard that you're holding to me, you're not going to have any operators in Kansas operating. So just be honest. This is a fluid law.
So that 90 days, you feel like that's something that is fluid that you don't necessarily need to abide by? Is that what you're saying?
No, staff has worked with us in the past, and they've been very helpful up until recently, up until these harassment issues. Staff tells us, oh, put a swedge. I mean, I have emails to support that. They don't waste time with penalties. They haven't until the last 2 years with staff changeovers. They view the best resources, instead of finding people, are making sure that things are, you put a swedge on it, put a TA in, it's fine. What, you don't go through and regulate people to death. I mean, over every single well, I did not have any issues, not one well that needed to be plugged, not one issue. And I challenge you to go on any operator and find any compliance. And again, we question over 150 of these allegations that aren't even valid. Just
Okay.
being completely honest, not argumentative. We challenge the validity after your teams have inspected my leases for 10 years, and I've had more inspections and more staff time all over my leases. Russell Hines, everyone has been all over my leases, and this is the first time I'm hearing that my wells need to be TA'd. Or have swedge issues, or take it up with them. Just being honest. When you got
deviate a bit.
Okay, all right.
So this is Staff's Exhibit 5, which we've talked about several times already. Are these penalty violations that go back all the way to 2015?
Yeah, I've been in business for over 10 years.
So this wasn't something that just started recently, you receiving penalty orders. You've been receiving penalty orders since you basically started business, correct?
I'd say over a 10-year period and many of these, and I mean, not to diminish a penalty, most of them have been challenged, but the large one on there from 2016 was former employees that went out and turned on all my injectors and called in a violation that was vandalism. Most of these other ones were when you guys were switching over to Kohler, and we had, I'm not going to blame anyone, but there were paperwork errors. Again, I paid, they were relatively minor, and I take every issue seriously. I paid, but overall, I don't view these as, again, for the amount of paperwork. And when Kohler was turned over, you guys had the wrong email address, the wrong address, and you still have the wrong phone number, I think. I wasn't getting information. Your MIT system was not recently, I mean, this is just, to be completely honest, your MIT system did not notify operators digitally. It was a once a year thing. And that caused, as you can see, a lot of my MITs that were late because I didn't get proper notifications. So if you remove the paperwork, again, not diminishing the fact that they are violations, I paid them, but over a 10-year period, removing the paperwork and also removing all of the harassment since the past 3 years, I'd say that my record has been pretty good. For the number of wells I have, and but I'd say the last from 2019 or 18 on, everything has been a harassment from staff, and staff has caused, just being completely honest, the pattern there is very apparent.
All right, let's move on, Mr. Freden. Is this a picture of the Beechner number 8A well?
It says McCune up there. It doesn't say Beechner.
McCune, Kansas.
And I don't think that it doesn't look like the Beechner well. So,
any idea what well this is?
not to my knowledge.
Is this an Ace Energy well?
It's an Ace Energy well. Well, I mean, possibly, yeah.
Okay.
Fine. I'll go with you on this.
All right. And was this well in compliance with 82.3.111 on November 28th, 2022?
This picture was taken as part of your, with all due respect, minesweeping operation. So I would say yes, that this happened way after, and yes, it was in compliance. So this absolutely was 3 or 4 months past and that lease was recently redone, and I had work done, and I disagree with you. So I'm going to say yes, it was in compliance. This was part of your minesweeping operation. So
on November 28th, it was in 2022 is in compliance, and by January 23rd.
To the best
And
of
what-
my knowledge, this well was in compliance as far as every well was in compliance because my application was approved until you stopped it.
All right. And so then by January 23rd is when this, over that period of time, is when the well came to be in this condition, is what you're testifying.
Well, I don't know. I don't know if you consider that. I mean, is there something? Yeah, there's some frost on the ground. I mean, I don't know. I mean, we're here talking about my license, not the mine sweep. So,
All right. That doesn't look like oil on the ground to you?
it looks like some oil within 3 feet. I've never been told by staff there's a problem there, or my landowner, who I'm in constant contact with. We, as you can see, there's pipe. We were working on pulling the well because I know we were putting the lease back into production. And oil does come up from a well when you are working on a well. So I'd say we were working on it, which I know we were at that time.
All right. And did you report the spill to staff or the landowner?
That's not a spill. We're working on the well. As you can see, pipe is on a rack. We're working on a well, and the oil comes up when you're working on a well and putting it back into production. So next question, please.
Mr. Freden, I'll decide when to move on to the next question. Thank you. Moving on to the next question. This is the proposed settlement agreement that your attorney sent. And I just wanted to bring your attention to this sentence where it says, we estimated there are approximately 300 wells at issue. So is this admitting that there are 300 wells that are out of compliance with commission regulations?
No, we discussed
Yeah,
this.
hold on. This is actually what this particular evidentiary rule is for, is admissions of liability. And that kind of question can't come in. I'd also note that it mischaracterizes this particular email as based on the opening paragraph, but this is exactly the kinds of reasons why it's not admissible for that purpose.
Well, I think if Mr. Schlatt's been able to bring it into the hearing and try and use it to discredit several staff members, then
because it says at the very top that we're going to take that as gospel and not dispute it.
I'm sorry, can you restate that, Mr. Schlatter?
The email at the top, we're basically conceding this point with Mr. Dooling says, so we're not acknowledging that it's factually true. And you can see that in the very first paragraph.
Okay, so two things. I'm going to allow the question because this was a document that Mr. Schlatter introduced, but your point is taken, Mr. Schlatter, and your witness is free to incorporate that into his answer.
all right. So to repeat my question, Mr. Freden, where it says here that there are approximately 300 wells at issue, were there 300 wells out of compliance when this email was sent?
No. As I've already stated, that we are disputing that a vast majority of your wells, many of which aren't even on my license and is not legal to even, we never even had a chance to respond to them. They were not given as violations. This document was a good faith effort, a very good faith effort on my part. And from my knowledge, you agreed actually, and you thought it was a good idea. And Mr. Russell was the one that did not, from his own testimony.
Yeah, I do not believe that was Mr. Testimony. That was the testimony of Mr. Russell.
You told my counsel that
Mr.
you
Freden,
were in favor of settlement.
Mr. Freden, that's not relevant.
Okay. Okay. Well, let me answer your question though. So we acknowledge that you brought to our attention, you went through every single well on my lease, every single well, and then found 50 or 60 wells that weren't even on my leases. You found or inferred that were leases that didn't have power, brought up a whole bunch of issues. And we basically said, you know what, because of so much money that's been spent, so much time, I want to put an end to this. I talked to my counsel about that. We will look at every single thing they bring to us. And because it was ours, we looked at the pictures, we read everything, and most of it was swedges and paperwork and not one well of being plugged. And I felt actually that it was a pretty clean bill of health in terms of going through. I'd like every operator to go through that. And I don't think that anyone would have that type of and then actually we would beg to differ in terms of the opinions of being out of compliance. We've had multiple inspections as of even recently that staff has told us that the wells that you mentioned were not in compliance were in compliance. So our commitment was to look at every single well that you brought up and to bring everything into compliance, but in a mutually beneficial way, that we wanted it fair and to not be mistreated like we've been mistreated before with staff moving the goalposts and Troy Russell and just deciding to interpret the rules as he, for the last 10 years, staff keeps changing. They've been supportive and they've approved everything until recently that staff just decides to interpret as Ryan Dooling and these people without experience, at least the interpretations of the law. Because again, every single year my license was approved without any problems. My 400 wells were approved in the UC3 without any problems. We've had very strenuous approvals, and yet all of a sudden 300 wells. I'd ask the question is, where are your staff been for the last 10 years? But we committed to not the number, we committed to looking at every single well of mine. And I even said we could probably address most of these issues with surface controls, which were already brought to our attention from staff and my Thayer leases had already told us. And whenever they tell us to put surface controls on, we do everything that's been told of us. And that's why it was our intention to bring this agreement. You did not bring this agreement to us. And I appreciate your effort, your good faith effort to work with us on this. I'm disappointed that staff would rather spend the time and money of potentially putting me out of business and plugging wells and wasting the taxpayer money, but I do appreciate your effort.
All right, Mr. Freden, several different questions. First off, you said that you put on surface control whenever you're asked. Have you put surface control on any of your wells since staff filed its pre-filed direct testimony?
We just received this in, I think it was July, and I have a shut-in order and I have no staff left because of my business circumstance, because I've had to spend $200,000 in legal fees. So currently, I've done the best I can to survive and pay my legal bills. So, but previously, for the past 2 years, or whenever actually, but recently, I know for the last time I've been asked, actually I haven't been asked to put on surface controls, but whenever we've been asked, it's also a definition of surface controls that keeps changing. I've looked at a lot of those pictures and showed other people, and they're like, well, a pump jack's on it, a stuffing box is on it. That looks like a surface control to me. So to answer your question, I haven't been able to do a whole lot since I've been shut in.
By being suspended, your license suspended, does that mean you can't go out and make sure that your wells are safe?
I have a shut-in order. I have a responsibility, and I make sure that, but you guys have done everything possible to strip every ounce of money. You've scared away my staff, and I can't get barely anyone to help me because of these circumstances. And when I have to spend $25,000 a month in legal bills, that doesn't leave too much room nor have I been asked by the KCC. So, and your paperwork was submitted, as Troy said, he'd never asked me, I've never been communicated, and I just got that information and I dispute a lot of it. So it's just an exhibit.
So, Mr. Freden, do you have to be asked by staff before you bring a well into compliance?
I've already answered the question.
Mr. Freden, if Is it an operator's duty to remain in compliance with commission regulations, whether they're asked by staff or not?
I've already answered the question. The wells,
I do not
as
believe you
far
have,
as
Mr.
I'm
Freden.
concerned,
Mr. Kimbrell, I
Well-
think you've asked the question several times and
All
we've
right.
gotten the answer you're gonna get.
All right. All right. I will move on. Thank you. So my last set of questions, Mr. Freden. Do you see the license renewal application for XX54 on your screen?
yeah. Mhm.
And does it show that it was submitted on June 18th, 2018?
It was, again, these forms, but yes, it looks like, yes, it was submitted. Uh-huh.
And does the form say that it was submitted by you?
Again, I don't know if it says who it's submitted by, because this is not a form I have access to, but I think I did either Casey Minshew or myself, since I was helping him on this. Do you have where it says who submitted it?
It says right there, submitted, Jonathan Freden.
Okay.
So you do agree that you submitted this document?
Yes, I submitted this on behalf of Casey.
And in submitting this document, did you put yourself as owner of Ace Energy LLC contract op?
I'm the emergency contact because I am the Kansas contact for, obviously I'm the owner of Ace Energy, and I was helping the guys from Dallas out at the time.
Yeah, but under owner, you put owner of Ace Energy LLC contract op.
Yeah, I was helping them out because I was on the ground in Kansas. Yes, correct.
All right. Were you operating
They live in Houston, excuse me. I'll answer the question. They live in Houston. I'm in Kansas. Ace is in Kansas, and Ace was helping them out. So I'm not the owner. I was the operator just like hiring Hurricane.
All right. So Ace Energy was operating XS54 as well?
No. I don't,
Is that
I
what
don't
you just
see
said?
that on here.
Did you
I
just say
said-
that?
I said like Hurricane, a service vendor. I was helping
All
them
right.
out.
So what services did you perform for XS54?
I helped them because I advised them. I gave them guidance as a consultant, just like anyone else, just like Steve Windish with Midwest Services. I was a contract, contract service provider.
All right.
That's what that means.
Okay, I'm going to move now to Staff's Exhibit 3. All right, so this is Staff's Exhibit 3, page 1. And Mr. Freden, is this a transfer of operator form?
T1.
Yes, a T1.
Yeah. Yep.
And is it transferring wells from XX54 to Ace Energy?
Yes.
And is it transferring, what is that? 9 wells?
Yes.
And did you submit this form?
It looks like I did. Yeah.
All right.
Since the new operator is Ace Energy, yes.
Okay. And under past operator, where it lists XX54, did you sign your name?
No.
Does it say Jonathan Freden after signature?
That is there because I had to put something, because I put the form in and they wouldn't accept it without, it's Casey Minshew. And I've seen this on other T1s when sometimes you don't even put a past operator, but I had to put something there. So on behalf of Casey, since I was putting this in, I mean, I've seen T1s with no past operator. So why would I submit a T1 if I for Ace Energy, if SX54, if I'm not an owner, I've already said I wasn't. The state records show that. So
I'm just wondering if you put your name under signature for XX54. And I believe you
my
said yes.
name is there because Casey asked me to submit the form and I needed to put it's not a signature, it's just a name there. So
Right. And under title next to signature, did you put member?
that's Casey, not me.
So having title next to signature and you put member, that means that you weren't the member.
Correct. This is a T1 form. Again, I didn't have to, we didn't have to submit anything for the past operator. I told you that Casey is the owner. The state forms of the LLCs show that. I put that in there because I was the one that signed the form. Casey is the member. Ace Energy is me. It also says below manager, Jonathan Freden. It was probably an error to put my name there, but I'm correcting that right now. So I don't know why I put
so
that
maybe
there.
You're saying maybe it was an error on this T1?
Possibly, yeah. It could have been an old T1, but I'm saying that I'm not the owner.
Okay. And this is Staff's Exhibit 3, page 16. Is this also a T1 that you signed your name on behalf of XX54?
Probably the same form. Yep. A lot of times the forms are just updated. I mean, they're just copied, cut and pasted. Probably it's an error as well.
So you're transferring different wells, but you're saying that it's the same form?
It looks like the same wells to me.
I believe there are 2 SWDs that weren't there before. Is that correct?
Oh, that's a separate page, but
all right. Well, we'll move on to the next one.
Whatever. It's not. I'm telling you that I've never been. I'm not an owner, so I don't really. Whatever it says there, it's incorrect.
And I'm just going through these documents. This is the last one. This is this another T1 for the Holmes well? Sorry, for the Holmes lease. I can go down and show the 4 wells are being transferred. Is that correct?
Yeah. Yeah.
All right. And did you also
shows Casey Mensch's phone number, and that also matches the state records on the LLC ownership. So obviously it's an error.
But you did put your signature and lists member under title.
It's a type. No.
It's what?
No, I said, well, I'm clarifying for the record that that's an error. So I'm telling you that that's wrong. This is not a binding. I mean, it's an error. But the state records, and I've also stated in my testimony, I own Ace Energy. That's it. Never owned SX54. I was Casey and those guys from Houston own that. So why would I transfer? Why would I be the old operator and the new operator?
Did anyone from XX54 look over this form before you submitted it?
I didn't for them. They asked me to. They're not familiar with the form. It was easier for me to do it for them.
So did you decide which wells would be transferred?
No, the wells that are on the lease.
Right, but I mean, did you decide which ones would be transferred from XX54 to ACE?
No.
Who decided that?
SX50, they did. They did.
But they didn't look over this form before you submitted it?
They don't know how to fill out T1s. That's not they're financial people from Texas. I had to do the paperwork. Like I said, as I told you before, ACE was helping them. I was just like a hurricane or an advisor. This is the type of thing that I did for them. I had access to Kohler. They did. I mean, I think they might have, but they were unfamiliar with it. So it was easier for me to help them out. So.
And why did you decide to take some of their wells?
These were wells that we mutually decided ACE took responsibility for, did the right thing. So
Can you expand on that? What do you mean by you did the right thing?
did the right thing to take responsibility for wells that to not have them just out there. So I mean, that's, I think, a nice thing.
So XS 54 was just going to leave all these wells?
That's not, you'd have to ask them. And there was also a bank note tied to these wells that there was a situation that ACE might have been involved in. So I took, ACE took responsibility for them, just these wells.
Well, what do you mean by ACE might have been involved in? What does that mean?
I just answered the question that these wells were tied to a legal dispute that ACE was involved in, and that's all I can get into. So it's privileged information. But you asked, I gave you an answer. ACE was responsible for these wells and needed to take responsibility for them based on otherwise, it's just that's what was decided between the parties.
Was there a legal decision saying that ACE Energy was responsible for these wells?
No, it was a decision, again, based on what's right, the right thing to do, to pay to take responsibility for the loan from the bank. The bank note was tied to just these wells.
Okay. I'm going to stop my questioning there.
That brings you to the conclusion of all your cross-examination, Mr. Kimbrell?
At this point, yes, thank you.
Okay. All right. I think we will then move to commissioner questions. Commissioner Keen, why don't you go ahead?
There. All right, thank you, Chair French. Good afternoon, Mr. Freden.
Afternoon.
I'm going to go in a couple of quite different directions because I'm trying to get an overview of what the heck is going on here. Tell me, if you would, just a little bit about your background and your experience in the oil and gas industry. How'd you come to be involved in this industry?
I decided about 12 years ago to become an oil and gas producer, something that I had been thinking about in Kansas. Got a license in Kansas, but I've since become involved in other areas outside of Kansas and have a breadth and depth of knowledge, geophysical, drilling, been all over the place. So
How did you come?
internationally.
I'm sorry, pardon my interruption. How did you come by that knowledge and experience?
Hands-on and through mentors, people that have decades worth of geophysicists and geologists that I've employed on various projects out in, all throughout. I rely on expertise and then worked with them. I hired them on projects I was on. So learned from them. I'm not saying at all I'm an expert. I know a lot about things, but I've relied on them for mentoring and guidance. But I have detailed experience in oil and gas and significant background in business and data mining, reporting. I have a government background. I've been a commissioner myself in Kansas. I was appointed by the governor. So I have a lot more experience than what was discussed in this.
What sort of commissioner were you?
I was appointed to the Kansas Children's Cabinet.
Okay. Well, the reason I'm asking is how far back did this other experience really go, Mr. Freden? You've indicated, I'm looking here at page 2 of your pre-filed testimony, and it indicates that you founded ACE in 2010. Is that correct?
The LLC ACE, but my experience predates that. I've done other things besides in Kansas.
How far back does the relevant oil and gas experience go back? How far back does it predate this?
Probably 6 years prior to that.
Okay. And it says here in your pre-filed testimony that you founded ACE Energy LLC as an energy investment company. What in the world is an energy investment company? I'm not familiar with that term.
Ace Energy's, again, I have different LLCs and there's been various partnerships and promotes and different deals. As you're a business owner, as you know, there are multiple, obviously throughout my career, been involved in various partnerships and those partnerships. I mean, Ace Energy is the general term of who it's hard to.
Okay, but what is that? What is the energy investment company? What do you mean by that specifically? What does that mean?
What I mean by that is raising capital and engaging in exploration.
Okay.
And engaging in international oil and gas trading and other things that I'm not able to discuss on this call.
Well, all I'm asking you to do is to answer my questions. I'm not
Okay,
gonna,
you asked.
I'm not gonna go beyond
it. I'm a producer, and I'm also heavily engaged in oil and gas development, trading, research, analysis, drilling, contract negotiations, international trade, probably every aspect of, and with other people. To say that, does that answer your question?
I got it. How extensive would you say your experience is with respect to just oil and gas production?
Very extensive. I'm not going to say I'm a 30-year veteran, but I've been, due to considering that most producers in Kansas, at least the ones I know, only know Kansas. I've drilled in Kentucky. I've drilled in other places. I have experience in Pakistan. I have not that I'm an expert, but I do have extensive knowledge of other zones, other areas, other experiences than, not to toot my own horn, but I do have experience.
Does Ace Energy own oil and gas leases other than in Kansas?
Ace Energy does not own leases. Ace Energy is an
operator?
Ace Energy is an operator.
Ace Energy LLC doesn't own any leases. Are you saying that?
Ace Energy LLC does not own any leases.
How do you own wells without owning leases?
How do you own wells and not
I don't think it's possible within the industry to own wells without having leases that are associated with. What gives you the right? It's the lease. It's the lease through which the lease is the contract through which you are able to go in and extract oil and gas.
Ace Energy holds a license to operate in Kansas. That's it.
How did you?
How are your leases held, Mr. Keene?
My leases are held in a blind trust, and it isn't relevant to this matter at all.
Okay, then my leases are held by.
My next question to you, Mr. Freden, is this: how did you familiarize yourself with the KCC statutes, rules, and regulations that govern oil and gas operations and activities in Kansas? How did you go about familiarizing yourself with these rules?
I rely on the guidance of staff, and they've been very helpful over the past 10 years up until recently. And I also rely on the wonderful people that I've had up until recently work for me, and I've had no problems up until recently.
Okay, you've referred several times in conjunction with the examination by Mr. Kimbrell with respect to what you've talked about your team and your staff. So I'm going to have to ask the question again: who is your staff? Who is your team? How many people comprise your team and your staff?
I've been in business for 10 years. I've outsourced my operations for the most part.
You mean you use third-party contractors?
I have third-party pumpers, third-party contractors. I've had employees over the time, but for the most part, I am remote and I operate through third-party service providers. Yes, as do a lot of operators.
Okay. Who oversees the day-to-day operations of your field operations?
I've been in business for 10 years, so it depends on what time period.
Right now,
Right now, I'm shut in, so nothing is active.
when you were active, how many pumpers did you engage?
I wasn't, again, I've had various levels of pumpers. It depends on our operations. I've had 3 pumpers, I've had 6 pumpers. Again, I've been in business for 10 years. So again, I've outsourced my day-to-day operations to a third party. So.
Okay, do those third parties report back to you? Do they provide periodic reports back to you?
Correct.
Did you say yes?
I said correct.
How familiar are you personally with your individual well operations in the field?
Let's just say that I am a hands-on owner. So I know, I'm hands-on in terms of I'm not some investor that doesn't talk to, I pay the bills, I understand what's going on. I have to rely on daily, numerous times a day. I'm on call 24 hours a day. I have to rely on, I live in Leawood, Kansas. I have to rely on field staff, but I am intimately familiar with, because of my background and knowledge, I know to the best of my knowledge, again, I don't live there. If I lived there, I'd be on the leases every day, but I'm not. I have to rely on my paid contractors to provide me the information that I have on a daily basis. And sometimes it's ongoing.
Okay. How frequently are you out in the field observing the operations of your wells?
Again, it varies over the 10 years I've been in operations. I mean, since I've had very good, for the most part, I've had very good oversight. And we've had very good relations with field staff up until recently. And I've been in touch with that person. I talk to him 5 or 6 times a day. So with texts and phone calls, and I didn't need to be down every week because he was all over it. So.
Again, I'm trying to come to grips with an overview of Ace Energy LLC. So help me out here, if you would, on your well count. I want your opinion of your well count. I was going to ask you, first of all, how many leases you have, but you contend that you have wells without leases, and I'm stumped about how that works. So you have no leases? Is that your contention?
Commissioner Keen, I might be able to help bridge this gap here.
Please do.
I believe he's referencing to the difference between an operating entity and an asset holding company, which is pretty common in my experience with operators in Kansas, where the operating entity does the operations and a separate entity owns the working interest. Is that, I don't know if that's helpful, but that's
my Jonathan, but who owns the working interest?
That's a question he needs to answer. I just don't think I think you're talking across each other on that point.
Okay, well, I'm trying not to.
As you said, I have various there's various LLCs and trusts that own the working interests or have nothing to do with the operations.
So you're the operator then for other LLCs that are the owners. In some instances you have part ownership. In some instances you have total ownership. Am I correct now?
I'm not going to say myself. Ace Energy is the operator, and there's roughly, you asked how many leases? 14 leases, 420 something wells. I can pull up my inventory. I do spend a lot of time in that. And again, we've worked with the team that I did have before all these problems. We worked very well with KCC staff to make sure that inventory was accurate, updated, and we've done everything possible. And the amount of money I've spent over the years So I think it's very clear, as you mentioned, your own leases are held in a blind trust, and maybe your operator's license is held there, but it's very common in Kansas to have I don't know why you're confused by that, but
Well, I get the distinction
that
now that Mr. Platter has helped me. Now that he's helped me, I understand that your
well, I was
LLC,
pretty
that's
clear.
Ace, may I finish? That
Ace
Ace,
Energy is an operator.
they, okay. I understand that. And you operate these leases for some 14 other LLCs. Is that correct?
No, I mean, there's various, Ace Energy is the contracted operator for leases. That's all I'm gonna say.
Okay.
Ace Energy is not an owner of any of those leases.
All right, that's fine. So basically, then you're the operator for 430 wells, roughly. Is that correct?
I think the 400 and again,
427 is what I've heard. Yes.
okay, well, we can pull up the inventory. Yeah.
How many of these wells are slim holes, and how many are 4.5 completions?
I'd say that 90% are slim hole.
Okay. How many of these are producers, oil or gas or both?
There are 92 injectors. I'm give or take, because I just looked at this number recently.
Okay, you got 92 injectors,
I
and the
can give
rest.
you an exact number if you want, because
I want an exact number.
Okay. Sorry, I apologize. I'm looking for an email. 430 wells, and again, this is from a geologist I'm working with. Producing oil wells 314, producing gas wells 10, EOR wells 97, disposal wells 5, water supply wells 4.
Okay.
And again, that's from a number that someone looked at my inventory and did some analysis.
Okay, it gives me a good idea. Save me from asking each one as a line item too. I appreciate that. How many of these wells, whether they're characterized as oil, gas, EOR, disposal, water supply, how many of these wells are inactive? In your opinion?
Right now, they're all shut in.
If they were not immediately before they were shut in, how many of them were inactive?
How do you define inactive? Based on the TAs, based on the inventory?
No, I'm asking you, how many of these wells how many wells do you have that are not fully equipped to produce oil, to produce gas, for injection for EOR, for injection for disposal, or water supply? How many wells are not completely equipped to perform any of those functions?
Well, I'll let you know, all my MITs are current, except the ones that I just received letters on since my shut-in. So I think that's pretty good. And I don't have a number in terms of, I'd say the majority of my wells have equipment, and as of the submission of my license, I had no staff comments or issues. My annual reports were submitted and approved. So the answer, I mean, I don't know if that gives you, every day we move, or we used to move equipment around, and my orders were to get as many wells on as possible. So it's a moving target, but I think that the fact that my MITs of 97 wells, 97 MITs, I think that says something that I've done up until, I think there's maybe 4 or 5 right now. My TAs have all been compliant up until recently, because again, I'm broke and staffless because again, you know why, but I think I've done I've done a very good job of keeping everything, as far as I've been guided by staff, who are all over my leases for the past 10 years, ever since I've been in, I'm only as good as staff's guidance. And like I said, staff has been wonderful up until the recent changeovers and something happened internally the last 2 years.
Okay. Considering ACE Energy LLC as an operator here, who within ACE Energy is responsible for regulatory compliance? Is that you?
Yes.
Okay.
I'm responsible for submitting the forms, and then when I had staff or contractors or third parties, it's my job to order them and pay them to do it. Yeah.
Okay. Tristan, I think, as I did with Mr. Ely, I'm going to have to rely upon you a bit here, if you can, to help me retrieve some documents that are in evidence here so that we can do a share screen. If you would help me on that, I'd be grateful. You're pretty familiar with this. You've been doing the kinds of things I'm headed toward here for about an hour now.
Yes.
Let's turn next, if we can, to Exhibit RD1, page 9. While he's looking for that, Mr. Freden, if I could ask you this question. My next series of questions come from this rather holistic field examination that occurred in January of 2023. So I'm going to refer to several pages here and ask you some questions that pertain to these field reports. The first page I've turned to is page 9. If you can page up just a little bit. Yes.
This is Chair French. I hate to cut you off here. I just wanted to ask, at some point here, I'd like to give everybody a mid-afternoon break, and to be fair to Mr. Freden, he's been going for almost 2 hours. When would be a good time in your questioning to take a quick break? I mean, would right now, as you're shifting gears, be good, or would you prefer to wait a few minutes?
I appreciate that courtesy very much. Right now would be fine.
Let's, if everybody's okay with it, let's take a 10-minute break right now, and we'll reconvene at 3 o'clock, at where Commissioner Keene can continue his questioning. I never want to make people go more than a couple hours. So we are now off the record. We will reconvene at 3 o'clock. Please remember to turn off your audio and video. All right, I've got 3 o'clock. Commissioner Keen, I apologize for the interruption, but I hope everybody appreciated the short break. At this point, we are back on the record, and I will allow Commissioner Keen to continue his questions of Mr. Freden.
No apology required, Chair French. I think it was a great idea. As I indicated, what I want to do, I'm not going through all 600 pages of this. I can guarantee you that. But I am going to go through about 10 or so different wells here, just to kind of get a sense about what's going on here and get your impression about what's happening here, Mr. Freden. That's what's important to me. Tristan, if you can bring that up just a little bit so we can get some of the narrative in the screen. Yeah, that's perfect. Thank you very much. All right, Mr. Freden, as indicated here, this is the Allen Hauser #2 well located in Allen County. The date of this photograph is January 13th, 2023. I guess my first question to you is, does this appear to you to be an active oil well?
No, actually, I'm very aware of this situation, so I can answer any question you have about it. This was not an active oil well, no.
So how did all that oil come to be on the surface?
From what my team told me, because I'm fully aware of we were all over this situation when it was brought to my attention that day. Because anytime a spill is brought to my attention, because I have a lot of wells, we address it right away. And I was told that it was freezing that day, or that during that time period, and why do spills happen? Things happen. I mean, we don't know for sure, but it looks like there was some sort of some sort of a pipe break.
Is it possible that it could have come from the fact that the well flowed oil onto the ground because the well hadn't been capped or otherwise shut in or surface controlled? Is that possible?
It's possible, but my guys told me there was surface control. There was something happened because there's pipe laying there. It might have been worked on. Something caused that to happen, and we addressed it. I mean, spills do happen, so it happens as a regular course of business. And when it's brought into our attention, which we have, again, I have 400. The key is we address it. We cleaned it up that day. Staff was aware of it, and we took care of it right away because I was involved in that.
Well, the findings as they go on to elaborate indicates that your field staff did indeed remove free fluids and contaminated soil. You put down sorbent to soak up any free fluids after the ground could thaw, and that you also capped valves. You used valves to prevent more leaks. So I'm guessing that those caps were not on the well previously. Is that possible?
We were guided by Ryan. He was out there and he told us what to do. So we addressed it. The key is we addressed it as they told me to call it in, as they always do. I do whatever staff tells me when they have my phone number correct, which we laugh about. I mean, again, they call me. I'm available 24 hours. We jumped on it right away. Staff was very helpful. My team, we brought equipment out there again, because I remember this. That we address these. I mean, I don't know if, do you have the pictures that show the after?
Here's my concern.
Okay.
Here's my concern. You've acknowledged that this is an inactive oil well. Yet your oil well your inventory, the one that you had filed, it was germane at the time, indicated that this is a producing oil well. How can you reconcile that?
Well, as to the status of, I rely on the data from my field, and again, every operator goes in and where it's a constantly moving target in terms of what wells we turn on. As I told you before, staff tells us on lease inspections, as did I think Levi's his name in Thayer. He gave me a list of wells that needed swedges. move this, move that. I mean, you're an operator, you know, I mean, these are moving targets. It's not you submit the inventory once and it gets updated, but it's not a, well, submit it once and that's the end all be all. I've got 420 moving targets and data changes, and everyone should know that. And I would think you of all people should know that. I mean, I'm just being honest.
If we were to inspect this well location today, would the condition of the well, not the surrounding spill area, but would the condition of the well be the same as it is represented in these photos? That is this well still shut in?
This well, again, staff went out and re-inspected it after we cleaned it up and gave us a sign off on it. So as far as I know, that's the last time. I mean, that's the process from the years that I've been involved. They won't, we call it in. We're either told by staff there's a problem or a landowner. I call it in, they tell us to, that's why I don't even know why this is on here. I mean, I did exactly what they told us. I called it in right away. As soon as we were aware of it, we went out there, we did it. And, that's what I'm saying is there's so many of these quote examples that are questionable as to why they're even in here. This is regular course of business that spills do happen. And this
is an inactive well. Independently of the spill, this was an inactive well on January 13, 2023. Your license was suspended on by what I see here under docket number 223124 on April 6, 2023. Had you equipped that well for production between the time of this inspection and the time your license was suspended? Or is it still in this condition today?
The well has been capped. I did not, as we've told everyone, I didn't have this massive report until the summer. We had no idea this was even done. Okay. Staff came out, they told us what to do. The surface equipment was in there. They signed off on our cleanup in the well. To my knowledge, I haven't been told otherwise. It's fine.
Okay. Tristan, let's move on to the next page, please. The next page is, in fact, Exhibit RD1, page 10. Yes, that's it. Thank you. This is the Allen Hauser number 2 well, also located in Allen County. This photograph was taken on January 31st, 2023. I guess my first question to you, Mr. Freden, would be, does this appear to you to be an active oil well?
I don't know if equipment was moved. It looks like it's in pretty decent shape to me. I mean, to me, we move equipment around, and again, we TA wells all the time. I mean, I don't classify a violation of whether a TA has been submitted throughout the year or not.
You're answering things I'm not even asking. I'm asking you if that is, if as of the date of this photograph, is that an active oil well?
I can't, it does not have a pump jack on it. That's what I'll say.
Doesn't have pump jack, doesn't have any tubings, doesn't have any other surface equipment, doesn't have anything. So how could it possibly be an active well?
Okay, I'll go with that.
Okay, and so here's my concern, Mr. Freden. Once again, your well inventory as of this date showed that this was a producing oil well. How can we reconcile your actual field practice with what you represent on your well inventory sheet?
I haven't updated my well inventory sheet because my license has been suspended and I'm shut in and I'm effectively in a holding pattern until we resolve legal issues.
Mr. Freden, what's the anniversary date of your operator's license? Do you know?
November, what is it? November 1st, I think.
Okay, let's say it's November. Okay, let's say it's November 1st. Every November 1st, from the beginning of Ace Energy as a licensed operator through today, every year you have to update that oil inventory sheet. Is it, or pardon me, that well inventory sheet? Is that not correct? As of the date that you
and I've done that
your
for the
license.
past 10 years.
as of the date you renew your license.
And I have not submitted, okay. Answering your question, I have not submitted, we're still talking about my submission, which my wells were approved. And my license, the only reason it wasn't approved was because of rig tags. So I'm answering your question. I have done nothing since, I can't do anything until my license that was submitted and approved based on my wells that were submitted and my inventories that for every single year for the past 10 years, I've never had a problem.
Are you aware of the obligation to update your inventory each time you renew your license?
Correct.
Okay. Let's move on here. Tristan, move down
can I answer that?
Yes,
can I
please.
follow up your question?
Please.
Okay, and every single year, I've never had a problem, not once. And I do an annual inventory well submission, and occasionally there's, oh, this doesn't line up, but I've never had any issues. And you can go back and talk to Russell Hines, you can talk to all kinds of staff that have worked with us. Up until the recent staff changes, we have been over backwards to, again, how many operators have the number of wells I have over 6 counties. And I'm just being completely honest. Up until this day, up until recently, I've done everything possible to cooperate with the commission orders. And it's just been extremely challenging to have, these roadblocks and anyway, so enough said.
All right, Tristan, let's move on. Move to RD1, page 13, please. Okay, this is the George Hauser number 10 well, also located in Allen County. Date of this photograph was January 13th, 2023. This is a little different twist to this one. This particular well, again, would you acknowledge that this is not an active producing well?
Okay, I'll acknowledge that.
No equipment inside, is there?
Okay.
Okay. The concern here was the fact
it needs a TA submitted.
Well, the bigger concern here was that this well was not on your inventory. It did not appear on the well inventory, and that is what the field tech noted was the fact that it needed to be added to the inventory. Once again, we had obviously a spill issue here, all about the same point in time here within apparently a relatively short time period, but a little bit different circumstances. Any comments you care to make about that, please do.
Yeah, according to Kansas statute, I did clean up the request, but if it's not on my inventory, then it's really not my responsibility. It's on a lease that I'm, but again, my lawyer can, we've disputed, hold on a second, I need to get my earphones.
Commissioner Keen, forgive me for being probably the first lawyer ever to lodge an objection against a commission question, but I believe this is one of the wells that was identified within the area of review that operator is not responsible for.
Okay. Okay.
We did clean up the mess, and no, I'm not responsible for. I mean, I cleaned up the mess as required, but yes, I confer with my counsel.
Okay, let's move on. Tristan, move to page 43, if you would. Okay. This well is the beach near Bennett, number 63. It's located in Crawford County. The date of this photograph is January 20th, 2023. Evidently, it is equipped, but is an inactive EOR well. It shows up on your well inventory as an active EOR well. Does look like an active EOR well?
All of my EOR wells are accounted for, and I'm not aware of this. I mean, we do a very good job of keeping up our records. I'm not familiar with why there'd be an EOR well that's not on my MIT list.
Well, your well inventory shows this well to be an active EOR well. That's why I'm asking the question.
Well, on the beach there, we just were working on our wells, and I just spent $50,000 putting in new lines. So this well was, given the time frame of the picture, was under construction. So we were working on the lease. So as you can see, there was dirt around it, and we were fixing and getting the new lines put in. So.
Okay, fair enough. Even though it's under construction, I still don't see any surface control. In the event it could potentially flow and create some kind of.
The flood was turned off because we were doing repairs. It wasn't even connected. Because I just put in an entire new field.
And you're saying it could not flow without having injection wells operated somewhere else. Is that what you're saying?
What I'm saying is I put in entire new lines, and the field was not injecting because the system wasn't hooked up. We were fixing everything.
Okay. Tristan, move on to page 45, please. Again, this well is an inactive EOR well. Obviously, there's nothing obviously being injected into this well. However, I guess my concern is that there's no surface control here. And yet, evidently, that the field report shows that a visual inspection shows that there's fluid within 5 feet of the surface down inside the casing. Should that be a concern, the absence of well control in this instance?
Yes, we were fixing, as I had previously said, that lease was all under, and as you can see, there was a recent MIT date, and that's why it's being dug up around there, is because we were actively working on these wells.
Okay. Move to page 47, if you would, Tristan. Again, Mr. Freden, I'd have to ask, does this appear to you to be an active oil well?
Yes, we were working on that while putting it into production. Yes, there's pipe rock there, and like I said, the beach near lease. I had just laid new lead lines. We had just put in new power lines. I spent a significant amount of money, and we were putting it into production at that time. So yes, that would classify as a well in progress.
No, I was actually asking you if it was an active oil well, because it shows up on your inventory as an active oil well, yet obviously there's no tubing in the well. There's no horse head on the jack. There's no evidence of other connections there that would evidence it being an active well, are there?
Well, my well inventory was submitted a year prior to that, and we had just spent digging up the field $50,000 of putting in new lead lines, and well equipment was removed. And to be respectful, all equipment was removed, and we were in the process. As you can see, there's a pipe rack there, putting back the well into service. So I respectfully, with all due respect, disagree with you.
Well, I'm just looking at what the photographs.
Do you see the pipe rack, sir?
I see that. I don't see the pipe in the well.
Okay, so when we pull a well, and when when we work on wells, we bring pipe racks in. I just told, again, I'm just being completely honest with you. You've asked pointed questions, so I'm giving you pointed information as an informed, hands-on operator. I completely dug up the field, completely put in new lead lines, electric lines, injection lines. All the wells were stripped of equipment. Everything was pulled out. I spent a great deal of money because it needed that. And yes, we pulled out equipment, we swapped jacks, and because that needed to be done to put in those lead lines and to put in new power. And the pipe racks were there to be set as this well was being put back into production. So, and no, I don't update my well inventory every 3 days to account for, and again, staff has been all over my leases for the past 10 years. So, I mean, you can ask your staff about, if you have questions, why, anyway. Just being honest.
All right, let's move away from this exhibit. You can take away the screen share if you would. One of the concerns I had, Mr. Freden, from so many of the wells that appeared in here, we've got 660 pages of exhibit here, was the prevalence of the absence of surface control on so many of these wells that appeared to be abandoned or inactive. That is should that be a legitimate concern? Should I care about that? Should I have a concern about that?
Yeah, I'd have a concern for your staff, but why haven't they done their job to bring that on all the inspections that they spend all their time? If they don't like what they see out there, I'm not aware of problems. Surface controls, your staff has changed the rules over the past years. We've had, Russell Hines has every single lease in McCune. I was under a compliance agreement. I've had every single well looked at, and the definition of surface controls has changed. Again, I can only do what your staff is out there doing, and if they tell us to do something, we do it. I've not had any complaints. I've been in business over 10 years, and if I'm so bad, if I'm so horrible, how come everyone has had no problem up until recently working with us? Every single year, my license has been renewed. I've had no problems, major issues. We've worked with staff. They tell us to put swedges on, submit this TA. All of my MITs are up to date. I've spent significant amount of money plugging wells. I've spent more per capita, per well, per lease, over 6 counties going through 2 major oil crashes. I've spent huge amounts of money redoing my leases. Sir, I beg to differ that yes, if you have a concern, I would hold your staff accountable. Why haven't they been telling me for the past 10 years that they haven't had problems instead of doing a fishing investigation without even telling me up until they send discovery reports? I'd say that that is an effort to entrap me and to continue a harassment campaign of a government witness.
Do you believe it's the responsibility of the KCC staff to monitor your wells, to make sure that they have surface control, and if they don't, to provide surface control for your wells? You believe that's the responsibility of the KCC?
I believe it's the responsibility, excuse me? Okay, finish your question.
I'm finished. Do you believe that's the KCC responsibility?
We have worked with staff. We work with staff, and we have had a wonderful relationship with staff. We feel that, as Russell Hines once told us, he would rather have our time and money going into improving the leases than paying fines and spending the money on these type of waste of time hearings and fishing expeditions and harassments. That when we have a history, and if you want to call them as witnesses, every single staff member besides Mr. Dooling and Troy Russell, we've had a wonderful history of working with staff, doing everything we can, and I stand behind every single year. Our license has been approved, and if there's a problem, no, I don't think it's staff's responsibility, but they're out there inspecting leases, and if they see a problem, we address it right away. I don't argue. I don't complain. I've plugged wells. We've had staff out with metal detectors that, you know, we've done things that weren't even my fault, that they said, here, plug this well, wasn't even mine on my inventory. So I've gone above and beyond the call of probably anyone, because I do have the resources and I care about my wells. But frankly, when I've been, you know, had to spend $200,000, which could have gone into all these leases and could have easily addressed all these issues that you obviously have concerns with. But when I've been held up in KCC hearings and nobody's held accountable on your end, I'm sorry. No, it's not their responsibility, but they are in the field to help us, not to punish us. And they used to do that. They used to be very helpful. And I don't know what's changed except harassment of me. Maybe, well, obviously they don't like me and they're harassing me and they have an issue. We know that already. But sir, I'm just being honest.
I have two more questions and I'm through. I had some other questions, but the essence of what those were about were, I think, covered in the course of the cross-examination by Mr. Kimbrell. Two more questions. Mr. Freden, have you ever filed de novo? Have you ever filed a permit for an injection well?
To my knowledge, possibly. I don't recall.
I have a sense that you would have recalled because it's quite an onerous process. I think it's something that in your mind's eye you would have.
Well, let me take that back. I did. Again, it was a complicated situation, but there was a well that I drilled and Mr. Russell was involved. Potentially, it was a water supply well. That might have had a permit involved. I think it was. It was a difficult process because the driller applied to the other, what's it called, the Kansas Water Division. It needed to be the mistake.
I'm sorry, Mr. Freden, you cut out a little bit there toward
so
the
the
end.
Answer would be for that well, yes. The answer would be, I'm pretty sure that well was, but the driller handled it with because he made the initial mistake because the first one had to be plugged and he had to re-drill it because he didn't apply for the right permits.
Do you remember, you were present, were you not, for the testimony yesterday by Mr. Sims?
Yes.
And during that testimony, there was some discussion. We've had some further discussion about that by Mr. Kimbrell in his cross-examination about the Mullen I-22A well that you contend was authorized for injection because it was listed as an EOR well on your inventory. Am I stating that correctly?
That same driller, that well was drilled at the same time. So
okay.
During that,
go ahead, please. Go ahead.
During that same time, since the driller took care of the permit on the other well, yes, I didn't know I needed to apply personally for that. The driller took care of that, and it's never been brought to my attention that it's been on my inventory. It's been submitted. Staff has been out there 50,000 times looking at all my wells, and only until this campaign of harassment has surfaced that this has been an issue.
Well, there are different kinds of permits, are there not? There's a permit to drill. There's a drill intent, and you can indicate on that drill intent what your ultimate goal is as far as the well to be drilled. You can actually indicate that it would be an injection or an EOR well. Do you believe that by completing that drill intent and filing that drill intent and having that drill intent approved to drill that well, and that's all that intent is for drilling a well, that thereby gives you a permit to inject water into it once the well is completed? You believe that?
Yes, my driller handled the other well, and as far as I'm concerned, since he handled the other well, yes. I don't have physical permits on my other wells. It was approved by the KCC. Nobody ever said anything. The driller handled the other one. He's a water well guy. So yes, and we drilled it. It was approved. It's been out there we drilled it in 2017. So to my knowledge, since you asked if I ever done that before, no. but this driller has. That's what he does for a living. So he told me he'd take care of it. So if that's
You're
not
responsible
appropriate,
for the well, not the driller, right? It's you responsible as the operator for the well, not the
I'm
drill.
responsible for the well, but staff is responsible for inspecting my leases, and if I have a problem, they need to let me know.
I think
And
they have.
nobody has let me know until the harassment campaign started.
Okay, here's my final question. My final question is this. Whether or not compliance issues are brought to your attention by the KCC staff, aren't you, as the operator, responsible for being aware of and remediating any and all compliance issues that are presented by wells you're responsible for without being prodded to do so by the KCC?
Absolutely. And I've done this for the past 10 years without being penalized, we've worked in partnership with field staff and without having a police force go out there and fine us. We spend our time, and that, again, this is Russell Hines' only words to us. He'd rather us spend our time in the field and our money fixing the wells to make sure the environment is protected, to work with us as partners instead of working with us as adversaries and police cops, and spending the time, the $200,000 in legal bills and all your time and working with us as partners, which has happened in the past. And I don't know what has not happened, but yes, it's our responsibility, but we're only as good as our partners.
All right, Mr. Freden, that's the extent of my questions. I appreciate your indulgence in my questions. Appreciate your answers. Mr. Chairman, I have no further questions of this witness.
All right, thank you. Commissioner Keither, do you have any questions for this witness?
Well, yes, briefly. I need some elaboration, not much, but some. Mr. Freden, you keep suggesting that things have gone along fine until recently with staff changes. And who are these people that are out to get you? I mean, I don't. And why did it start when, if staff changes, they might not have known you very well? I don't understand what this is really referring to.
Okay, well, what's it referring to? It's in my testimony, but I'd like to elaborate on that. I have been collecting information on being a patriot, on being in the oil and gas business down in Kansas, and not being happy with seeing the corruption and self-dealing and unaccountability and people being in positions all throughout the commission or the oil and gas commission, and the just some of the terrible things I've seen, not happen to me personally. Well, yes, what's happened to me, but what's been going on is unacceptable. No one's been held accountable. There is no oversight from the top down. And this is important. People were tipped off to, and also I had a conversation with Dwayne Sims about the information I had about, because he was harassing me directly about my wells. But Mr. Dooling, Mr. Sims, and the people that I have come in contact with, they were aware that I had information about KCC's lack of compliance with many laws. And again, this does not have to do with my case. You're fully aware of my situation, but there's serious issues within that go much beyond myself. But they were aware because I told them, and it's in my testimony. They were aware that I know, and I have proof of the information, and that they have not been doing their jobs. They have caused, again, I'm not the investigator, but I just have the facts. That's not my job. But there's serious questions as to laws that have been broken, and I'm a threat because I'm a witness and an informant. And there are certain people that find that threatening.
But I'm
And if you
asking
look at
you,
this holistic view, excuse me?
I was asking you about, you say all the staff changes. Who are those people? That's who I
Well,
want
the
to know.
people, well,
You keep saying there
okay,
are all
there
these
were
changes.
people that over the years, there were people that were retired, and
You
I think
said
they were
recent.
probably retired. What's his? I mean, there were people that we used to work with that were very friendly towards us, and were. But Mr. Dooling was brought in. Mr. Russell's been there for 30 years, but there's been but the people that used to work with my team were very helpful, and I don't have any direct knowledge of their let's just say shady activities.
Well,
But
what do you refer to as recent changes? What are recent changes? You keep saying
I've been
recent.
told by other operators, and this is just not my opinions, that recent staff changes, that there's been pressure from either the KCC, the commission, or somewhere else that pressure on somebody to ratchet, that operators feel different now, that we're all under tight scrutiny, and the laws have been changed, that goalposts have been moved, and there's an adversarial relationship. Now, my situation, if you look at it from, as Mr. Keene said, a 30,000 foot view, everyone that has seen my case, maybe not you guys, can see very clearly this is a case of extreme harassment and witness suppression. There's no other reason. I don't deserve any other treatment. Why would the KCC spend hundreds of thousands of dollars on someone hot, broke laws, could be in federal prison, and you spent less time and effort on him? He's an admitted criminal, and I am being subjected to this because you asked me. So,
and I think you've answered.
Well, no, I'm not done yet. So I attempted.
Mr. Freden,
Well,
I think Commissioner Keither asked you specifically about which specific staff changes. If you have an answer to that,
the
I
specific
would
staff
give it.
changes, Mr. Dooling came into position as a supervisor, and ever since Mr. Dooling came in, because there is some sort of a relationship between Mr. Dooling, Mr. Sims, and Mr. Russell, since they're all tenured people. The people that we used to work with are no longer in the commission. They're, I don't know, or the field, District 3. I don't know what happened to them. And ever since that changeover, we've had nothing but harassment and issues. And I can point to it, and now we can prove it, that it's because they know I'm a witness, and the harassment.
Well, again, I don't think that deals with the recent question. One thing I did want to bring up is we did see that listed was Prairie Fire Energy LCC on one of the forms as a member, and you say no, they're not a member, but you don't know them. You don't really know them. You know they're an LLC.
I'm not a member of that. That's all I'm going to say. So it's a Wyoming entity, and
the point is that in our pages, you have signed at least 3 different lease agreements with Prairie Fire Energy. So I don't quite understand how you don't know them if they have signed on with at least operator agreements with you at least 3 different times.
Oh, I didn't say I didn't know them. ACE operates, as we've discussed.
Well, you did indicate you didn't really know them I don't know anything about them.
Oh. Well, I don't think I did. I can clarify that ACE, there was some confusion about who ACE was. I said, I don't know all the owners of that entity. It's a large investment group, but I'm not a member of that. And ACE operates assets.
Okay. I just wanted to clarify that I heard that you didn't really know who they were. That's what I heard.
I don't know
Well, I didn't ask for all of them,
or 60.
but when you're referring to them, you were saying, I don't really know them. And I'm saying, well, you've got 3 different at least.
I don't know the specific list of owners.
Okay. No. Okay. All right, Mr. Chairman, I'm going to let it go. Thanks.
All right. despite the length of the questioning, I do not have any questions for you, Mr. Freden. So I'm going to turn back to Mr. Schlatter and ask if you have any redirect.
Yeah, I'll try and keep it limited. May I proceed? Yeah, thank
Yes,
you.
please.
Just some issues that I want to clarify through the course of the last several hours of testimony. I want to first talk about the E.C. Larson number 2 and number 6 wells that were undergoing MIT. The record reflects there was MITs conducted April 5th, June 21st, and I believe July 8th. Was Ace Energy working on those wells that entire time? Jonathan?
Are you talking to me?
Yes.
Oh, I'm sorry. Could you please repeat the question? I don't know if you were talking to Mr. King or Commissioner.
I'm sorry. Yeah, we had discussed these E.C. Larson wells. The testimony in the record shows that they were.
Oh, yeah.
I believe it was April 5th, again on June 21st, and then one of the wells was then again tested on, I think it was July 8th. Was Ace Energy working diligently on repairing those wells that entire time?
Yes, absolutely. And Mr. Dooling was in constant contact with Mr. Windish because we were having serious challenges with that. Was in contact with Casey Jessup.
Okay. Because I believe he testified he had no knowledge of that, and you testified something different.
Yes, he's incorrect.
Okay. And he also mentioned that the 90 days to get the MIT completed is a hard deadline. Have you ever had an extension to those 90 days granted?
Oh, we had a cooperative working environment. Mr. Dooling has been impossible to work with. We always, staff has been very supportive in the past of granting extensions. Like I said, the old, not so recent path, it was about let's cooperate, get the job done. Let's not waste time on legal fees and fines. That let's care about the environment and the lease. I'd rather have the money go into the leases than deal with what we've been going through the past 2 years.
Okay. Not sure if, and maybe I was confused. Are you supposed to submit your well inventory annually and then update it daily, or is this just an annual requirement?
It's an annual submission. Everyone has the same date. I don't know. No, I take that back. It goes in for your license renewal, and it's been approved every single time without any questions. And same with the UIC report. Occasionally there's an error here, a formatting error, but never had any problems with my license. Not one problem.
Okay. There was testimony about a Gale Mullen I-22A. I believe that's on the Gale Mullen lease with the C43, E43, and I-43. You mentioned that those wells were incapable of injection because a trunk line was turned off. Is that correct?
Yeah, we put in a trunk line, and that trunk line was for future use to allow flipping of wells as needed, as permitting allowed, to add more injection over time, and that needed to be physically done in order to, and that was not done for those wells, so it would have been impossible for those wells to be injecting.
Okay. Well, was the Mullen I-22 connected to that particular trunk line?
The I-22, was that the one we drilled, what we discussed? Again, I forget.
The Mullen I-22A, yes. I think that was the one you said you drilled.
That was drilled by us. Most of those other ones were not. I think that was the injector that we drilled. Yeah, that probably was connected.
Did you say it was connected to the trunk line?
To the best of my knowledge, it was connected. Yeah, if it was under my thoughts that it was an injector. Yeah.
There was
think
some,
it was even MIT as well.
yeah, there was some confusion as to whether that, well, you were testifying whether the I-22A had actually been injecting water or was just authorized for injection. I just wanted to clarify that point.
Okay, yeah, I don't, I mean, again, it was authorized, it was an EOR, was I out there? I don't know, so.
You also testified on a few occasions that the Grundy B5 takes water naturally. Does that mean it's not equipped to inject at pressure?
It's on a vacuum, it's a granite wash.
So it's not equipped to inject at pressure?
If that's what that means, yeah, I mean, I'm not a.
That's my understanding of what it means, but.
Yeah.
As far as
I'm going to object to that. That should be stricken. Mr. Schlatters testifying as to what he believes this thing is.
It's a granite wash. It doesn't need an injection pump. It sucks down water. But you can put pressure on it.
Mr. Schlatter?
I don't think I was testifying. He said that I think vacuum means not at pressure, and I said that's my understanding. But I don't understand what the issue is.
I believe
I was told by the staff when I called that
that
that's an interpretive number.
Mr. Freden, hold on, that we're addressing.
Okay, sorry.
Yeah, Mr. Kimbrell.
Yeah, I believe Mr. Frieden said he didn't know whether that meant it was at atmosphere or not. And then Mr. Schlatter said, my understanding is that that's what it means. So he was obviously testifying and leading Mr. Freden.
We'll just leave it in the record, and the KCC can make a determination on how to interpret the testimony.
Thank you. Got a couple more things here. SX54, is it my understanding that you filled out their COLAR for them?
I helped them, yeah. From time to time. I think they did it I think they were authorized, but yeah, I think I helped them, yeah.
That was in the scope of your engagement as a contractor.
They needed my help from time to time. Yeah, I was yeah, go ahead.
But you can't actually process the T1 without filling all the blanks in, can you? You were asked.
Yeah, correct.
You were asked about your signature on there and whether that indicated that you were a member or something like that. And isn't it the case that those T1s can't be processed without having all those blanks filled in?
Correct.
Have you ever transferred a membership interest via T1 in an LLC?
Have I transferred?
Have you ever sold someone a membership interest in an LLC and done a T to evidence your? I don't. Never mind. I'll withdraw that question.
Oh, okay. All right.
Did you enter into some kind of an agreement with Excess 54 to acquire those particular wells that you were asked about?
Yes, I took over those wells because of the bank note.
You had been asked questions about, and this is my last question. You'd been asked questions about various phone calls you had with staff and the contents of those phone calls. Did you get to answer that question to as much as you wanted?
No, I did not.
Do you have anything to add there? And I'd ask that you do it as quickly as possible if you do.
Okay, I'd like to just clarify that, yes, I did make a call based on third-party guidance because I was told he was the appropriate party, the KCC HR director who's no longer with the case, I guess no longer there, but I called him and got a hold of him and told him that I had a serious, that I wanted to file a confidential whistleblower report. And I specifically said that this did not involve any of my legal cases, anything that involved me. I made it very clear. I said that this is my information. This has nothing to do with legal counsel, that I had, I could not, that this was sensitive. My life had been, my security, and it involved high-level people in the KCC, all the way up and down in the legislature. It involved contracts. It involved very serious allegations. I didn't want to get into too much detail of the call. I did mention because he asked me who it involved, because he thought it was a complaint that I was lodging against her, that they were harassing me personally. I said, they have been harassing me, and that's already in the public domain. But this call was to formally make a whistleblower complaint against the Oil and Gas Division, a commissioner on the KCC, and other issues that are going on in related to contracts and other issues that I'm not prepared to discuss in a public setting due to security and due to the fact that I'm not allowed to. But I intended to be, and that individual he said he could not take my call. He went back and discussed these phone calls with that said commissioner. He went and discussed the call with Mr. Hoffman and other people that we discussed on that call, because it was already in the record. I'm just going to say that. And then Mr. Russell already admitted that's why he basically he called me back, and he in his testimony told you he did not recall, because he don't think he wanted to recall. But I'm going to recall that second conversation was he talked to the various parties I mentioned. I never told him. I said that serious crimes and alleged issues that needed to be investigated, and that Kansas has a right to investigate. And I was told to contact him to take it to the right authorities to open an independent investigation into these matters. And that as my case had already, I had been subjected, I've already paid the price. I had nothing to lose anymore. There was no gain for me to do this. I told him this on the call. He refused to recognize that. Again, like I said, he went and called me back after he talked to those people. He talked to the people that were committing, potentially, allegedly. And again, I'm not an investigator, but I did want to file that report. And I'm not going to discuss whether that report was filed elsewhere. I'm not allowed to. But to this day, nobody has reached out to me from the commission, from HR, from the governor's office. And you are all aware that I intended to file a whistleblower complaint. And as a whistleblower, this harassment, and now Mr. Russell has proven on the call, Mr. Hines, through my testimony, but everyone's made aware that this harassment primarily has to silence me as a whistleblower and as a threat to serious issues that have already come up on this call. And I'm not going to discuss the matter of those issues. That's for someone else to investigate. But that's the root of this harassment. And we've more than proved that. And I wanted to clarify that there was not a complaint about my harassment personally. This was a call made as a patriot. I've been a commissioner myself, or a governor appointed, and I brought up fraud and corruption as a member of a commission, and I paid the price of being I wasn't renominated, but you know what? That's what we do. I'm a patriot. I don't have any benefit from doing what I do, but anyway, we'll let and see what the chips fly. And I hope that this commission finally can acknowledge that I've been harmed, and that I hope that you open an investigation and recognize that I've been harmed and take the information seriously and do with what you may.
Mr. Schlatter, was that your, I believe you indicated that was your final question, is that correct?
Yes.
All right. I think I've allowed recross for every witness, but we have been going quite a while and we don't have much time left. Mr. Kimbrell, is there any absolutely essential recross that you feel you need to make?
I feel that given that Mr. Pierboom isn't here to testify, that I think it would be helpful to have some cross on that issue.
If you could keep it as brief as possible, I would
Yeah, absolutely.
appreciate.
Absolutely. Mr. Freden, when you spoke to Mr. Pierboom, were you represented by an attorney at that point in time?
I told him this was a matter that needed to be discussed for me as a whistleblower myself.
All right. Did you have several dockets open in front of the commission when you spoke with Mr. Pierboom?
I made it very clear that this was not an issue that related to my dockets. I said I was given advice by outside, I'm just going to say authorities, that this was the appropriate path to file a whistleblower complaint or whistleblower report. I made it very clear to him, this has nothing to do with my dockets. This is information that was compiled over a long period of time, and I intended to file it confidentially, and he broke that confidentiality and put my life, and obviously what has happened after the fact has ruined my business and has caused severe harm to me.
When you spoke with Mr. Pierboom, did he refer you to the KCC Office of the General Counsel?
No, this has nothing to do with that. No, he did not.
All right. Do you have any evidence?
This is not a general counsel matter.
But did he?
He is the appropriate.
We got the answer to the question, Mr. Kimbrell. Next question.
Absolutely. And do you have any evidence that Mr. Pierboom discussed your call with anyone else?
Excuse me?
Do you have any evidence that you can present to the commission that Mr. Pierboom actually discussed this matter with, I believe you said, a commissioner and Mr. Hoffman?
He told me.
Okay.
He told me on the second call. No, he told me, he called me back and said, I've discussed the matter with the people that you mentioned, and I'm not able to take, nor will I take your whistleblower complaint. And we discussed it in length, and I said that this was advised to me by outside agencies. This is the path, and he is the appropriate party, just like if I was raped, he is the appropriate party to handle this and to take it to the governor if need be, and to open an investigation.
We got the answer to the question. Mr. Kimbrell, was that your last question?
That was my last question. Thank you.
I'm hesitant to ask commissioners anything further for Mr. Freden. Seeing shaking heads. Mr. Schlatter, any necessary redirect? All right. Looks like no. All right. We have now reached the conclusion for this witness. Mr. Freden, we thank you for your testimony, and you may virtually step down. We are now, let's see. Looks like we have come to our final witness. Operator, you may call your next witness.
Operator calls David Bedau to stand.
Welcome back, Mr. Ely. Looks like you'll be conducting this examination.
I will be. Mr. Bedau, are you on the line? I see your screen.
Good afternoon, Mr. Bedau. Can you hear us all right?
Yes, thank you.
Very good. If you would please raise your right hand. Do you swear the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Back to you, Mr. Ely.
Thank you, Chair French. Mr. Bedau, can you state your name and your work address for the record, please?
My name is David Bedau. My work address is 18 North Forest Avenue, Chanute, Kansas.
Mr. Bedau, do you have a previous relationship with Ace Energy?
I do.
What is that relationship?
I served as attorney for Ace Energy up until December of last year, when I contracted COVID-19. I had a really severe case and had to pass off Ace Energy to you all.
Are you here testifying on behalf of Ace Energy or operator?
Yes.
Are you the same David Bedau who created the pre-filed testimony of David J. Bedau on behalf of Ace Energy LLC dated June 21st, 2023?
Yes, sir.
Is that a true and accurate reflection of your testimony?
I believe so, yes.
Do you have any changes you would like to make to that testimony at this time?
I do not.
I would offer Mr. Bedau's pre-filed testimony into evidence, please.
Staff would object to certain portions of that testimony and ask that it be struck. Page 2, line 2 through page 3, line 26, as that testimony concerns docket 22-3124, which is irrelevant to the present proceeding.
Oh, hold on just a second, Mr. Kimbrell. Can you give me those lines again?
Page 2, line 2 through page 3, line 26.
Mr. Ely, any response?
Yes. There have been multiple staff witnesses who have testified to that exact same docket thus far this proceeding. I would ask that the commission exercise the same discretion that it has granted all other evidence up until this point.
Yeah, I would observe that basically the motion would would remove the entirety of Mr. Bedau's testimony, and I think we will grant a little leeway here, and so the objection is overruled. We will admit Mr. Bedau's testimony as described into the official record. Mr. Ely, do you tender your witness for cross?
I do, Chair French.
Thank you. Mr. Kimbrell, you may proceed.
Thank you. And I'm going to share my screen real quickly. Mr. Bedau, do you see your testimony on the screen?
Yes, sir.
All right. And starting at page 2, line 15, you state that the purpose of your testimony is to provide insights regarding perceived bias towards Ace Energy. Is that correct?
That's correct.
And then when asked to elaborate, you discuss docket 22-CNS-3124 and specifically a letter sent on October 3rd that arose out of that docket. Is that correct?
Yes.
And you discuss docket 22-3124 and that letter basically until the end of your testimony. Is that a fair statement of your testimony?
Yes, sir.
All right. Did the commission hold a hearing on March 10th, 2023 regarding docket 22-3124?
I don't recall at this point.
The commission did hold a hearing as far as you know on that docket?
I don't have that information in front of me.
All right. Do you know if the commission has issued a final order in that docket?
I'm not sure.
All right. Any idea do you have any knowledge on whether the commission has denied operators' petition for reconsideration in that docket?
I believe that's correct.
Okay. In any of the orders that you have read regarding this docket that have been ordered by the commission in docket 22-3124, did the commission state at any point that it found that staff had acted in a biased manner toward Ace Energy?
I don't believe so.
Okay. I have no more questions at this point. Thank you.
Thank you. Are there any commissioner questions for this witness? And I'll begin again with Commissioner Keen.
No questions for me, thank you.
And Commissioner Keither, no questions. Mr. Ely, any redirect?
No, Chair French.
All right. Easy peasy. I don't believe we have anything else for you, Mr. Bedau. You are released and you may virtually step down.
Thank you.
Thank you. We have now come to the end of our witness examination. We will have closing statements if the parties still wish to make them, and I will begin with operator. I don't know if that's going to be Mr. Schlatter or Mr. Ely.
That will be me.
Okay, go ahead whenever you are ready, Mr. Schlatter.
Okay, can I have just a minute here?
Absolutely, and I do want to mention there's nothing in my script. I'm planning to talk to you all about this after closing statements. There's nothing in my script about briefing, but it seems during this hearing that everyone has agreed some briefing is necessary. To the extent you all would like to forego closing statements and address all these items in briefing, that would be fine with me. But if you want to proceed with closing statements as well, I'm certainly not going to remove that out of your hands.
I have no objection to that approach.
Yeah, I'm fine with that as well.
Okay. Why don't we do that? So let me look here. So we're going to move past closing statements because it sounds like we do need some briefing. So you can tell we don't have a court reporter here, but we have recorded the entire proceeding. We are going to have this transcribed. I imagine you'll want that for briefing. What I would like to propose is that as soon as we get this transcribed, and we'll send it out via notice to the parties when we get the transcription, perhaps we would give 2 weeks for an initial brief, and then 2 weeks from that, we would accept simultaneous reply briefs. Would that be acceptable to the parties? So your first deadline wouldn't start until everybody receives the transcript.
That makes perfect sense to me. The transcripts are usually 30 days out or so.
I think so. Mr. Myers, can you recall on the last couple of these how long it's taken?
Yeah, it's likely to be a little sooner, although this is a longer one than some of our others. Typically, we get them within 10 to 14 days.
And John, one thing that we talked about in the past is we don't get notice when those are filed. Can we try and be reminded of that?
Chair French just said that you would be noticed, so you shall. I can do that.
Yeah,
I apologize.
That's
I'm gonna have John make a special note of that. That when we get it, John, I don't know if we will. I don't think we typically file the transcript in the docket, but we will make sure that it is sent and notified, and that the parties are notified when the transcript is available. I mean, since we're tying the deadline to that, I want to make sure we do that. All right. That was the only post-hearing item I wanted to raise with the parties. Are there any other issues we need to address before we conclude?
Chair French, I guess, did you want to give any direction on what the briefings should contain, or you want to leave that up to the parties?
I'm going to leave it open-ended for the parties to identify what they believe needs to be addressed in their briefing, and obviously then you can respond to each other in your reply briefs. But I think at this point we will keep it open-ended. All right, anything further? All right, if there's no further business or items we need to address, this will conclude our hearing in this docket. At this time, we will close the record and adjourn. Thank you all for your participation in the hearing. We are off the record. Thank you all.
Thank you.
Thank you.
Thank you.